Parliamentary forums rationale of the Group M.N. Call and S.L. Schuchter have not.
Parliamentary forums rationale of the Group M.N. Call and S.L. Schuchter have nicely explained the rationale of the Indian Parliamentary Group, IPG, in the following way. The establishment and development of relations among parliaments constitutes part of the regular activities of national parliaments. Although promotion of interparliamentary relations has for many years been a significant part of the work of parliamentarians, recently it has received a new thrust due to the increased interdependence of nations in a global environment. It is imperative that parliamentarians will join hands to safeguard democracy and work in synergy to confront the challenges before the world and convert them into opportunities to facilitate peace and prosperity in their countries as well as globally. Parliamentarians from different parts of the world, therefore, have a forum where they can meet to discuss and find out solutions to their common problems. It is here that some sort of cross-fertilization of ideas can take place not only between the older and the younger parliaments, but also between parliamentarians working under different parliamentary systems. These problems are no doubt discussed in intergovernmental conferences. However, those discussions are not so frank and free as they can be at a conclave of legislators. Interparliamentary relations thus assume great importance today when the whole world is beset with many pressing problems. The problems that are faced by one parliament today may confront another tomorrow. It is, therefore, essential that a link should exist between various parliaments of the world. This link is maintained by India through the exchange of delegations, goodwill missions, correspondence, documents, etc. with foreign parliaments through the machinery of the IPG that acts both as the national group of the Interparliamentary Union, IPU, and also as the India branch of the Commonwealth Parliamentary Association, CPA. Composition of the group IPG3 is an autonomous body. It was formed in the year 1949 in pursuance of a motion adopted by the Constituent Assembly, Legislative. For the membership of IPG is open to all members of Parliament. The former members of Parliament can also become associate members of the group. 5 But the associate members are entitled to limited rights only. They are not entitled to representation at meetings and conferences of the IPU and the CPA. They are also not entitled to the travel concessions provided to members by certain branches of the CPA. The Speaker of the Lok Sabha is the ex-officio president of the group. The Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha are the ex-officio Vice Presidents of the group. The Secretary General of the Lok Sabha acts as the ex-officio Secretary General of the group. Objectives of the group. The aims and objects of the group are mentioned below. 1. To promote personal contacts between members of the Parliament of India. 2. To study questions of public importance that are likely to come up before the Parliament, arrange seminars, discussions and orientation courses, and bring out publications for the dissemination of information to the members of the group. 3. To arrange lectures on political, defense, economic, social and educational problems by the members of the Parliament and distinguished persons. 4. To arrange visits to foreign countries with a view to develop contacts with members of other parliaments. Functions of the group. The various functions performed and activities undertaken by the group are as follows. 1. The group acts as a link between the Parliament of India and the various parliaments of the world. This link is maintained through exchange of delegations, goodwill missions, correspondence, documents, etc. with foreign parliaments. 2. The group functions as the A. national group of the IPU and B. main branch of the CPA in India. 3. Addresses to the members of the Parliament by visiting heads of state and government of foreign countries and talks by eminent persons are arranged under the auspices of the group. 4. Seminars and symposia on parliamentary subjects of topical interest are organized periodically at national as well as international level. 5. Members of the group, when visiting abroad, are given letters of introduction to the secretaries of the national groups of the IPU and secretaries of the CPA branches. The Indian missions in the countries of visit are also suitably informed so as to enable them to get assistance and usual courtesies. 6. Only those members of the Parliament who are members of the group of at least 6 months standing at the time of the composition of the delegation may be included in the Indian parliamentary delegations to foreign countries. 7. An uninterrupted flow of information to members regarding the activities of the group is maintained through the IPG newsletter brought out every quarter. It is sent regularly to all members of the group, including associate members. 8. As per decision of the group, an award of outstanding parliamentarian was instituted in the year 1995 to be given annually. A committee of 5 persons, constituted by the Speaker of the Lok Sabha, invites and finalizes the nomination for the award. 9. To encourage bilateral relations, the group constitutes parliamentary friendship groups with other countries in the parliament. 6. The aims and objectives of the friendship group are to maintain political, social and cultural contacts between the two countries and to assist in exchanges of information and experiences on issues relating to parliamentary activities. The group and IPU. 7. The IPU is an international organization of the parliaments of sovereign states. At present, the IPU consists of 153 parliaments of sovereign nations. Its aim is to work for peace and cooperation among peoples and for the firm establishment of representative institutions. It fosters contacts, coordination and the exchange of experience among parliaments and parliamentarians of all member countries and contributes to better knowledge of the working of representative institutions. It also expresses its views on all burning questions of international importance for necessary effective implementation of parliamentary actions and suggests avenues for improving the working standard and capacity of international institutions. The main advantages of membership of the group, insofar as its functions as the national group of the IPU are concerned, are as follows. 1. It helps members of Indian parliamentary delegations to develop contacts with the parliamentarians of the member countries of the IPU. 2. The events provide an opportunity to study and understand contemporary changes reforms taking place in various countries of the world. 3. It provides facilities to meet parliamentarians in different countries during tours in abroad or in India when visiting parliamentarians are here. 4. The members of the group are eligible to visit foreign countries as members of the Indian parliamentary delegations to interparliamentary conferences. In the recent past, members of the group have been holding various positions in the IPU bodies, namely, office bearers in different committees of the IPU, rapporteurs, chairman of drafting committees, etc. And by virtue of the same, the group has been successful in putting forward effectively the viewpoint of India on various important issues dealt in the IPU meetings.
The group
and CPA. The CPA is an association of about 17,000 Commonwealth parliamentarians spread over 175 national, state, provincial and territorial parliaments. Its aims are to promote knowledge and understanding of the constitutional, legislative, economic, social and cultural systems within a parliamentary democratic framework with particular reference to the countries of the Commonwealth of Nations and to countries having close historical and parliamentary associations with it. Its mission is to promote the advancement of parliamentary democracy by enhancing knowledge and understanding of democratic governance and by building an informed parliamentary community able to deepen the Commonwealth's democratic commitment and to further cooperation among its parliaments and legislatures. The main advantages of membership of the group, insofar as its functions as the main branch of the CPA in India are concerned, are as follows. 1. Conferences and seminars. Membership provides an opportunity for participation in the plenary and regional conferences, seminars, visits and exchanges of delegations. 2. Publications. All members of the group are entitled to receive, free of charge, the Parliamentarian, Quarterly and the newsletter, first reading, every second month. 93. Information. The Parliamentary Information and Reference Centre of the CPA Secretariat provides information to members on parliamentary, constitutional and Commonwealth matters. 4. Introductions. The CPA branches readily assist in arranging introductions for members visiting other jurisdictions. 5. Parliamentary facilities. Members visiting other Commonwealth countries are normally accorded parliamentary courtesies, especially access to debates and local members. 6. Travel facilities. Some branches provide for a designated number of their members annually to undertake study tours of Commonwealth and other countries to compare political and procedural developments. Other branches arrange ad hoc visits. Notes and references.
1
ML Call and SL Charter, Practice and Procedure of Parliament, Lok Sabha Secretariat, 6th edition, 2009, p. 1160. 2. Ibid. 3. Hereafter referred to as the group. 4. The concerned motion was adopted on 16 August 1948. 5. A member or ex-member of Parliament can become a life member of the group on payment of a fixed life subscription. 6. Each friendship group consists of 22 sitting members of Parliament, 15 from the Lok Sabha and 7 from the Rajya Sabha, in proportion to the strength of parties in the Lok Sabha and the Rajya Sabha. The Speaker of the Lok Sabha appoints the President and 2 Vice Presidents, 1 from each house, of the friendship group. 7. Handbook for members of Lok Sabha, 15th edition, 2009, pp. 207-208. 8. Ibid, pp. 208-209. 9. These are published by the CPA Secretariat, London.
Supreme
Court, like the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the High Courts below it. Under a High Court, and below the state level, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts, adopted from the Government of India Act of 1935, enforces both central laws as well as the state laws. In USA, on the other hand, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. There is thus a double system of courts in USA, one for the center and the other for the states. To sum up, India, although a federal country like the USA, has a unified judiciary and one system of fundamental law and justice. The Supreme Court of India was inaugurated on 28 January 1950. It succeeded the Federal Court of India, established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. 1 Articles 124 to 147 in Part V of the Constitution deal with the organization, independence, jurisdiction, powers, procedures and so on of the Supreme Court. The Parliament is also authorized to regulate them. Organization of Supreme Court.
At present, the Supreme Court consists of
13 judges, 1 Chief Justice and 30 other judges. In February 2009, the Centre notified an increase in the number of Supreme Court judges from 26 to 31, including the Chief Justice of India. This followed the enactment of the Supreme Court, Number of Judges, Amendment Act, 2008. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The Parliament has increased this number of other judges progressively to 10 in 1956, to 13 in 1960, to 17 in 1977 and to 25 in 1986. Judges. Appointment of judges. The judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But, in the second judge's case, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court. But, the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case 2, 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to
the government. The court
held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointments Commission, NJAC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the 4th Judge's Case 2A, 2015. The court opined that the new system, i.e., NJAC, would affect the independence of the judiciary. Appointment of Chief Justice from 1950 to 1973, the practice has been to appoint the senior-most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1973 when A.N. Ray was appointed as the Chief Justice of India by superseding 3 senior judges. 3 Again in 1977, M.U. Beg was appointed as the Chief Justice of India by superseding the then senior-most judge. 4 This discretion of the government was curtailed by the Supreme Court in the 2nd Judge's Case, 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Qualifications of judges: a person to be appointed as a judge of the Supreme Court should have the following qualifications. 1. He should be a citizen of India. 2. He should have been a judge of a High Court, or High Courts in succession, for 5 years, or B. He should have been an advocate of a High Court, or High Courts in succession, for 10 years, or C. He should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Oath or affirmation: a person appointed as a judge of the Supreme Court, before entering upon his office, has to make and subscribe an oath or affirmation before the President, or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears, 1. To bear true faith and allegiance to the Constitution of India, 2. To uphold the sovereignty and integrity of India, 3. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will, and 4. To uphold the Constitution and the laws. Tenure of judges: the Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following 3 provisions in this regard. 1. He holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. 2. He can resign his office by writing to the President. 3. He can be removed from his office by the President on the recommendation of the Parliament. Removal of judges: a judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. 5. The address must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are 2. Proved misbehavior or incapacity. The Judges' Enquiry Act, 1968, regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. 1. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker Chairman. 2. The Speaker Chairman may admit the motion or refuse to admit it.
3. If
3.
it
If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of a. The Chief Justice or a Judge of the Supreme Court, b.
A Chief Justice of the
of the High Court, and c. A distinguished jurist. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first and the only case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991193. Though the Enquiry Committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2009, the salary of the Chief Justice was increased from 33,000 to 1 lakh per month and that of a judge from 30,000 to 90,000 per month. 6. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when 1. The office of Chief Justice of India is vacant, or
2. The
2.
Chief
The Chief
Justice of India
is temporarily absent, or 3. The Chief Justice of India is unable to perform the duties of his office. Ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. The judge so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court, in priority to other duties of his office. While so attending, he enjoys all the jurisdiction, powers and privileges, and discharges the duties of a judge of the Supreme Court. Retired judges. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court, who is duly qualified for appointment as a judge of the Supreme Court, to act as a judge of the Supreme Court for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers and privileges of a judge of Supreme Court. But he will not otherwise be deemed to be a judge of the Supreme Court. Seat of Supreme Court. The Constitution declares Delhi as the seat of the Supreme Court. But it also authorizes the Chief Justice of India to appoint other place or places as seat of the Supreme Court. He can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as a seat of the Supreme Court. Procedure of the court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are usually decided by a bench consisting of not less than 3 judges. The judgments are delivered by the open court. All judgments are by majority vote, but if differing, then judges can give dissenting judgments or opinions. Independence of Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures and interferences of the executive, council of ministers, and the legislature, parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. 1. Mode of appointment. The judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, i.e., judges of the Supreme Court and the High Courts. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. 2. Security of tenure. The judges of the Supreme Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed, or impeached, so far.
3. Fixed service conditions. The
salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of the Supreme Court remain same during their term of office. 4. Expenses charged on consolidated fund. The salaries, allowances and pensions of the judges and the staff as well as all the administrative expenses of the Supreme Court are charged on the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. 6. Ban on practice after retirement. The retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. 7. Power to punish for its contempt. The Supreme Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity and honor. 8. Freedom to appoint its staff. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive. He can also prescribe their conditions of service. 9. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. The Constitution has guaranteed to the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. 10. Separation from executive. The Constitution directs the state to take steps
to separate the judiciary from
the executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of executive authorities in judicial administration came to an end. 7. Jurisdiction and powers of Supreme Court. The Constitution has conferred a very extensive jurisdiction and vast powers on the Supreme Court. It is not only a federal court like the American Supreme Court but also a final court of appeal like the British House of Lords, the upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizens. Further, it has advisory and supervisory powers. Therefore, Alladi Krishnaswamy Iyer, a member of the drafting committee of the Constitution, rightly remarked, "The Supreme Court of India has more powers than any other Supreme Court in any part of the world." The jurisdiction and powers of the Supreme Court can be classified into the following: 1. Original jurisdiction. 2. Writ jurisdiction. 3. Appellate jurisdiction. 4. Advisory jurisdiction. 5. A court of record. 6. Power of judicial review. 7. Other powers. 1. Original jurisdiction. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation. More elaborately, any dispute between a. The centre and one or more states, or b. the centre and any state or states on one side and one or more states on the other, or c. between two or more states. In the above federal disputes, the Supreme Court has exclusive original
Jurisdiction. Exclusive means
no other court can decide such disputes, and original means the power to hear such disputes in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, 2 points should be noted. 1. The dispute must involve a question, whether of law or fact, on which the existence or extent of a legal right depends. Thus, the questions of political nature are excluded from it. 2. Any suit brought before the Supreme Court by a private citizen against the centre or a state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following: a. A dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sanad or other similar instrument. 8. b. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. 9. c. Interstate water disputes. 10. d. Matters referred to the Finance Commission. e. Adjustment of certain expenses and pensions between the centre and the states. f. Ordinary dispute of commercial nature between the centre and the states. g. Recovery of damages by a state against the centre. In 1961, the first suit, under the original jurisdiction of the Supreme Court, was brought by West Bengal against the centre. The state government challenged the constitutional validity of the Coal-Bearing Areas, Acquisition and Development Act, 1957, passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the Act. To writ jurisdiction, the Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the
Supreme
Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The High Courts are also empowered to issue writs for the enforcement of the fundamental rights. It means, when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdiction with regard to disputes relating to fundamental rights. In the first case, it is exclusive, and in the second case, it is concurrent with High Court's jurisdiction. Moreover, the parties involved in the first case are units of the Federation, centre and states, while the dispute in the second case is between a citizen and the government, central or state. There is also a difference between the writ jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purposes. It means that the writ jurisdiction of the High Court is wider than that of the Supreme Court. But, the Parliament can confer on the Supreme Court the power to issue writs for other purposes also. 3. Appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under four heads: A. Appeals in constitutional matters. B. Appeals in civil matters. C. Appeals in criminal matters. D. Appeals by special leave. A. Constitutional matters. In the constitutional cases, an appeal can be
made to
made
the
to the
Supreme
Supreme Court
Court
against the judgment of a High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution.
based
Based
on the certificate.
the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. B. Civil matters. In civil cases, an appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies I. That the case involves a substantial question of law of general importance, and 2. That the question needs to be decided by the Supreme Court. Originally, only those civil cases that involved a sum of 20,000 could be appealed before the Supreme Court. But this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. C. Criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceeding of a High Court if the High Court I. has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or 2. has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death, or 3. certifies that the case is a fit one for appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right, i.e., without any certificate of the High Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lies to the Supreme Court from the judgment of a High Court if the High Court I. has on appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years, or 2. has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to imprisonment for life or for 10 years. Further, the appellate jurisdiction of the Supreme Court extends to all civil
and criminal cases in which the Federal Court of India
has jurisdiction to hear appeals from the High Court but which are not covered under the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. D. Appeal by special leave. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country, except military tribunal and court-martial. This provision contains the four aspects as under I. It is a discretionary power and hence cannot be claimed as a matter of right. 2. It can be granted in any judgment whether final or interlocutory. 3. It may be related to any matter, constitutional, civil, criminal, income tax, labor, revenue, advocates, etc. 4. It can be granted against any court or tribunal and not necessarily against a high court, of course, except a military court. Thus, the scope of this provision is very wide and it vests the Supreme Court with a plenary jurisdiction to hear appeals. On the exercise of this power, the Supreme Court itself held that, being an exceptional and overriding power, it has to be exercised sparingly and with caution and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. For advisory jurisdiction, the Constitution, Article 143, authorizes the President to seek the opinion of the Supreme Court in the two categories of matters: A. On any question of law or fact of public importance which has arisen or which is likely to arise. B. On any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sanad or other similar instruments. 11. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But, in the second case, the Supreme Court must tender its opinion to the President. In both the cases, The opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, 2013, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction.
These are
Mentioned
mentioned
below in the chronological order. 1 Delhi Laws Act in 1951 2. Kerala Education Bill in 1958 3. Berubari Union in 1964. C. Customs Act in 1963 5. Keshav Singh's case relating to the privileges of the legislature in 1964 6. Presidential election in 1974 7. Special Courts Bill in 1978 8. Jammu and Kashmir Resettlement Act in 1982 9. Koveri Water Disputes Tribunal in 1992 10. Rama Janmabhoomi case in 1993 11. Consultation process to be adopted by the Chief Justice of India in 1998 12. Legislative competence of the centre and states on the subject of natural gas and liquefied natural gas in 2001 13. The constitutional validity of the Election Commission's decision on deferring the Gujarat Assembly elections in 2002 14. Punjab Termination of Agreements Act in 2004 15. 2G Spectrum case verdict and the mandatory auctioning of natural resources across all sectors in 2012 5. A court of record. As a court of record, the Supreme Court has two powers. The judgments, proceedings and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of court, either with simple imprisonment for a term up to 6 months or with fine up to 2,000 or with both. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of high courts, subordinate courts and tribunals functioning in the entire country. Contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ or other process of a court or willful breach of an undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which I. Scandalizes or lowers the authority of a court, or 2. Prejudices or interferes with the due course of a judicial proceeding, or 3. Interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticism of judicial acts and comment on the administrative side of the judiciary do not amount to contempt of court. 6. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional and invalid, null and void, by the Supreme Court. Consequently, they cannot be enforced by the government. 7 other powers. Besides the above, the Supreme Court has numerous other powers. A. It decides the disputes regarding the election of the President and the Vice President. In this regard, it has the original, exclusive and final authority. B. It inquires into the conduct and behavior of the Chairman and members of the Union Public Service Commission on a reference made by the President. If it finds them guilty of misbehavior, it can recommend to the President for their removal. The advice tendered by the Supreme Court in this regard is binding on the President. C. It has power to review its own judgment or order. Thus, it is not bound by its previous decision and can depart from it in the interest of justice or community welfare. In brief, the Supreme Court is a self-correcting agency. For example, in the Keswananda Bhati case, 1973, The Supreme Court departed from its previous judgment in the Golaknath case, 1967. D.
It is
It is
authorized
authorized to withdraw the cases pending before the High Courts and dispose them by itself. It can also transfer a case or appeal pending before one High Court to another High Court. E. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. All authorities, civil and judicial, in the country should act in aid of the Supreme Court. F. It is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. G. It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. Further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the centre and the states. Supreme Court advocates. 3 categories of advocates are entitled to practice law before the Supreme Court. They are 1. Senior advocates. These are advocates who are designated as senior advocates by the Supreme Court of India or by any High Court. The court can designate any advocate, with his consent, as senior advocate if in its opinion by virtue of his ability, standing at the bar or special knowledge or experience in law the said advocate is deserving of such distinction. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instructions to draw pleadings or affidavits, advise on evidence or do any drafting work of an analogous kind in any court or tribunal in India or undertake conveyancing work of any kind whatsoever, but this prohibition shall not extend to settling any such matter as aforesaid in
Consultation with the junior.
Table 26.1 Comparing Indian and American Supreme Courts. Indian Supreme Court, American Supreme Court. 1. Its original jurisdiction is confined to federal cases. 1. Its original jurisdiction covers not only federal cases but also cases relating to naval forces, maritime activities, ambassadors, etc. 2. Its appellate jurisdiction covers constitutional, civil and criminal cases. 2. Its appellate jurisdiction is confined to constitutional cases only. 3. It has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal, except military. 3. It has no such plenary power. 4. It has advisory jurisdiction. 4. It has no advisory jurisdiction. 5. Its scope of judicial review is limited. 5. Its scope of judicial review is very wide. 6. It defends rights of the citizen according to the procedure established by law. 6. It defends rights of the citizen according to the due process of law. 7. Its jurisdiction and powers can be enlarged by Parliament. 7. Its jurisdiction and powers are limited to that conferred by the Constitution. 8. It has power of judicial superintendence and control over the state high courts due to integrated judicial system. 8. It has no such power due to double, or separated, judicial system. Table 26.2 Articles related to Supreme Court at a glance.
Article
No.
Subject.
Subject matter 124. Establishment and Constitution of Supreme Court 124A. National Judicial Appointments Commission 124B. Functions of Commission 124C. Power of Parliament to make law 125. Salaries, etc., of judges 126. Appointment of acting Chief Justice 127. Appointment of ad hoc judges 128. Attendance of retired judges at sittings of the Supreme Court 129. Supreme Court to be a court of record 130. Seat of Supreme Court 131. Original jurisdiction of the Supreme Court 131A. Exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws, repealed, 132. Appellate jurisdiction of Supreme Court in appeals from High Courts in certain cases 133. Appellate jurisdiction of Supreme Court in appeals from High Courts in regard to civil matters 134. Appellate jurisdiction of Supreme Court in regard to criminal matters 134a. Certificate for appeal to the Supreme Court 135. Jurisdiction and powers of the Federal Court under existing law to be exercisable by the Supreme Court 136. Special leave to appeal by the Supreme Court 137. Review of judgments or orders by the Supreme Court. 138 Enlargement of the jurisdiction of the Supreme Court 139. Conferment on the Supreme Court of powers to issue certain writs 139a. Transfer of certain cases 140. Ancillary powers of Supreme Court 141. Law declared by Supreme Court to be binding on all courts 142. Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. 143. Power of President to consult Supreme Court 144. Civil and judicial authorities to act in aid of the Supreme Court 144a. Special provisions as to disposal of questions relating to constitutional validity of laws, repealed, 145. Rules of Court, etc. 146. Officers and servants and the expenses of the Supreme Court 147. Interpretation 2. Advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. 3 other advocates. These are advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act, 1961, and they can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. Notes and references. 1. Before 1950, the British Privy Council had the jurisdiction to hear appeals from India. 2. In Presidential Reference, 1998. The President sought the Supreme Court's opinion, under Article 143, on certain doubts over the consultation process to be adopted by the Chief Justice of India as stipulated in the 1993 case. 2. A Supreme Court Advocates on Record Association and Another versus Union of India, 2015. 3. A. N. Ray was 4th in seniority. The 3 superseded judges were J. M. Shalak, K. S. Hegde and A. N. Grover. All the 3 judges resigned from the Supreme Court. They were superseded due to their judgment in Keswananda Vaki case, 1973, which was not favorable to the government. 4. He was H.R. Khanna and he too resigned. His dissenting judgment upholding the right to life even during emergency in the ADM Jabalpur v. Shivkant Shukla case, 1976, was not appreciated by the government. 5. An impeachment motion for the removal of a judge does not lapse on the dissolution of the Lok Sabha. 6. In 1950, their salaries were fixed at 5,000 per month and 4,000 per month respectively. In 1986, their salaries were raised to 10,000 per month and 9,000 per month respectively. In 1998, their salaries were raised to 33,000 per month and 30,000 per month respectively. 7. The Criminal Procedure Code, 1973, has effected the separation of judiciary from the executive, Article 50 under the directive principles of state policy. 8. Pre-constitution means that, which have been entered into or executed before the commencement of the Constitution and which continues to be in operation after such commencement. 9. This means that the intergovernment agreements, i.e., the agreements between states or between centre and states, can exclude the original jurisdiction of the Supreme Court insofar as the disputes arising out of them are concerned. 10. The Interstate Water Disputes Act of 1956 has excluded the original jurisdiction of the Supreme Court in disputes between states with respect to the use, distribution or control of the water of interstate river or river valley. 11. These include treaties, covenants, etc. between the central government and the formerly princely states during 1947 to 1950.
Judicial review. The doctrine of
Judicial review originated and developed in the USA. It was propounded for the first time in the famous case of Marbury v. Madison, 1803, by John Marshall, the then Chief Justice of the American Supreme Court. In India, on the other hand, the Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as high courts. Further, the Supreme Court has declared the power of judicial review as a basic feature of the Constitution or an element of the basic structure of the Constitution. Hence, the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. Meaning of judicial review. Judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional and invalid, null and void, by the judiciary. Consequently, they cannot be enforced by the government. Justice Syed Shah Mohammad Qadri has classified the judicial review into the following three categories.
1. Judicial review of constitutional amendments.
2. Judicial review of legislation of the Parliament and state legislatures and subordinate legislations. 3. Judicial review of administrative action of the Union and state and authorities under the state. The Supreme Court used the power of judicial review in various cases, as for example, the Golkanath case, 1967, the bank nationalization case, 1970, the Privy Purses abolition case, 1971, the Keswananda Bharti case, 1973, the Minerva Mills case, 1980, and so on. In 2015, the Supreme Court declared both the 99th Constitutional Amendment, 2014 and the National Judicial Appointments Commission, NJAC, Act, 2014 as unconstitutional and null and void. Importance of judicial review. Judicial review is needed for the following reasons. A. To uphold the principle of the supremacy of the Constitution. B. To maintain federal equilibrium, balance between the center and the states. C. To protect the fundamental rights of the citizens. In a number of cases, the Supreme Court has pointed out the significance of the power of judicial review in our country. Some of the observations made by it, in this regard, are given below. In India it is the Constitution that is supreme, and that a statute law to be valid, must be in conformity with the constitutional requirements, and it is for the judiciary to decide whether any enactment is constitutional or not. 2. Our Constitution contains express provisions for judicial review of legislation as to its conformity with the Constitution. This is especially true as regards the fundamental rights, to which the court has been assigned the role of sentinel on the qui vive. 3. As long as some fundamental rights exist and are a part of the Constitution, the power of judicial review has also to be exercised with a view to see that the guarantees afforded by these rights are not contravened. 4.
The Constitution is supreme lex,
the permanent law of the land, and there is no branch of government above it. Every organ of government, be it the executive or the legislature of the judiciary, derives its authority from the Constitution, and it has to act within the limits of its authority. No one, however highly placed, and no authority howsoever lofty, can claim that it shall be the sole judge of the extent of its power under the Constitution, or whether its action is within the confines of such power laid down by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits, and whether any action of that branch transgresses such limits. 5. It is the function of the judges, made their duty, to pronounce upon the validity of laws. If courts are totally deprived of that power, the fundamental rights conferred on the people will become a mere adornment, because rights without remedies are as writ in water. A controlled constitution will then become uncontrolled. 6. The judges of the Supreme Court have been entrusted with the task of upholding the Constitution, and to this end, have been conferred the power to interpret it. It is they who have to ensure that the balance of power envisaged by the Constitution is maintained and that the legislature and the executive do not, in the discharge of their functions, transgress constitutional limitations. 7. The Founding Fathers very wisely, therefore, incorporated in the Constitution itself the provisions of judicial review so as to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms guaranteed to the citizens and to afford a useful weapon for availability, availment and enjoyment of equality, liberty and fundamental freedoms and to help to create a healthy nationalism. The function of judicial review is a part of the constitutional interpretation itself. It adjusts the Constitution to meet new conditions and needs of the time. 8 Constitutional provisions for judicial review. Though the phrase, judicial review, has nowhere been used in the Constitution, the provisions of several articles explicitly confer the power of
judicial review on the Supreme Court and the High Courts.
These provisions are explained below. 1. Article 13 declares that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. 2. Article 32 guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or writs for that purpose. 3. Article 131 provides for the original jurisdiction of the Supreme Court in center-state and interstate disputes. 4. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. 5. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. 6. Article 134 provides for the appellate jurisdiction of the Supreme Court in criminal cases. 7. Article 134 deals with the certificate for appeal to the Supreme Court from the High Courts. 98. Article 135 empowers the Supreme Court to exercise the jurisdiction and powers of the Federal Court under any pre-constitution law. 9. Article 136 authorizes the Supreme Court to grant special leave to appeal from any court or tribunal, except military tribunal and court-martial. 10. Article 143 authorizes the President to seek the opinion of the Supreme Court on any question of law or fact and on any pre-constitution legal matters. 11. Article 226 empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. 12. Article 227 vests in the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdictions, except military courts or tribunals. 13. Article 245 deals with the territorial extent of laws made by Parliament and by the legislatures of states. 14. Article 246 deals with the subject matter of laws made by Parliament and by the legislatures of states, i.e., Union list, state list and concurrent list.
15.
Articles 251 and 254 provide that in case of a conflict between the central law and state law, the central law prevails over the state law and the state law shall be void. 16. Article 372 deals with the continuance in force of the pre-constitution laws. Scope of judicial review. The constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the following 3 grounds. A. It infringes the fundamental rights. Part 3. B. It is outside the competence of the authority which has framed it. And C. It is repugnant to the constitutional provisions. From the above, it is clear that the scope of judicial review in India is narrower than what exists in the USA, though the American Constitution does not explicitly mention the concept of judicial review in any of its provisions. This is because the American Constitution provides for due process of law, against that of procedure established by law, which is contained in the Indian Constitution. The difference between the two is, the due process of law gives wide scope to the Supreme Court to grant protection to the rights of its citizens. It can declare laws violative of these rights void not only on substantive grounds of being unlawful, but also on procedural grounds of being unreasonable. Our Supreme Court, while determining the constitutionality of a law, however, examines only the substantive question, i.e., whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of its reasonableness, suitability or policy implications. 10. The exercise of wide power of judicial review by the American Supreme Court in the name of due process of law clause has made the critics to describe it as a third chamber of the legislature, a super legislature, the arbiter of social policy, and so on. This American principle of judicial supremacy is also recognized in our constitutional system, but to a limited extent. Nor do we fully follow the British principle of parliamentary supremacy. There are many limitations on the sovereignty of Parliament in our country, like the written character of the Constitution, the federalism with division of powers, the fundamental rights and the judicial review. In effect, what exists in India is a synthesis of both, that is, the American principle of judicial supremacy and the British principle of parliamentary supremacy. Judicial review of the 9th Schedule Article 3(1)(b) saves the acts and regulations included in the 9th Schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Article 3(1)(b) along with the 9th Schedule was added by the First Constitutional Amendment Act of 1951. Originally, in 1951, the 9th Schedule contained only 13 acts and regulations, but at present, in 2016, their number is 282.11 of these. The acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. However, in a significant judgment delivered in Ir Coelhone case, 2007-12, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the 9th Schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th Schedule. It said that the laws placed under the 9th Schedule after 24 April 1973 are open to challenge in court if they violated fundamental rights guaranteed under the Articles 14, 15, 19 and 21 or the basic structure of the Constitution. It was on 24 April 1973 that the Supreme Court first propounded the doctrine of basic structure or basic features of the Constitution in its landmark verdict in the Keswananda Vaki case. 13 While delivering the above judgment, the Supreme Court made the following conclusions. 1. A law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine, or it may not. If former is the consequence of law, whether by an amendment of any article of Part 3 or by an insertion in the 9th Schedule, such law will have to be invalidated in the exercise of judicial review power of the court. The constitutional validity of the 9th Schedule laws on the touchstone of basic structure doctrine can be adjudged by applying the direct impact and effect test, i.e., rights test, which means the form of an amendment is not the relevant factor, but the consequence thereof would be the determinative factor. 2. The majority judgment in the Keswananda Vaki case 14 read with Indira Gandhi case 15 requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys basic structure. The impact test would determine the validity of the challenge. 3. All amendments to the Constitution made on or after 24 April 1973 by which the 9th Schedule is amended by inclusion of various laws therein shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21 read with Articles 14 and 19 and the principles underlying them. To put it differently, even though an act is put in the 9th Schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure if the fundamental right or rights taken away or abrogated pertain to the basic structure. 4. Justification for conferring protection. not blanket protection, on the laws included in the 9th schedule by constitutional amendments shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute, sought to be constitutionally protected, and on the touchstone of the basic structure doctrine as reflected in Article 21 read with Articles 14 and 19 by application of the rights test, and the essence of the rights test. Taking the synoptic view of the articles in Part 3 as held in the Indira Gandhi case. 16 applying the above test to the 9th schedule laws, if the infraction affects the basic structure, then such a law or laws will not get the protection of the 9th schedule. 5. If the validity of any 9th schedule law has already been upheld by this court, it would not be open to challenge such law again on the principles declared by this judgment. However, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the 9th schedule after 24 April 1973, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure as indicated. In Article 21 read with Articles 14 and 19 and the principles underlying them. 6. Action taken and transactions finalized as a result of the impugned acts shall not be open to challenge. The number of acts and regulations included in the 9th schedule before and after 24 April 1973 are mentioned below in Table 26.1. Table 26.1 Number of acts and regulations included in the 9th schedule, serial number, amendment number, year. Number of acts and regulations included in the 9th schedule are included before 24 April 1973. 1. First Amendment, 1951, 13, 1 to 13, 2. Fourth Amendment, 1955, 7, 14 to 20, 3. Seventh Amendment, 1964, 44, 21 to 64, 4. 29 to 65 to 66, Amendment, 1972, 2. Included after 24 April 1973. 5. 34, 20, 67 to 86, Amendment, 1974, 6. 39th Amendment, 1975, 38, 87 to 124, 7. 40th Amendment, 1976, 64, 125 to 188, 8. 47th Amendment, 1984, 14, 189 to 202, 66th.
9th
Amendment, 1990, 55, 203 to 257, 10. 76th Amendment, 1994, 1, 257A, 11. 78th Amendment, 1995, 27, 258 to 284, note, entries 87, 92 and 130 have been omitted by the 44th Amendment, 1978. Notes and references. 1. Justice Syed Shah Mohammad Qadri, Judicial Review of Administrative Action, 2001, 6 SCC, J. P3. 2. Chief Justice Kania in A.K. Gopalan v. State of Madras, 1950. 3. Chief Justice Patanjali Shastri in State of Madras v. V.G. Rao, 1952. 4. Justice Khanna in Keswananda Varti v. State of Kerala, 1973. 5. Justice Bhagwati in Rajasthan v. Union of India, 1977. 6. Chief Justice Chandrachud in Minerva Mills v. Union of India, 1980. 7. Chief Justice Ahmadi in L. Chandra Kumar v. Union of India, 1997. 8. Justice Ramaswamy in S.S. Bola v. B.D. Sharma, 1997. 9. This provision was added by the 44th Constitutional Amendment Act of 1978. 10. Subhash C. Kashyap, Our Constitution, National Book Trust, 3rd edition, 2001, p. 232. 11. Though the last entry is numbered 284, the actual total number is 282. This is because the 3 entries, 87, 92 and 130, have been deleted and one entry is numbered as 257A. 12 Ir Koilhon We State of Tamil Nadu, 2007. 13 Keswananda Bharti We State of Kerala, 1973. 14 Ibid. 15 Indira Nehru Gandhi We Raj Narayan, 1975. 16 Ibid.
Judicial activism,
The concept of judicial activism originated and developed in the USA. This term was first coined in 1947 by Arthur Schlesinger Jr., anti-American historian and educator. 1 In India, the doctrine of judicial activism was introduced in mid-1970s. Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice O. Chinnappa Reddy and Justice D.A. Desai laid the foundations of judicial activism in the country. Meaning of judicial activism. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in the society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. Judicial activism is also known as
judicial dynamism. It is the antithesis of judicial restraint, which means the self-control exercised by the judiciary. Judicial activism is defined in the following way. 1. Judicial activism is a way of exercising judicial power that motivates judges to depart from normally practiced strict adherence to judicial precedent in favor of progressive and new social policies. It is
commonly marked by decision calling for social engineering, and occasionally these decisions represent intrusion in the legislative and executive matters. 22. Judicial activism is the practice in the judiciary of protecting or expanding individual rights through decisions that depart from established precedent, or are independent of, or in opposition to supposed constitutional or legislation intent. 3. The concept of judicial activism is closely related to the concept of public interest litigation, PIL. It is the judicial activism of the Supreme Court which is the major factor for the rise of PIL. In other words, PIL is an outcome of judicial activism. In fact, PIL is the most popular form, or manifestation, of judicial activism. Justification of judicial activism. According to Dr. B.L. Vedehra, the reasons for judicial activism are as follows. 4. There is near collapse of the responsible government, when the legislature and executive fail to discharge their respective functions. This results in erosion of the confidence in the constitution and democracy amongst the citizens. 2. The citizens of the country look up to the judiciary for the protection of their rights and freedoms. This leads to tremendous pressure on judiciary to step in aid for the suffering masses. 3. Judicial enthusiasm, that is, the judges like to participate in the social reforms that take place in the changing times. It encourages the public interest litigation and liberalizes the principle of locus standi. 4. Legislative vacuum, that is, there may be certain areas which have not been legislated upon. It is therefore upon court to indulge in judicial legislation and to meet the changing social needs. The Constitution of India has itself adopted certain provisions, which gives judiciary enough scope to legislate or to play an active role. Similarly, Subhash Kashyap observes that certain eventualities may be conceived when the judiciary may have to overstep its normal jurisdiction and intervene in areas otherwise falling within the domain of the legislature.
And the executive. 5.
When the legislature fails to discharge its responsibilities.
2. In case
of a legislature, when the government it provides is weak, insecure and busy only in the struggle for survival and, therefore, unable to take any decision which displeases any caste, community, or other group. 3. Those in power may be afraid of taking honest and hard decisions for fear of losing power and, for that reason, may have public issues referred to courts as issues of law in order to mark time and delay decisions or to pass on the odium of strawing decision-making to the courts. 4. Where the legislature and the executive fail to protect the basic rights of citizens, like the right to live a decent life, healthy surroundings, or to provide honest, efficient and just system of laws and administration. Where the court of law is misused by a strong authoritarian parliamentary party government for ulterior motives, as was sought to be done during the emergency aggression. 6. Sometimes, the courts themselves knowingly or unknowingly become victims of human, all too human, weaknesses of craze for populism, publicity, playing to the media and hogging the headlines. According to Dr. Vandana, the concept of judicial activism can be seen to be reflecting from the following trends, namely, 5a. Expansion of rights of hearing in the administrative process. 2. Excessive delegation without limitation. 3. Expansion of judicial control over discretionary powers. 4. Expansion of judicial review over the administration. Promotion of open government. 6. Indiscriminate exercise of contempt power. 7. Exercise of jurisdiction when none exist. 8. Overextending the standard rules of interpretation in its search to achieve economic, social and educational objectives. 9. Passing of orders which are per se unworkable. Activators of judicial activism Upendra Baxi, an eminent jurist, has delineated the following typology of
social human rights
activists who activated judicial activism. 6. 1. Civil rights activists. These groups primarily focus on civil and political rights issues. 2. People rights activists. These groups focus on social and economic rights within the contexts of state repression of people's movements. 3. Consumer rights groups. These formations raise issues of consumer rights within the framework of accountability of the polity and the economy. 4. Bonded labor groups. These groups ask for judicial activism is nothing short of annihilation of wage slavery in India. 5. Citizens for environmental action. These groups activate an activist judiciary to combat increasing environmental degradation and pollution. 6. Citizen groups against large irrigation projects. These activist formations ask the Indian judiciary the impossible for any judiciary in the world, namely, cease to and desist from ordering against mega irrigation projects. 7. Rights of child groups. These groups focus on child labor, the right to literacy, juveniles in custodial institutions and rights of children born to sex workers. 8. Custodial rights groups. These groups include social action by prisoners' rights groups, women under the state, protective, custody and persons under preventive detention. 9. Poverty rights groups. These groups litigate issues concerning drought and famine relief and urban impoverished. 10. Indigenous peoples' rights groups. These groups agitate for issues of forest dwellers, citizens of the 5th and 6th schedules of the Indian Constitution and identity rights. 11. Women's rights groups. These groups agitate for issues of gender equality, gender-based violence and harassment, rape and dowry murders. 12. Bar-based groups. These associations agitate for issues concerning autonomy and accountability of the Indian judiciary. 13. Media autonomy groups. These groups focus on the autonomy and accountability of the press and instruments of mass media owned by the state. 14. Assorted lawyer-based groups. This category includes the critically
influential lawyers
groups which agitate for various causes. 15. Assorted individual petitioners. This category includes freelance activist individuals. Apprehensions of judicial activism. The same jurist Upendra Baxi also presented a typology of fears which are generated by judicial activism. He observes, the facts entail invocation of a wide range of fears. The invocation is designed to bring into a nervous rationality among India's most conscientious justices. He described the following types of fears. 7. 1. Ideological fears. Are they usurping powers of the legislature, the executive or of other autonomous institutions in a civil society? 2. Epistemic fears. Do they have enough knowledge in economic matters of a Manmohan Singh, in scientific matters of the czars of the atomic energy establishment, the captains of the Council of Scientific and Industrial Research, and so on? 3. Management fears. Are they doing justice by adding this kind of litigation workload to a situation of staggering growth of arrears? For legitimation fears, are not they causing depletion of their symbolic and instrumental authority by passing orders in public interest litigation which the executive may bypass or ignore? Would not the people's faith in judiciary, a democratic recourse, be thus eroded? 5. Democratic fears, is a profusion of public interest litigation nurturing democracy or depleting its potential for the future? 6. Biographic fears, what would be my place in national affairs after superannuation if I overdo this kind of litigation? Judicial activism versus judicial restraint. Meaning of judicial restraint. Judicial activism and judicial restraint are the two alternative judicial philosophies in the United States. Those who subscribe to judicial restraint contend that the role of judges should be scrupulously limited. Their job is
merely to say
what the law is, leaving the business of lawmaking where it properly belongs, that is, with the legislators and the executives. Under no circumstances, moreover, should judges allow their personal political values and policy agendas to color their judicial opinions. This view holds that the original intent of the authors of the Constitution and its amendments is knowable, and must guide the courts. 8 Assumptions of judicial restraint in the USA. The doctrine of judicial restraint is based on the following 6 assumptions. 9. 1. The court is basically undemocratic because it is non-elective and presumably non-responsive to the popular will. Because of its alleged oligarchic composition, the court should defer wherever possible to the more democratic branches of government. 2. The questionable origins of the great power of judicial review, a power not specifically granted by the Constitution. 3. The doctrine of separation of powers. 4. The concept of federalism, dividing powers between the nation and the states, requires of the court deference toward the action of state governments and officials. 5. The non-ideological but pragmatic assumption that since the court is dependent on the Congress for its jurisdiction and resources, and dependent on public acceptance for its effectiveness, it ought not to overstep its boundaries without consideration of the risks involved. 6. The aristocratic notion that, being a court of law, and inheritor and custodian of the Anglo-American legal tradition, it ought not to go too far to the level of politics, law being the process of reason and judgment and politics being concerned only with power and influence. From the above, it is clear that all the assumptions, except the second dealing with the judicial review, hold good in the Indian context too. Supreme Court observations. While delivering a judgment in December 2007, the Supreme Court of India called for judicial restraint and asked courts not to take over the functions of the legislature or the executive, saying there is a broad separation of powers under the Constitution and each organ of the state must have respect for others and should not encroach on others' domain. In this context, the concerned bench of the court made the following observations. 10. 1. The bench said, "We are repeatedly coming across cases where judges are unjustifiably trying to perform executive or legislative functions. This is clearly unconstitutional. In the name of judicial activism, judges cannot cross their limits and try to take over functions which belong to another organ of the state." 2. The bench said, "Judges must know their limits and must not try to run the government. They must have modesty and humility, and not behave like emperors." 3. Quoting from the book, The Spirit of Laws by Montesquieu on the consequences of not maintaining separation of powers among the three organs, the bench said the French political philosophers' warning is particularly apt and timely for the Indian judiciary today, since very often it is rightly criticized for overreach and encroachment on the domain of the other two organs. 4. Judicial activism must not become judicial adventurism. The bench warned the court's adjudication must be done within the system of historically validated restraints and conscious minimization of judges' preferences. 5. The courts must not embarrass administrative authorities and must realize that administrative authorities have expertise in the field of administration while the court does not. 6. The bench said, the justification often given for judicial encroachment on the domain of the executive or the legislature is that the other two organs are not doing their jobs properly. Even assuming this is so, the same allegations can be made against the judiciary too, because there are cases pending in courts for half a century. 7. If the legislature or the executive was not functioning properly, it was for the people to correct the defects by exercising their franchise properly in the next elections and voting for candidates who would fulfill their expectations or by other lawful methods, e.g., peaceful demonstrations. 8. The remedy is not in the judiciary taking over the legislative or the executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution but also, because the judiciary has neither the expertise nor the resources to perform these functions. 9. The bench said, judicial restraint is consistent with and complementary to the balance of power among the three independent branches of the state. It accomplishes this in two ways. First, judicial restraint not only recognizes the equality of the other two branches with the judiciary, it also fosters that equality by minimizing inter-branch interference by the judiciary. Second, judicial restraint tends to protect the independence of the judiciary. When courts encroach on the legislative or administrative fields, almost inevitably voters, legislators, and other elected officials will conclude that the activities of judges should be closely monitored. Notes and references. 1. His article entitled as The Supreme Court, 1947, was published in the Fortune magazine. 2. Black's Law Dictionary. 3. Merriam-Webster's Dictionary of Law. 4. Dr. B. L. Vedehra, Public Interest Litigation, a Handbook, 2nd edition, 2009, Universal Law Publishing Co., pp. 161162. 5. Subhash C. Kashyap, Judiciary Legislature Interface, in Politics India, New Delhi, April 1997, p. 22. 5. A. Dr. Vandana, Dimensions of Judicial Activism in India, 2016, Raj Publications, New Delhi pp. 33-34. 6. Upendra Baxi, The Avatars of Indian Judicial Activism, Explorations in the Geographies of, in, Justice, in S.K. Verma and Kusum, ed. 50 Years of the Supreme Court of India, Its Grasp and Reach, Indian Law Institute and Oxford University Press, 2000, pp. 173175. 7. Upendra Baxi, Judicial Activism, Legal Education and Research in Globalizing India, in Mainstream, New Delhi, 24 February 1996, p. 16. 8. Ian MacLean and Alistair Macmillan, Oxford Concise Dictionary of Politics, 1st Indian edition, 2004, p. 284. 9. Joel B. Grossman and Richard S. Wells, ed. Constitutional Law and Judicial Policy Making, 1972, pp. 56-57. 10. The Hindu, Don't Cross Limits, Apex Court Asks Judges, December 11, 2007.
Public
Public
interest litigation.
The concept of public interest litigation, PIL, originated and developed in the USA in the 1960s.
In the USA,
it was designed to provide legal representation to previously unrepresented groups and interests. It was undertaken in recognition of the fact that the ordinary marketplace for legal services fails to provide such services to significant segments of the population and to significant interests. Such groups and interests include the TPOA, environmentalists, consumers, racial and ethnic minorities, and others. 1. In India, the PIL is a product of the judicial activism role of the Supreme Court. It was introduced in the early 1980s. Justice V.R. Krishna Iyer and Justice P.N. Bhagwati were the pioneers of the concept of PIL. PIL is also known variously as social action litigation, SAL, social interest litigation, SIL, and class action litigation, COL. Meaning of PIL. The introduction of PIL in India was facilitated by the relaxation of the traditional rule of locus standi. According to this rule, only that person whose rights are infringed alone can move the court for the remedies, whereas the PIL is an exception to this traditional rule. Under the PIL, any public-spirited citizen or a social organization can move the court for the enforcement of the rights of any person or group of persons who, because of their poverty or ignorance or socially or economically disadvantaged position,
are
are
themselves
themselves
unable to approach
the court for the remedies. Thus, in a PIL, any member of the public having sufficient interest can approach the court for enforcing the rights of other persons and redressal of a common grievance.
The
The
Supreme
Supreme
Court
Court
has
has
defined
defined
the
the
PIL
PIL
as
as
a
a
legal
legal
action
action initiated in a
court
court of law for the enforcement of public interest or general interest in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. 2. PIL is absolutely necessary for maintaining the rule of law, furthering the cause of justice and accelerating the pace of realization of the constitutional objectives. In other words, the real purposes of PIL are I. Vindication of the rule of law, 2. Facilitating effective access to justice to the socially and economically weaker sections of the society, and 3. Meaningful realization of the fundamental rights. Features of PIL. The various features of the PIL are explained below. 1. PIL is a strategic arm of the legal aid movement and is intended to bring justice within the reach of the poor masses, who constitute the low visibility area of humanity. 2. PIL is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is a dispute between two litigating parties, one making claims seeking relief against the other and that other opposing such claim or resisting such relief. 3. PIL is brought before the court not for the purpose of enforcing the right of one individual against another as happens in the case of ordinary litigation, but it is intended to promote and vindicate public interest. 4. PIL demands that violations of constitutional and legal rights of large numbers of people who are poor, ignorant or in a socially or economically disadvantaged position should not go unnoticed and unredressed. 5. PIL is essentially a cooperative effort on the part of the petitioner, the state or public authority, and the court to secure observance of the
constitutional
or legal rights, benefits and privileges conferred upon the vulnerable sections of the community and to reach social justice to them. 6. In PIL, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protecting social, collective, diffused rights and interests or vindicating public interest. 7. In PIL, the role held by the court is more assertive than in traditional actions. It is creative rather than passive and it assumes a more positive attitude in determining acts. 8. Though in PIL court enjoys a degree of flexibility unknown to the trial of traditional private law litigations, whatever the procedure adopted by the court, it must be procedure known to judicial tenets and characteristics of a judicial proceeding. 9. In a PIL, unlike traditional dispute resolution mechanism, there is no determination on adjudication of individual rights. Scope of PIL. In 1998, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by it as PIL. These guidelines were modified in 1993 and 2003. According to them, the letters or petitions falling under the following categories alone will ordinarily be entertained as PIL. 1. Bonded labor matters. 2. Neglected children. 3. Non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws, except in individual cases. 4. Petitions from jails complaining of harassment, for premature release and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right. 5. Petitions against police for refusing to register a case, harassment by police and death in police custody. 6. Petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. 7. Petitions complaining of harassment or torture of villagers by co-villagers or by police from persons belonging to scheduled caste and scheduled
tribes
tribes
and economically
backward classes. 8. Petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife and other matters of public importance. 9. Petitions from riot victims. 10. Family pension. The cases falling under the following categories will not be entertained as PIL. 1. Landlord-tenant matters. 2. Service matter and those pertaining to pension and gratuity. 3.
Complaints
Against central state government departments and local bodies except those relating to item numbers 1, 10, above 4. Admission to medical and other educational institution. 5. Petitions for early hearing of cases pending in high courts and subordinate courts. Principles of PIL. The Supreme Court evolved the following principles in regard to PIL. 3. 1. The court in exercise of powers under Articles 32 and 226 of the Constitution can entertain a petition filed by any interested person in the welfare of the people who are in a disadvantaged position and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people and direct the state to fulfill its constitutional promises. 2. When the issues of public importance, enforcement of the fundamental rights of large number of people vis-à-vis the constitutional duties and functions of the state are raised, the court treats a letter or a telegram as a PIL. In such cases, the court relaxes the procedural laws and also the law relating to pleadings. 3. Whenever injustice is meted out to a large number of people, the court will not hesitate to step in to invoke Articles 14 and 21 of the Constitution of India as well as the International Conventions on Human Rights which provide for a reasonable and fair trial. 4. The common rule of locus standi is relaxed so as to enable the court to
look into the grievances
complained on behalf of the poor, deprived, illiterate and the disabled who cannot vindicate the legal wrong or legal injury caused to them for violation of any constitutional or legal right. 5. When the court is prima facie satisfied about violation of any constitutional right of a group of people belonging to the disadvantaged category, it may not allow the state or the government from raising the question as to the maintainability of the petition. 6. Although procedural laws apply on PIL cases, the question as to whether the principles of res judicata for or principles analogous thereto would apply depend on the nature of the petition and also facts and circumstances of the case. 7. The dispute between two warring groups purely in the realm of private law would not be allowed to be agitated as a PIL. 8. However, in an appropriate case, although the petitioner might have moved a court in his private interest and for redressal of the personal grievances, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. 9. The court in special situations may appoint commission or other bodies for the purpose of investigating into the allegations and finding out facts. It may also direct management of a public institution taken over by such commission. 10. The court will not ordinarily transgress into a policy. It shall also take utmost care not to transgress its jurisdiction while purporting to protect the rights of the people from being violated. 11. The court would ordinarily not step out of the known areas of judicial review. The High Court, although may pass an order for doing complete justice to the parties, it does not have a power akin to Article 142 of the Constitution of India. 12. Ordinarily the High Court should not entertain a writ petition by way of PIL questioning constitutionality or validity of a statute or a statutory rule. Guidelines for admitting PIL. The PIL has now come to occupy an important field in the administration of law. It should not be allowed to become publicity interest litigation, or
politics interest litigation,
or private interest litigation, or paisa interest litigation, or middle-class interest litigation, MIL. The Supreme Court, in this context, observed, PIL is not a pill or a panacea for all wrongs. It was essentially meant to protect basic human rights of the weak and the disadvantaged and was a procedure which was innovated where a public-spirited person files a petition in effect on behalf of such persons who on account of poverty, helplessness or economic and social disabilities could not approach the court for relief. There have been, in recent times, increasingly instances of abuse of PIL. Therefore, there is a need to re-emphasize the parameters within which PIL can be resorted to by a petitioner and entertained by the court. 5. Therefore, the Supreme Court laid down the following guidelines for checking the misuse of the PIL. 6. 1. The court must encourage genuine and bona fide PIL and effectively discourage and curb the PIL field for extraneous considerations. 2. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate for each High Court to properly formulate rules for encouraging the genuine PIL filed and discouraging PIL filed with oblique motives. 3. The court should prima facie verify the credentials of the petitioner before entertaining the PIL. 4. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PIL. 5. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. 6. The court should ensure that the petition which involves larger public interest, gravity and urgency must be given priority over other petitions. 7. The court before entertaining the PIL must ensure that the PIL is aimed at redressal of genuine public harm and public injury. The court should also ensure that there is no personal gain, private motive or oblique motive behind filing PIL. 8. The court should also ensure that the petition filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary costs or adopting similar novel methods to curb frivolous petitions and the petitions filed for extraneous considerations.
Notes and references
1. Balancing the Scales of Justice Financing Public Interest Law in America, a report by the Council for Public Interest Law, 1976, pp.67. 2. Janata Dal vs. Chaudhary, 1992.
Sri Guru
Devas Managing Committee v. C.K. Rajan, 2003. 4. The principle that when a matter has been finally adjudicated upon by a court of competent jurisdiction it may not be reopened or challenged by the original parties or their successors in interest. Its justification is the need for finality in litigation. Oxford Dictionary of Law, 8th edition, 2015, p. 537. 5. Balco Employees Union v. Union of India, 2002. 6. State of Uttaranchal v. Balwant Singh Chopal, 2010.
Part 4
State Governor 30. Governor 31. Chief Minister 32.
State
Council
Council
of Ministers 33. State Legislature 34. High Court 35. Subordinate Courts 36. Special Status of Jammu and Kashmir 37. Special Provisions for some states.
Governor
The Constitution of India envisages the same pattern of government in the states as that for the centre, that is, a parliamentary system. Part 6 of the Constitution, which deals with the government in the states, is not applicable to the state of Jammu and Kashmir, which enjoys a special status and has a separate constitution of its own. Articles 153 to 167 in Part 6 of the Constitution deal with the state executive. The state executive consists of the governor, the chief minister, the council of ministers and the advocate general of the state. Thus, there is no office of vice governor in the state, like that of vice president at the center. The governor is the chief executive head of the state. But, like the president, he is a nominal executive head, titular or constitutional head. The governor also acts as an agent of the central government. Therefore, the office of governor has a dual role. Usually, there is a governor for each state, but the 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person as a governor for 2 or more states. Appointment of governor. The governor is neither directly elected by the people nor indirectly elected by a specially constituted electoral college as is the case with the president.
He is
appointed by the president by warrant under his hand and seal. In a way, he is a nominee of the central government. But, as held by the Supreme Court in 1979, the office of governor of a state is not an employment under the central government. It is an independent constitutional office and is not under the control of or subordinate to the central government. The draft constitution provided for the direct election of the governor on the basis of universal adult suffrage. But the Constituent Assembly opted for the present system of appointment of governor by the president because of the following reasons. 1. The direct election of the governor is incompatible with the parliamentary system established in the states. 2. The mode of direct election is more likely to create conflicts between the governor and the chief minister. 3. The governor being only a constitutional, nominal, head, there is no point in making elaborate arrangements for his election and spending huge amount of money. For the election of a governor would be entirely on personal issues. Hence, it is not in the national interest to involve a large number of voters in such an election. 5. An elected governor would naturally belong to a party and would not be a neutral person and an impartial head. 6. The election of governor would create separatist tendencies and thus affect the political stability and unity of the country. 7. The system of presidential nomination enables the center to maintain its control over the states. 8. The direct election of the governor creates a serious problem of leadership at the time of a general election in the state. 9. The chief minister would like his nominee to contest for governorship. Hence, a second-rate man of the ruling party is elected as governor. Therefore, the American model, where the governor of a state is directly elected, was dropped, and the Canadian model, where the governor of a province, state, is appointed by the Governor-General, Centre, was accepted in the Constituent Assembly. The Constitution lays down only 2 qualifications for the appointment of a person as a governor. These are:
1. He
1.
should
He
be
should
a
be a
citizen of India.
2.
He
He
should have
should have
completed
completed
the age of
35 years. Additionally, 2 conventions have also developed in this regard over the years. First, he should be an outsider, that is, he should not belong to the state where he is appointed, so that he is free from the local politics. Second, while appointing the governor, the president is required to consult the chief minister of the state concerned, so that the smooth functioning of the constitutional machinery in the state is ensured. However, both the conventions have been violated in some of the cases. Conditions of governor's office. The Constitution lays down the following conditions for the governor's office. 1. He should not be a member of either House of Parliament or a House of the state legislature. If any such person is appointed as governor, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as the governor. 2. He should not hold any other office of profit. 3. He is entitled without payment of rent to the use of his official residence, the Raj Bhavan. 4. He is entitled to such emoluments, allowances and privileges as may be determined by Parliament. 5. When the same person is appointed as the governor of 2 or more states, the emoluments and allowances payable to him are shared by the states in such proportion as determined by the President. 6. His emoluments and allowances cannot be diminished during his term of office. In 2008, the Parliament has increased the salary of the governor from 36,000 to 1.10 lakh per month. 2. Like the President, the governor is also entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can
be instituted against him during
his term of office in respect of his personal acts. Before entering upon his office, the governor has to make and subscribe to an oath or affirmation. In his oath, the governor swears, a. to faithfully execute the office, b. to preserve, protect and defend the Constitution and the law, and c. to devote himself to the service and well-being of the people of the state. The oath of office to the governor is administered by the Chief Justice of the concerned state High Court, and in his absence, the senior-most judge of that court available. Every person discharging the functions of the governor also undertakes the similar oath or affirmation. Term of governor's office. A governor holds office for a term of 5 years from the date on which he enters upon his office. However, this term of 5 years is subject to the pleasure of the President. Further, he can resign at any time by addressing a resignation letter to the President. The Supreme Court held that the pleasure of the President is not justifiable. The governor has no security of tenure and no fixed term of office. He may be removed by the President at any time. 3. The Constitution does not lay down any grounds upon which a governor may be removed by the President. Hence, the National Front government headed by V.P. Singh, 1989, asked all the governors to resign as they were appointed by the Congress government. Eventually, some of the governors were replaced and some were allowed to continue. The same thing was repeated in 1991, when the Congress government headed by P.V. Narasimha Rao changed 14 governors appointed by the V.P. Singh and Chandra Shekhar governments. The president may transfer a governor appointed to one state to another state for the rest of the term. Further, a governor whose term has expired may be reappointed in the same state or any other state. A governor can hold office beyond his term of 5 years until his
successor assumes charge.
The underlying idea is that there must be a governor in the state and there cannot be an interregnum. The president can make such provision as he thinks fit for the discharge of the functions of the governor in any contingency not provided for in the constitution, for example, the death of a sitting governor. Thus, the Chief Justice of the concerned state high court may be appointed temporarily to discharge the functions of the governor of that state. Powers and functions of governor. A governor possesses executive, legislative, financial and judicial powers more or less analogous to the President of India. However, he has no diplomatic, military or emergency powers like the President. The powers and functions of the governor can be studied under the following heads: 1. Executive powers, 2. Legislative powers, 3. Financial powers, 4. Judicial powers. Executive powers. The executive powers and functions of the governor are: 1. All executive actions of the government of a state are formally taken in his name. 2. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. 3. He can make rules for more convenient transaction of the business of a state government and for the allocation among the ministers of the said business. 4. He appoints the chief minister and other ministers. They also hold office during his pleasure. There should be a tribal welfare minister in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha appointed by him. The state of Bihar was excluded from this provision by the 94th Amendment Act of 2006.
5.
5. He appoints the Advocate General of a state and determines his remuneration. The Advocate General holds office during the pleasure of the governor. 6. He appoints the State Election Commissioner and determines his conditions of service and tenure of office. However, the State Election Commissioner can be removed only in like manner and on the like grounds as a judge of a high court. 7. He appoints the chairman and members of the State Public Service Commission. However, they can be removed only by the president and not by a governor. 8. He can seek any information relating to the administration of the affairs of the state and proposals for legislation from the chief minister. 9. He can require the chief minister to submit for the consideration of the council of ministers any matter on which a decision has been taken by a minister but which has not been considered by the council. 10. He can recommend the imposition of constitutional emergency in a state to the president. During the period of president's rule in a state, the governor enjoys extensive executive powers as an agent of the president. 11. He acts as the chancellor of universities in the state. He also appoints the vice-chancellors of universities in the state. Legislative powers. A governor is an integral part of the state legislature. In that capacity, he has the following legislative powers and functions. 1. He can summon or prorogue the state legislature and dissolve the state legislative assembly. 2. He can address the state legislature at the commencement of the first session after each general election and the first session of each year. 3. He can send messages to the house or houses of the state legislature, with respect to a bill pending in the legislature or otherwise. 4. He can appoint any member of the state legislative assembly to preside over its proceedings when the offices of both the speaker and the deputy speaker fall vacant. Similarly, he can appoint any member of the state legislature council to preside over its proceedings when the offices of
both chairman and
deputy
chairman
chairman fall vacant. 5. He nominates 1/6 of the members of the state legislative council from amongst persons having special knowledge or practical experience in literature, science, art, cooperative movement and social service. 6. He can nominate one member to the state legislature assembly from the Anglo-Indian community. 7. He decides on the question of disqualification of members of the state legislature in consultation with the election commission. 8. When a bill is sent to the governor after it is passed by state legislature, he can a. give his assent to the bill, or b. withhold his assent to the bill, or c. return the bill, if it is not a money bill, for reconsideration of the state legislature. However, if the bill is passed again by the state legislature with or without amendments, the governor has to give his assent to the bill, or d. reserve the bill for the consideration of the president. In one case such reservation is obligatory, that is, where the bill passed by the state legislature endangers the position of the state high court. In addition, the governor can also reserve the bill if it is of the following nature: 4. I. ultra vires, that is, against the provisions of the Constitution. 2. Opposed to the directive principles of state policy. 3. Against the larger interest of the country. 4. Of grave national importance. We. Dealing with compulsory acquisition of property under Article 3(1) of the Constitution. 9. He can promulgate ordinances when the state legislature is not in session. These ordinances must be approved by the state legislature within 6 weeks from its reassembly. He can also withdraw an ordinance anytime. This is the most important legislative power of the governor. 10. He lays the reports of the State Finance Commission, the State Public Service Commission and the Controller and Auditor General relating to the accounts of the state, before the state legislature.
Financial
The financial powers and functions of the governor are: 1. He sees that the annual financial statement, state budget, is laid before the state legislature. 2. Money bills can be introduced in the state legislature only with his prior recommendation. 3. No demand for a grant can be made except on his recommendation. 4. He can make advances out of the contingency fund of the state to meet any unforeseen expenditure. 5. He constitutes a finance commission after every 5 years to review the financial position of the panchayats and the municipalities. Judicial powers. The judicial powers and functions of the governor are: 1. He can grant pardons, reprieves, respites and remissions of punishment or suspend, remit and commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. 5. 2. He is consulted by the President while appointing the judges of the concerned state high court. 3. He makes appointments, postings and promotions of the district judges in consultation with the state high court. 4. He also appoints persons to the judicial service of the state, other than district judges, in consultation with the state high court and the State Public Service Commission. Now, we will study in detail the 3 important powers of the governor: veto power, ordinance-making power and pardoning power, by comparing them with that of the President. Table 30.1 Comparing veto powers of President and Governor. President-Governor with regard to ordinary bills. With regard to ordinary bills,
Every ordinary
bill, after it is passed by both the houses of the Parliament either singly or at a joint sitting, is presented to the President for his assent. He has 3 alternatives. 1. He may give his assent to the bill then becomes an act. 2. He may withhold his assent to the bill then ends and does not become an act. 3. He may return the bill for reconsideration of the houses. If the bill is passed by both the houses again with or without amendments and presented to the President for his assent, the President must give his assent to the bill. Thus the President enjoys only a suspensive veto. Every ordinary bill, after it is passed by the Legislative Assembly in case of a unicameral legislature or by both the houses in case of a bicameral legislature either in the first instance or in the second instance, is presented to the Governor for his assent. He has 4 alternatives. 1. He may give his assent to the bill then becomes an act. 2. He may withhold his assent to the bill then ends and does not become an act. 3. He may return the bill for reconsideration of the House or Houses. If the bill is passed by the House or Houses again with or without amendments and presented to the Governor for his assent, the Governor must give his assent to the bill. Thus, the Governor enjoys only a Suspensive veto. 4. He may reserve the bill for the consideration of the President. When a state bill is reserved by the governor for the consideration of the President has 3 alternatives. A. He may give his assent to the when the governor reserves a bill for bill, the bill then becomes an act. The consideration of the President, B. He may withhold his assent to will not have any further role in the bill then ends and does enactment of the bill. If the bill is not become an act returned by the President for the C. He may return the bill for reconsideration of the House or reconsideration of the House or Houses and is passed again, the bill.
Houses of
of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within 6 months. If the bill is passed by the House or Houses again with or without amendments and presented to the President for his assent, the President is not bound to give his assent to the bill. He may give his assent to such a bill or withhold his assent.
Must be
presented
again
for the presidential assent only. If the President gives his assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. With regard to money bills, every money bill after it is passed by the Parliament is presented to the President for his assent. He has 2 alternatives. 1. He may give his assent to the bill then becomes an act. 2. He may withhold his assent to the bill then ends and does not become an act. Every money bill, after it is passed by the state legislature, unicameral or bicameral, is presented to the governor for his assent. He has 3 alternatives. 1. He may give his assent to the bill then becomes an act. 2. He may withhold his assent to the bill then ends and does not become an act. 3. He may reserve the bill for the consideration of the President. Thus, the President cannot return a money bill for the reconsideration of the Parliament. Normally, the governor cannot return a President gives his assent to a money bill for the reconsideration of bill as it is introduced in the state legislature. Normally, the Parliament with his previous governor gives his assent to a money permission bill as it is introduced in the state when a money bill is reserved by legislature with his previous the governor for the consideration of permission. The President has to when the governor reserves a money.
Alternatives.
Bill for the consideration of the A. He may give his assent to the bill, President. He will not have any further. The bill then becomes an act. Role in the enactment of the bill. If the B. He may withhold his assent to the President gives his assent to the bill, the bill then ends and does not becomes an act. This means that the become an act. Assent of the governor is no longer thus, the President cannot return a required money bill for the reconsideration of the state legislature, as in the case of the Parliament. Table 30.2 Comparing ordinance making power of President and Governor. President Governor 1. He can promulgate an ordinance only when both the Houses of Parliament are not in session or when either of the 2 Houses of Parliament is not in session. The second provision implies that an ordinance can also be promulgated by the President when only one House is in session because a law can be passed by both the Houses and not by one House alone. 1. He can promulgate an ordinance only when the Legislative Assembly, in case of a unicameral legislature, is not in session or, in case of a bicameral legislature, when both the Houses of the state legislature are not in session or when either of the 2 Houses of the state legislature is not in session. The last provision implies that an ordinance can be promulgated by the governor when only one House, in case of a bicameral legislature, is in session because a law can be passed by both the Houses and not by one House alone. 2. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. 2. He can promulgate an ordinance only when he is satisfied that circumstances exist which render it necessary for him to take immediate action. 3. His ordinance making power is coextensive with the legislative power of the Parliament. This means that he can issue ordinances only on those subjects on which the Parliament can make laws. 3. His ordinance making power is co-extensive with the legislative power of the state legislature. This means that he can issue ordinances only on those subjects on which the state legislature can make laws. 4. An ordinance issued by him has the same force and effect as an act of the Parliament. 4. An ordinance issued by him has the same force and effect as an act of the state legislature. 5. An ordinance issued by him is subject to the same limitations as an act of Parliament. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the Parliament cannot make. 5. An ordinance issued by him is subject to the same limitations as an act of the state legislature. This means that an ordinance issued by him will be invalid to the extent it makes any provision which the state legislature cannot make. 6. He can withdraw an ordinance at any time. 6. He can withdraw an ordinance at any time. 7. His ordinance-making power is not a discretionary power. This means that he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. 7. His ordinance-making power is not a discretionary power. This means that he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Chief Minister. 8. An ordinance issued by 8. An ordinance issued by him should be laid before the Legislative Assembly or both the houses of the state legislature, in case Parliament when it of a bicameral legislature, when it
reassembles.
9. An ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. It may cease to operate even earlier than the prescribed 6 weeks, if both the Houses of Parliament passes resolutions disapproving it. 9. An ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of the state legislature. It may cease to operate even earlier than the prescribed 6 weeks, if a resolution disapproving it is passed by the Legislative Assembly and is agreed to by the Legislative Council, in case of a bicameral legislature. 10. He cannot make an ordinance without the instructions from the President in 3 cases. A. If a bill containing the same provisions would have required the previous sanction of the President for its introduction into the 10. He needs no instruction for state legislature making an ordinance. B. If he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President. C. If an act of the state legislature containing the same provisions would have been invalid without receiving the President's assent. Table 30.3 Comparing pardoning powers of President and Governor. President Governor 1. He can pardon, reprieve, respite, remit, suspend or 1. He can pardon, reprieve, respite, remit, commute the punishment or suspend or commute the punishment or sentence of any person convicted of any offense against a state law, against a central law. 2.
He can pardon,
reprieve. 2. He cannot pardon a death sentence, even respite, remit, suspend or if a state law prescribes for death sentence, commute a death sentence. The power to grant pardon lies with he is the only authority to President and not the Governor. But, the pardon a death sentence. Governor can suspend, remit or commute a death sentence. 3. He can grant pardon, reprieve, respite, suspension, remission or commutation in 3. He does not possess any such power. Respect to punishment or sentence by a court-martial, military court. Constitutional position of Governor. The Constitution of India provides for a parliamentary form of government in the states as in the centre. Consequently, the Governor has been made only a nominal executive. The real executive constitutes the Council of Ministers headed by the Chief Minister. In other words, the Governor has to exercise his powers and functions with the aid and advice of the Council of Ministers headed by the Chief Minister, except in matters in which he is required to act in his discretion, i.e., without the advice of ministers. In estimating the constitutional position of the Governor, particular reference has to be made to the provisions of Articles 154, 163 and 164. These are, the executive power of the state shall be vested in the Governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. Article 154. B. There shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his functions, except in so far as he is required to exercise his functions in his discretion. Article 163. C. The council of ministers shall be collectively responsible to the legislative assembly of the state. Article 164. This provision is the foundation of the parliamentary system of government in the state. From the above, it is clear that constitutional position of the governor differs from that of the president in the following two respects. 6.1. While the Constitution envisages the possibility of the governor acting at times in his discretion, no such possibility has been envisaged for the president. 2. After the 42nd Constitutional Amendment, 1976, ministerial advice has been made binding on the president, but no such provision has been made with respect to the governor. The Constitution makes it clear that if any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final and the validity of anything done by him cannot be called in question on the ground that he ought or ought not to have acted in his discretion. The governor has constitutional discretion in the following cases: 1. Reservation of a bill for the consideration of the president. 2. Recommendation for the imposition of the president's rule in the state. 3. While exercising his functions as the administrator of an adjoining union territory, in case of additional charge. 4. Determining the amount payable by the government of Assam, Meghalaya, Tripura and Mizoram to an autonomous tribal district council as royalty accruing from licenses for mineral exploration. 7. 5. Seeking information from the chief minister with regard to the administrative and legislative matters of the state. In addition to the above constitutional discretion, i.e., the express discretion mentioned in the Constitution, the governor, like the president, also has situational discretion, i.e., the hidden discretion derived from the exigencies of a prevailing political situation, in the following cases: 1. Appointment of chief minister when no party has a clear-cut majority in the state legislative assembly or when the chief minister in office dies suddenly and there is no obvious successor. 2. Dismissal of the council of ministers when it cannot prove the confidence of the state legislative assembly. 3. Dissolution of the state legislative assembly if the council of ministers has lost its majority. Moreover, the governor has certain special responsibilities to discharge. According to the directions issued by the president. In this regard, the governor, though has to consult the council of ministers led by the chief minister, acts finally on his discretion. They are as follows: 1. Maharashtra, establishment of separate development boards for Vidarbha and Marathwada. 2. Gujarat, establishment of separate development boards for Saurashtra and Kutch. 3. Nagaland, with respect to law and order in the state for so long as the internal disturbance in the Naga Hills Toensan area continues. 4. Assam, with respect to the administration of tribal areas. 5. Manipur, regarding the administration of the hill areas in the state. 6. Sikkim, for peace and for ensuring social and economic advancement of the different sections of the population. 7. Arunachal Pradesh, with respect to law and order in the state. 8. Karnataka, establishment of a separate development board for Hyderabad Karnataka Region 8. Thus, the Constitution has assigned a dual role to the office of a governor in the Indian federal system. He is the constitutional head of the state as well as the representative of the centre, i.e., President. Table 30.4 Articles related to Governor at a glance. Article No. Subject Matter 153. Governors of States 154. Executive Power of State 155. Appointment of Governor 156. Term of Office of Governor 157. Qualifications for appointment as Governor 158. Conditions of Governor's Office 159. Oath or affirmation by the Governor. 160 Discharge of the functions of the Governor in certain contingencies. 161. Power of the Governor to grant pardons and others. 162. Extent of executive power of State 163. Council of Ministers to aid and advise the Governor 164. Other provisions as to ministers like appointments, term, salaries, and others 165. Advocate General for the State 166. Conduct of business of the Government of a State 167. Duties of the Chief Minister regarding furnishing of information to the Governor, and so on 174. Sessions of the State Legislature, prorogation and dissolution 175. Right of the Governor to address and send messages to the House or Houses of State Legislature 176. Special address by the Governor 200. Assent to bills, I. Assent of the Governor to the bills passed by the State Legislature, 201. Bills reserved by the Governor for consideration of the President 213. Power of Governor to promulgate ordinances 217. Governor being consulted by the President in the matter of the appointments of the judges of the High Courts 233. Appointment of district judges by the Governor 234. Appointments of persons, other than district judges, to the judicial service of the state by the Governor. Notes and references 1. Constituent Assembly Debates, Volume 4, pp. 588607. 2 Governors, Emoluments, Allowances and Privileges, Act, 1982, as amended in 2008, by Act 1 of 2009, with effect from 1 January 2006. 3 Surya Narayan v. Union of India, 1982. 4 Solis or Abji, the Governor, Sage or Sabotier, Rowley Books, New Delhi, 1985, p. 25. 5 For the meanings of these legal terms, see, Pardoning Power of the President, under Chapter 17. 6 M.P. Jain, Indian Constitutional Law, Wadhwa, 4th ed., p. 186. 7 Paragraph 9, 2, of the 6th Schedule says, if any dispute arises as to the share of such royalties to be made over to a district council, it shall be referred to the Governor for determination, and the amount determined by the Governor in his discretion shall be deemed to be the amount payable to the district council, and the decision of the Governor shall be final. The 6th Schedule contains the provisions as to the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. 8. This provision was added by the 98th Constitutional Amendment Act of 2012. Chief Minister in the scheme of parliamentary system of government provided by the Constitution, the Governor is the nominal executive authority, de jure executive, and the Chief Minister is the real executive authority, de facto executive. In other words, the Governor is the head of the state while the Chief Minister is the head of the government. Thus the position of the Chief Minister at the state level is analogous to the position of Prime Minister at the I Centre. Appointment of Chief Minister. The Constitution does not contain any specific procedure for the selection and appointment of the Chief Minister. Article 164 only says that the Chief Minister shall be appointed by the Governor. However, this does not imply that the Governor is free to appoint anyone as the Chief Minister. In accordance with the convictions of the parliamentary system of government, the Governor has to appoint the leader of the majority party in the State Legislative Assembly as the Chief Minister. But, when no party has a clear majority in the Assembly, then the Governor may exercise his personal discretion in the selection and appointment of the Chief Minister. In such a situation, the Governor usually appoints the leader of the largest party or coalition in the Assembly as the Chief Minister and asks him to seek a vote of confidence in the House within a month. 1. The Governor may have to exercise his individual judgment in the selection and appointment of the Chief Minister when the Chief Minister in office dies suddenly and there is no obvious successor. However, on the death of a Chief Minister, the ruling party usually elects a new leader and the Governor has no choice but to appoint him as Chief Minister. The Constitution does not require that a person must prove his majority in the Legislative Assembly before he is appointed as the Chief Minister. The governor may first appoint him as the chief minister and then ask him to prove his majority in the legislative assembly within a reasonable period. This is what has been done in a number of cases too. A person who is not a member of the state legislature can be appointed as chief minister for 6 months, within which time he should be elected to the state legislature, failing which he ceases to be the chief minister. 3 According to the constitution, the chief minister may be a member of any of the 2 houses of a state legislature. Usually chief ministers have been selected from the lower house, legislative assembly, but, on a number of occasions, a member of the upper house, legislative council, has also been appointed as chief minister. 4 Oath, term and salary. Before the chief minister enters his office, the governor administers to him the oaths of office and secrecy. 5 In his oath of office, the chief minister swears, 1. To bear true faith and allegiance to the Constitution of India, 2. To uphold the sovereignty and integrity of India, 3. To faithfully and conscientiously discharge the duties of his office, and 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the chief minister swears that he will not directly or indirectly communicate or reveal to any person, any matter that is brought under his consideration or becomes known to him as a state minister, except as may be required for the due discharge of his duties as such minister. The term of the chief minister is not fixed and he holds office during the pleasure of the governor. However, this does not mean that the governor can dismiss him at any time. He cannot be dismissed by the governor as long as he enjoys the majority support in the legislative assembly. 6 But, if he loses the confidence of the assembly, he must resign or the governor can dismiss him. The salary and allowances of the chief minister are determined by the state legislature. In addition to the salary and allowances, which are payable to a member of the state legislature, he gets a sumptuary allowance, free accommodation, traveling allowance, medical facilities, etc. Powers and functions of chief minister. The powers and functions of the chief minister can be studied under the following heads. In relation to Council of Ministers, the chief minister enjoys the following powers as head of the State Council of Ministers. A. The governor appoints only those persons as ministers who are recommended by the chief minister. B. He allocates and reshuffles the portfolios among ministers. C. He can ask a minister to resign or advise the governor to dismiss him in case of difference of opinion. D. He presides over the meetings of the Council of Ministers and influences its decisions. E. He guides, directs, controls and coordinates the activities of all the ministers. F. He can bring about the collapse of the Council of Ministers by resigning from office. Since the chief minister is the head of the Council of Ministers, his resignation or death automatically dissolves the Council of Ministers. The resignation or death of any other minister, on the other hand, merely creates a vacancy, which the chief minister may or may not like to fill. In relation to the governor, the chief minister enjoys the following powers in relation to the governor. A. He is the principal channel of communication between the governor and the Council of Ministers. 7 It is the duty of the chief minister, I, to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. 2. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for, and 3. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. B. He advises the governor with regard to the appointment of important officials like Advocate General, Chairman and members of the State Public Service Commission, State Election Commissioner, and so on. In relation to state legislature, the chief minister enjoys the following powers as the leader of the House. A. He advises the governor with regard to the summoning and proroguing of the sessions of the state legislature. B. He can recommend the dissolution of the legislative assembly to the governor at any time. C. He announces the government policies on the floor of the House. other powers and functions. In addition, the Chief Minister also performs the following functions. A. He is the chairman of the State Planning Board. B. He acts as the vice chairman of the concerned zonal council by rotation, holding office for a period of 1 year at a time. 8. C. He is a member of the Interstate Council and the National Development Council, both headed by the Prime Minister.
D. He is the chief spokesman of the state government.
E. He is the crisis manager-in-chief at the political level during emergencies. F. As a leader of the state, he meets various sections of the people and receives memoranda from them regarding their problems, and so on. G. He is the political head of the services. Thus, he plays a very significant and highly crucial role in the state administration. However, the discretionary powers enjoyed by the governor reduces to some extent the power, authority, influence, prestige and role of the chief minister in the state administration. Relationship with the governor. The following provisions of the Constitution deal with the relationship between the governor and the chief minister. 1. Article 163, there shall be a council of ministers with the chief minister as the head to aid and advise the governor on the exercise of his functions, except in so far as he is required to exercise his functions or any of them in his discretion. 2. Article 164, the chief minister shall be appointed by the governor and other ministers shall be appointed by the governor on the advice of the chief minister. B. The ministers shall hold office during the pleasure of the governor, and C. The council of ministers shall be collectively responsible to the legislative assembly of the state. 3. Article 167, it shall be the duty of the chief minister, A. to communicate to the governor of the state all decisions of the council of ministers relating to the administration of the affairs of the state and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for, and C. If the governor so requires, to submit for the consideration of the council of ministers any matter on which a decision has been taken by
a minister but which has not been considered by the
council. Table 31.1 Articles related to Chief Minister at a glance. Article No. Subject Matter 163. Council of Ministers to aid and advise Governor 164. Other provisions as to Ministers 166. Conduct of business of the government of a state 167. Duties
of Chief Minister as
respects the furnishing of information to Governor, etc. Notes and references. 1. For example, the governors of Tamil Nadu, 1951, Rajasthan, 1967, and Haryana, 1982, invited the leader of the largest party to form the ministry. The governors of Punjab, 1967, West Bengal, 1970, and Maharashtra, 1978, on the other hand, invited the leader of the coalition to form the ministry. 2. For example, the governor of J&K, Jagmohan, appointed G.M. Shah as the chief minister and asked him to prove his majority on the floor of the house within a month. He proved his majority. Similarly, the governor of Andhra Pradesh, Ram Lal, appointed Bhaskar Rao as the chief minister and gave him 1 month to prove his majority on the floor of the house. However, he could not prove his majority. 3. For example, Bansilal and S.B. Chavan were appointed as chief ministers of Haryana and Maharashtra respectively, even though they were not members of the state legislature. Subsequently, they were elected to the state legislature. 4. For example, C. Rajgopalachari in Madras, now Tamil Nadu, in 1952, Morarji Desai in Bombay, now Maharashtra, in 1952, C.B. Gupta in UP in 1960 and B.P. Mandal in Bihar in 1968 were appointed as chief ministers, while they were members of the state legislative council. 5. The form of oath of office and secrecy for the chief minister is similar to
that for any state minister.
See Chapter 32. 6. This was ruled by the Supreme Court in S.R. Bommai v. Union of India, 1994. However, there have been many violations of this rule, whereby the governors have dismissed the chief ministers without giving them an opportunity to prove their majority in the Legislative Assembly. 7. Article 167 specifically deals with this function of the chief minister. 8. Union Home Minister is the chairman of all the zonal councils.
State Council of Ministers
as the Constitution of India provides for a parliamentary system of government in the states on the union pattern. The Council of Ministers, headed by the Chief Minister, is the real executive authority in the politico-administrative system of a state. The Council of Ministers in the states is constituted and function in the same way as the Council of Ministers at the centre. The principles of parliamentary system of government are not detailed in the Constitution, but two articles, 163 and 164, deal with them in a broad, sketchy and general manner. Article 163 deals with the status of the Council of Ministers, while Article 164 deals with the appointment, tenure, responsibility, qualifications, oath and salaries and allowances of the ministers. Constitutional provisions. Article 163, Council of Ministers to aid and advise Governor. 1. There shall be a Council of Ministers with the Chief Minister as the head to aid and advise the Governor in the exercise of his functions, except in so far as he is required to exercise his functions in his discretion.
2.
If any question arises whether a matter falls within the Governor's discretion or not, decision of the Governor shall be final, and the validity of anything done by the Governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. 3. The advice tendered by ministers to the Governor shall not be inquired into in any court. Article 164, Other provisions as to ministers. 1. The Chief Minister shall be appointed by the Governor and the other ministers shall be appointed by the Governor on the advice of the Chief Minister. However, in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be a minister in charge of tribal welfare who may in addition be in charge of the welfare of the scheduled castes and backward classes or any other work. The state of Bihar was excluded from this provision by the 94th Amendment Act of 2006. 2. The total number of ministers, including the Chief Minister, in the Council of Ministers in a state shall not exceed 15% of the total strength of the Legislative Assembly of that state. But, the number of ministers, including the Chief Minister, in a state shall not be less than 12. This provision was added by the 91st Amendment Act of 2003. 3. A member of either House of State Legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. This provision was also added by the 91st Amendment Act of 2003. 4. The ministers shall hold office during the pleasure of the Governor. 5. The Council of Ministers shall be collectively responsible to the State Legislative Assembly. 6. The Governor shall administer the oaths of office and secrecy to a minister. 7. A minister who is not a member of the State Legislature for any period of 6 consecutive months shall cease to be a minister. 8. The salaries and allowances of ministers shall be determined by the State Legislature. Article 166. Conduct of business of the government of a state. 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor. Further, the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. 3. The governor shall make rules for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is required to act in his discretion. Article 167. Duties of Chief Minister. It shall be the duty of the Chief Minister of each state. 1. To communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. 2. to furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. 3. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Article 177, Rights of Ministers. As respects the Houses, every minister shall have the right to speak and take part in the proceedings of the Assembly, and also the Council where it exists, and any committee of the state legislature of which he may be named a member. But he shall not be entitled to vote. Nature of advice by ministers. Article 163 provides for a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions except the discretionary ones. If any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final and the validity of anything done by him cannot be called in question on the ground that he ought or ought not to have acted in his discretion. Further, the nature of advice tendered by ministers to the governor cannot be enquired by any court. This provision emphasizes the intimate and the confidential relationship between the governor and the ministers. In 1971, the Supreme Court ruled that a council of ministers must always exist to advise the governor, even after the dissolution of the state legislative assembly or resignation of a council of ministers. Hence, the existing ministry may continue in the office until its successor assumes charge. Again in 1974, the court clarified that except in spheres where the governor is to act in his discretion, the governor has to act on the aid and advice of the Council of Ministers in the exercise of his powers and functions. He is not required to act personally without the aid and advice of the Council of Ministers or against the aid and advice of the Council of Ministers. Wherever the Constitution requires the satisfaction of the governor, the satisfaction is not the personal satisfaction of the governor but it is the satisfaction of the Council of Ministers. Appointment of ministers. The chief minister is appointed by the governor. The other ministers are appointed by the governor on the advice of the chief minister. This means that the governor can appoint only those persons as ministers who are recommended by the chief minister. But there should be a tribal welfare minister in Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha. 1. Originally, this provision was applicable to Bihar, Madhya Pradesh and Odisha. The 94th Amendment Act of 2006 freed Bihar from the obligation of having a tribal welfare minister as there are no scheduled areas in Bihar now and the fraction of population of the scheduled tribes is very small. The same amendment also extended the above provision to the newly formed states of Chhattisgarh and Jharkhand. Usually, the members of the state legislature, either the Legislative Assembly or the Legislative Council, are appointed as ministers. A person who is not a member of either house of the state legislature can also be appointed as a minister. But, within 6 months, he must become a member, either by election or by nomination, of either house of the state legislature, otherwise, he ceases to be a minister. A minister who is a member of one house of the state legislature has the right to speak and to take part in the proceedings of the other house. But, he can vote only in the house of which he is a member. Oath and salary of ministers. Before a minister enters upon his office, the governor administers to him the oaths of office and secrecy. In his oath of office, the minister swears, 1. To bear true faith and allegiance to the Constitution of India, 2. To uphold the sovereignty and integrity of India, 3. To faithfully and conscientiously discharge the duties of his office, and 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the minister swears that he will not directly or indirectly communicate or reveal to any person, any matter that is brought under his consideration or becomes known to him as a state minister except as may be required for the due discharge of his duties as such minister. The salaries and allowances of ministers are determined by the state legislature from time to time. A minister gets the salary and allowances which are payable to a member of the state legislature. Additionally, he gets a sumptuary allowance, according to his rank, free accommodation, travelling allowance, medical facilities, etc. Responsibility of ministers, collective responsibility.
The
The
fundamental
principle underlying the working of parliamentary system of government is the principle of collective responsibility. Article 164 clearly states that the Council of Ministers is collectively responsible to the Legislative Assembly of the state. This means that all the ministers own joint responsibility to the Legislative Assembly for all their acts of omission and commission. They work as a team and swim or sink together. When the Legislative Assembly passes a no-confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Legislative Council too. Alternatively, the Council of Ministers can advise the governor to dissolve the Legislative Assembly on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The governor may not oblige the Council of Ministers which has lost the confidence of the Legislative Assembly. The principle of collective responsibility also means that the cabinet decisions bind all cabinet ministers and other ministers, even if they differed in the cabinet meeting. It is the duty of every minister to stand by the cabinet decisions and support them both within and outside the state legislature. If any minister disagrees with the cabinet decision and is not prepared to defend it, he must resign. Several ministers have resigned in the past owing to their differences with the cabinet. Individual responsibility. Article 164 also contains the principle of individual responsibility. It states that the ministers hold office during the pleasure of the governor. This means that the governor can remove a minister at a time when the Council of Ministers enjoys the confidence of the Legislative Assembly. But the governor can remove a minister only on the advice of the chief minister. In case of difference of opinion or dissatisfaction with the performance of a minister, the chief minister can ask him to resign or advise the governor to dismiss him. By exercising this power, the chief minister can ensure the realization of the rule of collective responsibility. No legal responsibility as at the center. There is no provision in the constitution for the system of
legal responsibility
of the minister in the states. It is not required that an order of the governor for a public act should be countersigned by a minister. Moreover, the courts are barred from enquiring into the nature of advice rendered by the ministers to the governor. Composition of the Council of Ministers. The Constitution does not specify the size of the State Council of Ministers or the ranking of ministers. They are determined by the Chief Minister according to the exigencies of the time and requirements of the situation.
Like at
the center, in the states too, the Council of Ministers consists of three categories of ministers, namely, cabinet ministers, ministers of state, and deputy ministers. The difference between them lies in their respective ranks, emoluments, and political importance. At the top of all these ministers stands the chief minister, supreme governing authority in the state. The cabinet ministers head the important departments of the state government like home, education, finance, agriculture and so forth. 3. They are members of the cabinet, attend its meetings and play an important role in deciding policies. Thus, their responsibilities extend over the entire gamut of state government. The ministers of state can either be given independent charge of departments or can be attached to cabinet ministers. However, they are not members of the cabinet and do not attend the cabinet meetings unless specially invited when something related to their departments are considered by the cabinet. Next in rank are the deputy ministers. They are not given independent charge of departments. They are attached to the cabinet ministers and assist them in their administrative, political and parliamentary duties. They are not members of the cabinet and do not attend cabinet meetings. At times, the Council of Ministers may also include a deputy chief minister. The deputy chief ministers are appointed mostly for local political reasons. Cabinet. A smaller body called cabinet is the nucleus of the Council of Ministers. It
consists of only
the cabinet ministers. It is the
center
center
of authority in the
state government. It performs the following role. 1. It is the highest decision-making authority in the politico-administrative system of a state. 2. It is the chief policy formulating body of the state government. 3. It is the supreme executive authority of the state government. 4. It is the chief coordinator of state administration. 5. It is an advisory body to the governor. 6. It is the chief crisis manager and thus deals with all emergency situations. 7. It deals with all major legislative and financial matters. 8. It exercises control over higher appointments like constitutional authorities and senior secretariat administrators. Cabinet committees. The cabinet works through various committees called cabinet committees. They are of two types, standing and ad hoc. The former are of a permanent nature while the latter are of a temporary nature. They are set up by the chief minister according to the exigencies of the time and requirements of the situation. Hence, their number, nomenclature and composition varies from time to time. They not only sort out issues and formulate proposals for the consideration of the cabinet but also take decisions. However, the cabinet can review their decisions. Table 32.1 Articles related to State Council of Ministers at a glance. Article No. Subject Matter 163. Council of Ministers to aid and advise Governor 164. Other provisions as to Ministers 166. Conduct of business of the government of a state. Duties of Chief Minister as respects the furnishing of information.
167
to Governor, etc. Notes and references. 1. They may, in addition, be in charge of the welfare of the SCs and BCs or any other work. 2. Each minister need not resign separately. The resignation of the Chief Minister amounts to the resignation of the entire Council of Ministers. 3. The term, ministry, or ministries, is used only in the centre and not in the states. In other words, the state government is divided into departments and not ministries.
State legislature.
The state legislature occupies a preeminent and central position in the political system of a state. T. Articles 168 to 212 in Part 6 of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers and so on of the state legislature. Though these are similar to that of Parliament, there are some differences as well. Organization of state legislature. There is no uniformity in the organization of state legislatures. Most of the states have an unicameral system, while others have a bicameral system. At present, 2016, only 7 states have 2 houses, bicameral. These are Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra, Karnataka and Jammu and Kashmir. 1. The Tamil Nadu Legislative Council Act, 2010 has not come into force. The Legislative Council in Andhra Pradesh was revived by the Andhra Pradesh Legislative Council Act, 2005. The 7th Amendment Act of 1956 provided for a Legislative Council in Madhya Pradesh. However, a notification to this effect has to be made by the President. So far, no such notification has been made. Hence, Madhya Pradesh continues to have 1 house only. The 22 states have unicameral system. Here, the state legislature
consists of
the governor and the legislative assembly. In the states having bicameral system, the state legislature consists of the governor, the legislative council and the legislative assembly. The legislative council, Vidhan Parishad, is the upper house, second chamber or house of elders, while the legislative assembly, Vidhan Sabha, is the lower house, first chamber or popular house. The constitution provides for the abolition or creation of legislative councils in states. Accordingly, the parliament can abolish a legislative council, where it already exists, or create it, where it does not exist, if the legislative assembly of the concerned state passes a resolution to that effect. Such a specific resolution must be passed by the state assembly by a special majority, that is, a majority of the total membership of the assembly and a majority of not less than 2/3 of the members of the assembly present and voting. This Act of Parliament is not to be deemed as an amendment of the Constitution for the purposes of Article 368 and is passed like an ordinary piece of legislation, i.e., by simple majority. The idea of having a second chamber in the states was criticized in the Constituent Assembly on the ground that it was not representative of the people, that it delayed legislative process and that it was an expensive institution too. Consequently, the provision was made for the abolition or creation of a legislative council to enable a state to have a second chamber or not according to its own willingness and financial strength. For example, Andhra Pradesh got the Legislative Council created in 1957 and got the same abolished in 1985. The Legislative Council in Andhra Pradesh was again revived in 2007, after the enactment of the Andhra Pradesh Legislative Council Act, 2005. The Legislative Council of Tamil Nadu had been abolished in 1986 and that of Punjab and West Bengal in 1969. In 2010, the Legislative Assembly of Tamil Nadu passed a resolution for the revival of the Legislative Council in the state. Accordingly, the Parliament enacted the Tamil Nadu Legislative Council Act, 2010, which provided for the creation of Legislative Council in the state. However, before this act was enforced, the Legislative Assembly of Tamil Nadu passed another resolution in 2011 seeking the abolition of the proposed Legislative Council. Composition of two houses. Composition of assembly strength. The Legislative Assembly consists of representatives directly elected by the people on the basis of universal adult franchise. Its maximum strength is fixed at 500 and minimum strength at 60. It means that its strength varies from 60 to 500 depending on the population size of the state 3. However, in case of Arunachal Pradesh, Sikkim and Goa, the minimum number is fixed at 30, and in case of Mizoram and Nagaland, it is 40 and 46 respectively. Further, some members of the legislative assemblies in Sikkim and Nagaland are also elected indirectly. Nominated member. The governor can nominate one member from the Anglo-Indian community, if the community is not adequately represented in the assembly. For originally, this provision was to operate for 10 years, i.e., up to 1960. But this duration has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this is to last until 2020. Territorial constituencies. For the purpose of holding direct elections to the assembly, each state is divided into territorial constituencies. The demarcation of these constituencies is done in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In other words, the Constitution ensures that there is uniformity of representation between different constituencies in the state. The expression, population, means the population as ascertained at the last preceding census of which the relevant figures have been published. Readjustment after each census. After each census, a readjustment is to be made in the a. total number of seats in the assembly of each state and b. the division of each state into territorial constituencies. The Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, Parliament has enacted the Delimitation Commission Acts in 1952, 1962, 1972 and 2002 for this purpose.
The
42nd Amendment Act of 1976 had frozen total number of seats in the assembly of each state and the division of such states into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment has been extended for another years, i.e., up to year 2026, by the 84th Amendment Act of 2001 with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in a state on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, This can be done without altering the total number of seats in the assembly of each state. Reservation of seats for SCs and STs. The Constitution provided for the reservation of seats for scheduled castes and scheduled tribes in the assembly of each state on the basis of population ratios. 5 Originally, this reservation was to operate for 10 years, i.e., up to 1960. But this duration has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this reservation is to last until 2020. Composition of council strength. Unlike the members of the Legislative Assembly, the members of the Legislative Council are indirectly elected. The maximum strength of the council is fixed at 1/3 of the total strength of the assembly and the minimum strength is fixed at 406. It means that the size of the council depends on the size of the assembly of the concerned state. This is done to ensure the predominance of the directly elected House, Assembly, in the legislative affairs of the state. Though the Constitution has fixed the maximum and the minimum limits, the actual strength of a council is fixed by Parliament. 7. Manner of election of the total number of members of a legislative council.
One-third
are elected by the members of local bodies in the state like municipalities, district boards, etc. 2. 1/12 are elected by graduates of 3 years standing and residing within the state. 3. 1/12 are elected by teachers of 3 years standing in the state, not lower in standard than secondary school. 4. 1/3 are elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly, and 5. The remainder are nominated by the governor from amongst persons who have a special knowledge or practical experience of literature, science, art, cooperative movement and social service. Thus, 5/6 of the total number of members of a legislative council are indirectly elected and 1/6 are nominated by the governor. The members are elected in accordance with the system of proportional representation by means of a single transferable vote. The bona fides or propriety of the governor's nomination in any case cannot be challenged in the courts. This scheme of composition of a legislative council as laid down in the Constitution is tentative and not final. The Parliament is authorized to modify or replace the same. However, it has not enacted any such law so far. Duration of 2 houses. Duration of assembly. Like the Lok Sabha, the Legislative Assembly is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections. 8. The expiration of the period of 5 years operates as automatic dissolution of the Assembly. However, the governor is authorized to dissolve the Assembly at any time, i.e., even before the completion of 5 years, to pave the way for fresh elections. Further, the term of the Assembly can be extended during the period of national emergency by a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. This means that the Assembly should be re-elected within 6 months after the revocation of emergency. Duration of council. Like the Rajya Sabha, the Legislative Council is a continuing chamber, that is, it is a permanent body and is not subject to dissolution. But, 1/3 of its members retire on the expiration of every second year. So, a member continues as such for 6 years. The vacant seats are filled up by fresh elections and nominations, by governor, at the beginning of every 3rd year. The retiring members are also eligible for re-election and renomination any number of times. Membership of State Legislature. 1. Qualifications. The Constitution lays down the following qualifications for a person to be chosen a member of the State Legislature. A. He must be a citizen of India. B. He must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In his oath or affirmation, he swears, I, to bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. C. He must be not less than 30 years of age in the case of the Legislative Council and not less than 25 years of age in the case of the Legislative Assembly. D. He must possess other qualifications prescribed by Parliament. Accordingly, the Parliament has laid down the following additional qualifications in the Representation of People Act, 1951. A person to be elected to the Legislative Council must be an elector for an assembly constituency in the concerned state, and to be qualified for the governor's nomination, he must be a resident in the concerned state. B. A person to be elected to the Legislative Assembly must be an elector for an assembly constituency in the concerned state.
C. He must be a member of
a scheduled caste or scheduled tribe if he wants to contest a seat reserved for them. However, a member of scheduled castes or scheduled tribes can also contest a seat not reserved for them. 2 disqualifications under the Constitution. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state. If he holds any office of profit under the union or state government, except that of a minister or any other office exempted by state legislature. 9. B. If he is of unsound mind and stands so declared by a court. C. If he is an undischarged insolvent. D. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. And E. If he is so disqualified under any law made by Parliament. Accordingly, the Parliament has prescribed a number of additional disqualifications in the Representation of People Act, 1951. These are similar to those for Parliament. These are mentioned here. 1. He must not have been found guilty of certain election offences or corrupt practices in the elections. 2. He must not have been convicted for any offence resulting in imprisonment for 2 or more years. But the detention of a person under a preventive detention law is not a disqualification. 3. He must not have failed to lodge an account of his election expenses within the time. 4. He must not have any interest in government contracts, works or services. 5. He must not be a director or managing agent nor hold an office of profit in a corporation in which the government has at least 25% share. 6. He must not have been dismissed from government service for corruption or disloyalty to the state. 7. He must not have been convicted for promoting enmity between different groups or for the offence of bribery.
8. He must not have been punished for
preaching and practicing social crimes such as untouchability, dowry and sati. On the question whether a member has become subject to any of the above disqualifications, the governor's decision is final. However, he should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified for being a member of either House of State Legislature if he is so disqualified on the ground of defection under the provisions of the 10th Schedule.
The question of
disqualification under the 10th Schedule is decided by the Chairman, in the case of Legislative Council, and Speaker, in the case of Legislative Assembly, and not by the Governor. In 1992, the Supreme Court ruled that the decision of Chairman Speaker in this regard is subject to judicial review. 10. 3. Oath or affirmation. Every member of either House of State Legislature, before taking his seat in the House, has to make and subscribe an oath or affirmation before the Governor or some person appointed by him for this purpose. In this oath, a member of the State Legislature swears a. To bear true faith and allegiance to the Constitution of India, b. To uphold the sovereignty and integrity of India, and c. To faithfully discharge the duty of his office. Unless a member takes the oath, he cannot vote and participate in the proceedings of the House and does not become eligible to the privileges and immunities of the state legislature. A person is liable to a penalty of 500 for each day he sits or votes as a member in a House, a. Before taking and subscribing the prescribed oath or affirmation, or b. When he knows that he is not qualified or that he is disqualified for its membership, or c. When he knows that he is prohibited from sitting or voting in the House by
virtue of any law made by
Parliament or the state legislature. Members of a state legislature are entitled to receive such salaries and allowances as may from time to time be determined by the state legislature. For vacation of seats in the following cases, A member of the state legislature vacates his seat. A. Double membership. A person cannot be a member of both houses of state legislature at one and the same time. If a person is elected to both the houses, his seat in one of the houses falls vacant as per the provisions of a law made by the state legislature. B. Disqualification. If a member of the state legislature becomes subject to any of the disqualifications, his seat becomes vacant. C. Resignation. A member may resign his seat by writing to the chairman of Legislative Council or Speaker of Legislative Assembly, as the case may be. The seat falls vacant when the resignation is accepted. 11. D. Absence. A house of the state legislature can declare the seat of a member vacant if he absents himself from all its meeting for a period of 60 days without its permission. E. Other cases. A member has to vacate his seat in the either house of state legislature. I. If his election is declared void by the court. 2. If he is expelled by the house. 3. If he is elected to the office of president or office of vice president. And 4. If he is appointed to the office of governor of a state. Presiding officers of state legislature. Each house of state legislature has its own presiding officer. There is a speaker and a deputy speaker for the legislative assembly and chairman and a deputy chairman for the legislative council. A panel of chairmen for the assembly and a panel of vice chairmen for the council is also appointed. Speaker of assembly.
The speaker is elected
by the assembly itself from amongst its members. Usually,
the speaker
remains in office during the life of the assembly. However, he vacates his office earlier in any of the following three cases: 1. If he ceases to be a member of the assembly; 2. If he resigns by writing to the deputy speaker; and 3. If he is removed by a resolution passed by a majority of all the then members of the assembly. Such a resolution can be moved only after giving 14 days advance notice. The speaker has the following powers and duties. 1. He maintains order and decorum in the assembly for conducting its business and regulating its proceedings. This is his primary responsibility and he has final power in this regard. 2. He is the final interpreter of the provisions of a. The Constitution of India, b. The rules of procedure and conduct of business of assembly, and c. The legislative precedents within the assembly. 3. He adjourns the assembly or suspends the meeting in the absence of a quorum. 4. He does not vote in the first instance, but he can exercise a casting vote in the case of a tie. 5. He can allow a secret sitting of the House at the request of the leader of the House. 6. He decides whether a bill is a money bill or not, and his decision on this question is final. 7. He decides the questions of disqualification of a member of the assembly, arising on the ground of defection under the provisions of the 10th schedule. 8. He appoints the chairman of all the committees of the assembly and supervises their functioning. He himself is the chairman of the Business Advisory Committee, the Rules Committee and the General Purpose Committee. Deputy Speaker of Assembly. Like the Speaker, the Deputy Speaker is also elected by the Assembly itself from amongst its members. He is elected after the election of the Speaker has
taken place. Like the
Speaker, the Deputy Speaker remains in office usually during the life of the Assembly. However, he also vacates his office earlier in any of the following three cases: 1. If he ceases to be a member of the Assembly; 2. If he resigns by writing to the Speaker; and 3. If he is removed by a resolution passed by a majority of all the then members of the Assembly. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. He also acts as the Speaker when the latter is absent from the sitting of Assembly. In both the cases, he has all the powers of the Speaker. The Speaker nominates from amongst the members a panel of chairmen. Any one of them can preside over the Assembly in the absence of the Speaker or the Deputy Speaker. He has the same powers as the Speaker when so presiding. He holds office until a new panel of chairmen is nominated. Chairman of Council. The chairman is elected by the Council itself from amongst its members. The chairman vacates his office in any of the following three cases: 1. If he ceases to be a member of the Council; 2 if he resigns by writing to the deputy chairman, and 3 if he is removed by a resolution passed by a majority of all the then members of the council. Such a resolution can be moved only after giving 14 days advance notice. As a presiding officer, the powers and functions of the chairman in the council are similar to those of the speaker in the assembly. However, the speaker has one special power which is not enjoyed by the chairman. The speaker decides whether a bill is a money bill or not, and his decision on this question is final. As in the case of the speaker, the salaries and allowances of the chairman are also fixed by the state legislature. They are charged on the consolidated fund of the state and thus are not subject to the annual vote of the state. Legislature. Deputy chairman of council. Like the chairman, the deputy chairman is also elected by the council itself from amongst its members. The deputy chairman vacates his office in any of the following 3 cases: 1 if he ceases to be a member of the council, 2 if he resigns by writing to the chairman, and 3 if he is removed by a resolution passed by a majority of all the then members of the council. Such a resolution can be moved only after giving 14 days advance notice. The deputy chairman performs the duties of the chairman's office when it is vacant. He also acts as the chairman when the latter is absent from the sitting of the council. In both the cases, he has all the powers of the chairman. The chairman nominates from amongst the members a panel of vice chairmen. Any one of them can preside over the council in the absence of the chairman or the deputy chairman. He has the same powers as the chairman when so presiding. He holds office until a new panel of vice chairmen is nominated. Sessions of state legislature summoning the governor from time to time summons each house of state legislature to meet. The maximum gap between the 2 sessions of state legislature cannot be more than 6 months, i.e., the state legislature should meet at least twice a year. A session of the state legislature consists of many sittings. Adjournment. An adjournment suspends the work in a sitting for a specified time, which may be hours, days or weeks. Adjournment sine die means terminating a sitting of the state legislature for an indefinite period. The power of the adjournment as well as adjournment sine die lies with the presiding officer of the House. Prorogation. The presiding officer, speaker or chairman, declares the House adjourned sine die when the business of the session is completed. Within the next few days, the governor issues a notification for prorogation of the session. However, the governor can also prorogue the House which is in session. Unlike an adjournment, a prorogation terminates a session of the House. Dissolution. The Legislative Council, being a permanent House, is not subject to dissolution. Only the Legislative Assembly is subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing House, and a new House is constituted after the general elections are held. The position with respect to lapsing of bills on the dissolution of the Assembly is mentioned below. 1. A bill pending in the Assembly lapses, whether originating in the Assembly or transmitted to it by the Council. 2. A bill passed by the Assembly but pending in the Council lapses. 3. A bill pending in the Council but not passed by the Assembly does not lapse. 4. A bill passed by the Assembly, in a unicameral state, or passed by both the Houses, in a bicameral state, but pending assent of the Governor or the President does not lapse. 5. A bill passed by the Assembly, in a unicameral state, or passed by both the Houses, in a bicameral state, but returned by the President for reconsideration of House, does not lapse. Quorum. Quorum is the minimum number of members required to be present in the
House before
it can transact any business. It is 10 members or 1/10 of the total number of members of the House, including the presiding officer, whichever is greater. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House. All matters at any sitting of either House are decided by a majority of votes of the members present and voting excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution, like removal of the Speaker of the Assembly, removal of the Chairman of the Council and so on, require special majority, not ordinary majority. The presiding officer, i.e., Speaker in the case of assembly or chairman in the case of council or the person acting as such, does not vote in the first instance, but exercises the casting vote in the case of an equality of votes. Language in state legislature. The Constitution has declared the official language, of the state or Hindi or English, to be the languages for transacting business in the state legislature. However, the presiding officer can permit a member to address the House in his mother tongue. The state legislature is authorized to decide whether to continue or discontinue English as a floor language after the completion of 15 years from the commencement of the Constitution, i.e., from 1965. In case of Himachal Pradesh, Manipur, Meghalaya and Tripura, this time limit is 25 years, and that of Arunachal Pradesh, Goa and Mizoram, it is 40 years. Rights of ministers and advocate general. In addition to the members of a house, every minister and the advocate general of the state have the right to speak and take part in the proceedings of either house or any of its committees of which he is named a member, without being entitled to vote. There are two reasons underlying this constitutional provision.
1. A
One, a
minister,
minister can participate in the proceedings of a house, of which he is not a member. 2. A minciter, who is not a member of either house, can participate in the proceedings of both the houses. 12. Legislative procedure in state legislature. Ordinary bills. Bill in the originating house. An ordinary bill can originate in either house of the state legislature, in case of a bicameral legislature. Such a bill can be introduced either by a minister or by a new member. The bill passes through 3 stages in the originating house, viz. 1. First reading, 2. Second reading, and 3. Third reading. After the bill is passed by the originating house, it is transmitted to the second house for consideration and passage. A bill is deemed to have been passed by the state legislature only when both the houses have agreed to it, either with or without amendments. In case of a unicameral legislature, a bill passed by the Legislative Assembly is sent directly to the governor for his assent. Bill in the second house. In the second house also, the bill passes through all the 3 stages, that is, first reading, second reading and third reading. When a bill is passed by the Legislative Assembly and transmitted to the Legislative Council, the latter has 4 alternatives before it. 1. It may pass the bill as sent by the Assembly, i.e., without amendments. 2. It may pass the bill with amendments and return it to the Assembly for reconsideration. 3. It may reject the bill altogether. And 4. It may not take any action and thus keep the bill pending. If the Council passes the bill without amendments or the Assembly accepts the amendments suggested by the Council, the bill is deemed to have been
passed by both
the houses, and the same is sent to the governor for his assent. On the other hand, if the Assembly rejects the amendments suggested by the Council, or the Council rejects the bill altogether, or the Council does not take any action for 3 months, then the Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or passes the bill with amendments not acceptable to the Assembly, or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the houses in the form in which it was passed by the Assembly for the second time. Therefore, the ultimate power of passing an ordinary bill is vested in the Assembly. At the most, the Council can detain or delay the bill for a period of 4 months, 3 months in the first instance and 1 month in the second instance. The Constitution does not provide for the mechanism of joint sitting of both the houses to resolve the disagreement between the 2 houses over a bill. On the other hand, there is a provision for joint sitting of the Lok Sabha and the Rajya Sabha to resolve a disagreement between the 2 over an ordinary bill. Moreover, when a bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. Thus, the Council has been given much lesser significance, position and authority than that of the Rajya Sabha at the centre. Assent of the governor. Every bill, after it is passed by the Assembly or by both the houses in case of a bicameral legislature, is presented to the governor for his assent. There are 4 alternatives before the governor. 1. He may give his assent to the bill. 2. He may withhold his assent to the bill. 3. He may return the bill for reconsideration of the House or Houses, and 4. He may reserve the bill for the consideration of the President. If the Governor gives his assent to the bill becomes an act and is placed on the statute book. If the Governor withholds his assent to the bill ends and does not become an act. If the Governor returns the bill for reconsideration and if the bill is passed by the House or both the Houses again, with or without amendments, and presented to the Governor for his assent, the Governor must give his assent to the bill. Thus, the Governor enjoys only a suspensive veto. The position is same at the central level also. 13. Assent of the President. When a bill is reserved by the Governor for the consideration of the President may either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the House or Houses of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within a period of 6 months.
The bill is
presented again to the presidential assent after it is passed by the House or Houses with or without amendments. It is not mentioned in the Constitution whether it is obligatory on the part of the President to give his assent to such a bill or not. Money bills. The Constitution lays down a special procedure for the passing of money bills in the state legislature. This is as follows. A money bill cannot be introduced in the Legislative Council. It can be introduced in the Legislative Assembly only, and that too on the recommendation of the Governor. Every such bill is considered to be a government bill and can be introduced only by a minister. After a money bill is passed by the Legislative Assembly, it is transmitted to the Legislative Council for its consideration. The Legislative Council has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make recommendations and must return the bill to the Legislative Assembly within 14 days. The Legislative Assembly can either accept or reject all or any of the recommendations of the Legislative Council. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the Houses in the modified form. If the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the Houses in the form originally passed by the Legislative Assembly without any change. If the Legislative Council does not return the bill to the Legislative Assembly within 14 days, the bill is deemed to have been passed by both Houses at the expiry of the said period in the form originally passed by the Legislative Assembly. Thus, the Legislative Assembly has more powers than Legislative Council with regard to a money bill. At the most, the Legislative Council can detain or delay a money bill for a period of 14 days. Finally, when a money bill is presented to the Governor, he may either give his assent, withhold his assent or reserve the bill for presidential assent but cannot return the bill for reconsideration of the state legislature. Normally, the Governor gives his assent to a money bill as it is introduced in the state legislature with his prior permission. When a money bill is reserved for consideration of the President may either give his assent to the bill or withhold his assent to the bill but cannot return the bill for reconsideration of the state legislature. Table 33.1 Comparing legislative procedure in the Parliament and State Legislature. Parliament State Legislature A. With regard to ordinary bills. 1. It can be introduced. 1. It can be introduced in either house of the state in either house of the legislature. Parliament. 2. It can be introduced either by a minister or by a private member. 2. It can be introduced either by a minister or by private member. 3. It passes through first reading, second reading and third reading in the originating house. 3. It passes through first reading, second reading and third reading in the originating house. 4. It is deemed to have been passed by the Parliament only when both the Houses have agreed to it, either 4. It is deemed to have been passed by the state legislature only when both the Houses have agreed to it, either with or without amendments.
With or without
amendments. 5. A deadlock between the two houses takes place when the second house, after receiving a bill passed by the first house, rejects the bill or proposes amendments that are not acceptable to the first house or does not pass the bill within 6 months. 5. A deadlock between the two houses takes place when the Legislative Council, after receiving a bill passed by the Legislative Assembly, rejects the bill or proposes amendments that are not acceptable to the Legislative Assembly or does not pass the bill within 3 months. 6. The Constitution provides for the mechanism of joint sitting of two houses of the Parliament to resolve a deadlock between them over the passage of a bill. 6. The Constitution does not provide for the mechanism of joint sitting of two houses of the state legislature to resolve a deadlock between them over the passage of a bill. 7. The Legislative Assembly can override the 7. The Lok Sabha Legislative Council by passing the bill for the cannot override the second time and not vice versa. When a bill is Rajya Sabha bypassed by the Assembly for the second time and passing the bill for the transmitted to the Legislative Council, if the second time and vice Legislative Council rejects the bill again, or versa. A joint sitting is proposes amendments that are not acceptable to the only way to the Legislative Assembly, or does not pass the bill resolve a deadlock within 1 month, then the bill is deemed to have between the two been passed by both the houses in the form in houses, which it was passed by the Legislative Assembly for the second time.
8. The
The
mechanism
mechanism
of joint
sitting for resolving a deadlock applies to a bill whether originating in the Lok Sabha or the Rajya Sabha. If a joint sitting is not summoned by the President, the bill ends and becomes dead. 8. The mechanism of passing the bill for the second time to resolve a deadlock applies to a bill originating in the Legislative Assembly only. When a bill, which has originated in the Legislative Council and sent to the Legislative Assembly, is rejected by the latter, the bill ends and becomes dead. B. With regard to money bills 1. It can be introduced only in the Lok Sabha and not in the Rajya Sabha. 1. It can be introduced only in the Legislative Assembly and not in the Legislative Council. 2. It can be introduced only on the recommendation of the President. 2. It can be introduced only on the recommendation of the Governor. 3. It can be introduced only by a minister and not by a private member. 3. It can be introduced only by a minister and not by a private member. 4. It cannot be rejected or amended by the Rajya Sabha. It should be returned to the Lok Sabha within 14 days, either with or without recommendations. 4. It cannot be rejected or amended by the Legislative Council. It should be returned to the Legislative Assembly within 14 days, either with or without amendments. 5. The Lok Sabha can
either accept
or reject all or any of the recommendations of the Rajya Sabha. 5. The Legislative Assembly can either accept or reject all or any of the recommendations of the Legislative Council. 6. If the Lok Sabha accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. 6. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. 7. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Lok Sabha without any change. 7. If the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Legislative Assembly without any change. 8. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the houses at the expiration of the said period in the form originally passed by the Lok Sabha. 8. If the Legislative Council does not return the bill to the Legislative Assembly within 14 days, the bill is deemed to have been passed by both the houses at the expiration of the said period in the form originally passed by the Legislative Assembly. 9. The Constitution does not provide for the resolution of any
deadlock
between the 9. The Constitution does not provide for the two houses. This is resolution of any deadlock between the two houses. Because the will of the Legislative Assembly Lok Sabha is made to prevail over that of Legislative Council, if prevail over that of the latter does not agree to the bill passed by the Rajya Sabha, if the former latter does not agree to the bill passed by the former. Position of Legislative Council. The constitutional position of the Council, as compared with the Assembly, can be studied from two angles: A. Spheres where Council is equal to Assembly. B. Spheres where Council is unequal to Assembly. Equal with Assembly in the following matters: the powers and status of the Council are broadly equal to that of the Assembly, 1. Introduction and passage of ordinary bills. However, in case of disagreement between the two houses, the will of the Assembly prevails over that of the Council. 2. Approval of ordinances issued by the Governor. 14. 3. Selection of ministers including the Chief Minister. Under the Constitution, the ministers including the Chief Minister can be members of either house of the state legislature. However, irrespective of their membership, they are responsible only to the Assembly. 4. Consideration of the reports of the constitutional bodies like State Finance Commission, State Public Service Commission and Controller and Auditor General of India. 5. Enlargement of the jurisdiction of the State Public Service Commission. Unequal with Assembly.
In the following matters,
the powers and status of the Council are unequal to that of the Assembly. 1. A money bill can be introduced only in the Assembly and not in the Council. 2. The Council cannot amend or reject a money bill. It should return the bill to the Assembly within 14 days, either with recommendations or without recommendations. 3. The Assembly can either accept or reject all or any of the recommendation of the Council. In both the cases, the money bill is deemed to have been passed by the two houses. 4. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Assembly. 5. The final power of passing an ordinary bill also lies with the Assembly. At the most, the Council can detain or delay the bill for the period of 4 months, 3 months in the first instance and 1 month in the second instance. In other words, the Council is not even a revising body like the Rajya Sabha, it is only a dilatory chamber or an advisory body. 6. The Council can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Assembly. 7. The Council cannot remove the Council of Ministers by passing a no-confidence motion. This is because the Council of Ministers is collectively responsible only to the Assembly. But the Council can discuss and criticize the policies and activities of the government. 8. When an ordinary bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. 9. The Council does not participate in the election of the President of India and representatives of the state in the Rajya Sabha. 10. The Council has no effective say in the ratification of a constitutional amendment bill. In this respect also, the will of the Assembly prevails over that of the Council. 15. 11. Finally, the very existence of the Council depends on the will of the Assembly. The Council can be abolished by the Parliament on the recommendation of the Assembly. From the above, it is clear that the position of the Council vis-à-vis the Assembly is much weaker than the position of the Rajya Sabha vis-à-vis the
Lok
Lok
Sabha.
Sabha. The Rajya Sabha has equal powers with the Lok Sabha in all spheres except financial matters and with regard to the control over the government. On the other hand, the Council is subordinate to the Assembly in all respects. Thus, the predominance of the Assembly over the Council is fully established. Even though both the Council and the Rajya Sabha are second chambers, the Constitution has given the Council much lesser importance than the Rajya Sabha due to the following reasons. 1. The Rajya Sabha consists of the representatives of the states and thus reflect the federal element of the polity. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the centre. Therefore, it has to be an effective revising body and not just an advisory body or dilatory body like that of the Council. On the other hand, the issue of federal significance does not arise in the case of a Council. 2. The Council is heterogeneously constituted. It represents different interests and consists of differently elected members and also includes some nominated members. Its very composition makes its position weak and reduces its utility as an effective revising body. On the other hand, the Rajya Sabha is homogeneously constituted. It represents only the states and consists of mainly elected members, only 12 out of 250 are nominated. 3. The position accorded to the Council is in accordance with the principles of democracy. The Council should yield to the Assembly, which is a popular house. This pattern of relationship between the two houses of the state legislature is adopted from the British model. In Britain, the House of Lords, Upper House, cannot oppose and obstruct the House of Commons, Lower House. The House of Lords is only a dilatory chamber. It can delay an ordinary bill for a maximum period of 1 year and a money bill for 1 month. 16 Keeping in view its weak, powerless and insignificant position and role, the critics have described the council as a secondary chamber, costly ornamental luxury, white elephant, etc. The critics have opined that the council has served as a refuge for those who are defeated in the assembly elections. It enabled the unpopular, rejected and ambitious politicians to
occupy the post
of
of
a chief minister or a minister or a member of the state legislature. Even
The
though the
council has
council
been
has
given
been
less
given less
powers
powers as compared with the assembly, its utility is supported on the following grounds. 1. It checks the hasty, defective, careless and ill-considered legislation made by the assembly by making provision for revision and thought. 2. It facilitates representation of eminent professionals and experts who cannot face direct elections. The governor nominates 1/6 members of the council to provide representation to such people. Privileges of state legislature. Privileges of a state legislature are a sum of special rights, immunities and exemptions enjoyed by the houses of state legislature, their committees and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the houses can neither maintain their authority, dignity and honor nor can protect their members from any obstruction in the discharge of their legislative responsibilities. The Constitution has also extended the privileges of the state legislature to those persons who are entitled to speak and take part in the proceedings of a house of the state legislature or any of its committees. These include Advocate General of the state and state ministers. It must be clarified here that the privileges of the state legislature do not extend to the governor, who is also an integral part of the state legislature. The privileges of a state legislature can be classified into two broad categories: those that are enjoyed by each house of the state legislature collectively, and those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each house of the state legislature collectively are: 1. It has the right to publish its reports, debates and proceedings, and also the right to prohibit others from publishing the same. 17.
2. It can exclude strangers from its
proceedings and hold secret sittings to discuss some important matters. 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition or imprisonment, also suspension or expulsion, in case of members. 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member. 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. 7. The courts are prohibited to inquire into the proceedings of a house or its committees. 8. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the house without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: 1. They cannot be arrested during the session of the state legislature and 40 days before the beginning and 40 days after the end of such session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. 2. They have freedom of speech in the state legislature. No member is liable to any proceedings in any court for anything said or any vote given by him in the state legislature or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of the state legislature. 18. 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when the state legislature is in session. Table 33.2 Strength of state legislatures as name of the number of seats in number of seats in. No.
State Union
Territory Legislative Assembly Legislative Council I states 1. Andhra Pradesh 175-52. Arunachal Pradesh 60. 3. Assam 126. 4. Bihar 243.75.5. Chhattisgarh 90.6. Goa 40.7. Gujarat 182.8. Haryana 90.9. Himachal Pradesh 68.10. Jammu and Kashmir 8719.36.11. Jharkhand 81.12. Karnataka 224.75.13. Kerala 140.14. Madhya Pradesh 230.15. Maharashtra 288.78.16. Manipur 60.17. Meghalaya 60.18. Mizoram 40.19. Nagaland 60.20. Odisha 147.21. Punjab 117.
22
Rajasthan
200.
223. Sikkim 32.24. Tamil Nadu 234.25. Telangana 119.40.26. Tripura 60.27. Uttarakhand 70.28. Uttar Pradesh 403.100.29. West Bengal 294.2. Union Territories 1. Delhi 70.2. Puducherry 30, Table 33.3 seats reserved for SCs and STs in the Legislative Assembly's name of the number of seats in the House State Union before the delimitation in 2008 territory number of seats in after the delimitation total reserved for the scheduled castes reserved for the scheduled tribes total reserved for the scheduled castes I states 1. Andhra Pradesh 294.39.15 175.29.2. Arunachal Pradesh 60.59.60, 3. Assam 126.8.16 126.8.
For Bihar
243.39, 243.38.5. Chhattisgarh 90.10.34 90.10.6. Goa 41.41.7. Gujarat 182.13.26 182.13.8. Haryana 90.17, 90.17.9. Himachal Pradesh 68.16 368.17.10. Jammu and Kashmir 20.11. Jharkhand 81.9.28 81.9.12. Karnataka 224.33 to 224.36.13. Kerala 140.13 140.14.14. Madhya Pradesh 230.34.41 230.35.15. Maharashtra 288.18.22 288.29.16. Manipur 61.19.60.117. Meghalaya 60.55.60.18. Mizoram 40.39.40.19. Nagaland 60.59.60.20. Odisha 147.22.34 147.24.21. Punjab 117.29, 117.34.22. Rajasthan 233.24 234.23. Sikkim 32 2nd December 1932 to 24. Tamil Nadu 234.42 3 234.44.25. Telangana 119.19.
26
Tripura 67 20 60 10 27. Uttarakhand 70 12 March 1970 13 28.
Uttar
Uttar
403.89.
403.89, 403.85 Pradesh 29. West Bengal 294.59.17 294.68 2. Union Territories 1 Delhi 70.13, 70.12 2. Puducherry 35 Table 33.4 Articles related to state legislature at a glance Article No. Subject Matter General 168. Constitution of Legislatures in States 169. Abolition or creation of legislative councils in states Article No. Subject matter 170. Composition of the Legislative Assemblies 171. Composition of the Legislative Councils 172. Duration of state legislatures 173. Qualification for membership of the state legislature 174. Sessions of the state legislature, prorogation and dissolution 175. Right of governor to address and send messages to the House or Houses 176. Special address by the governor 177. Rights of ministers and advocate general as respects the Houses.
Officers of the
Officers of
state
the state
legislature.
legislature 178. The Speaker and Deputy Speaker of the Legislative Assembly 179. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker 180. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker 181. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration 182. The Chairman and Deputy Chairman of the Legislative Council 183. Vacation and resignation of, and removal from, the offices of Chairman and Deputy Chairman 184. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman 185. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration 186.
Salaries
Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman 187. Secretariat of State Legislature Conduct of Business 188. Oath or affirmation by members 189. Voting in Houses. Power of Houses to act notwithstanding vacancies and quorum disqualifications of members 190. Vacation of seats 191. Disqualifications for membership 192. Decision on questions as to disqualifications of members. 193 Penalty for sitting and voting before making oath or affirmation under Article 188 or when not qualified or when disqualified. Powers, privileges and immunities of state legislatures and their members 194. Powers, privileges, etc. of the House of Legislatures and of the members and committees thereof 195. Salaries and allowances of members. Legislative Procedure 196. Provisions as to introduction and passing of bills 197. Restriction on powers of Legislative Council as to bills other than money bills 198. Special procedure in respect of money bills 199. Definition of money bills 200. Assent to bills 201. Bills reserved for consideration. Procedure in financial matters 202. Annual financial statement 203. Procedure in legislature with respect to estimates 204. Appropriation bills 205. Supplementary, additional or excess grants 206. Votes on account, votes of credit and exceptional grants 207. Special provisions as to financial bills. Procedure generally 208. Rules of procedure 209. Regulation by law of procedure in the legislature of the state in
relation
to financial business 210. Language to be used in the legislature 211. Restriction on discussion in the legislature 212. Courts not to inquire into proceedings of the legislature. Legislative powers of the governor 213. Power of governor to promulgate ordinances during recess of legislature. Notes and references. 1. Jammu and Kashmir has adopted a bicameral legislature by its own state constitution, which is separate from the Indian constitution. 2. MP Jain, Indian Constitutional Law, Vadhva 4th edition, p. 159-3. See table 33.2 at the end of this chapter. 4. An Anglo-Indian means a person whose father or any other male progenitor in the male line is or was of European descent, but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not established there for temporary purposes only. 5. This means that the number of assembly seats reserved in a state for such castes and tribes is to bear the same proportion to the total number of seats in the assembly as the population of such castes and tribes in the concerned state bears to the total population of the state. 6. The minimum strength fixed at 40 by the Constitution of India is not applicable to Jammu and Kashmir. Its council has 36 members under the provisions of its own state constitution. 7. See table 33.2 at the end of this chapter. 8. The term of the Legislative Assembly of Jammu and Kashmir is 6 years under its own state constitution. 9. A minister in the union or state government is not considered as holding an office of profit. Also, the state legislature can declare that a particular office of profit will not disqualify its holder from its membership. 10. Ke hota holohan we zachailu, 1992. 11. However, the chairman speaker need not accept the resignation if he is
satisfied
that it is not voluntary or genuine. 12. A person can remain a minister for 6 months, without being a member of either house of the state legislature. 13. For a comparative study of the veto power of the president and the governor, see chapter 30. 14. For a comparative study of the ordinance-making power of the President and the Governor, see Chapter 30. 15. The position, in this regard, is very well analysed by J.C. Johari in the following way. The Constitution is not clear on this point whether a bill of constitutional amendment referred to the states for ratification by their legislatures shall include the Vidhan Parishad or not. In practice, it may be understood that the will of the Vidhan Sabha has to prevail. In case the Vidhan Parishad concurs with the view of the Vidhan Sabha, it is all right. In case it differs, the Vidhan Sabha may pass it again and thereby ignore the will of the Vidhan Parishad as it can do in case of a non-money bill. Indian Government and Politics, Vishal, 13th edition, 2001, p. 441. 16. The Parliament Act of 1911, and the Amending Act of 1949, have curtailed the powers of the House of Lords and established the supremacy of the House of Commons. 17. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of state legislature without its prior permission. But this is not applicable in the case of a secret sitting of the House. 18. Article 211 of the Constitution says that no discussion shall take place in the legislature of a state with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties. Under the rules of a House, of the state legislature, use of unparliamentary language or unparliamentary conduct of a member is prohibited. 19. Under the Constitution of Jammu and Kashmir, the total number of seats fixed for the Legislative Assembly is 111. But 24 seats fall in the Pakistan-occupied Kashmir, POK. These seats are vacant and are not to be taken into account for reckoning the total membership of the Assembly. Originally, the strength of J&K Assembly was 100 and this was increased to 111 in 1987. 20. Under the Constitution of Jammu and Kashmir, the number of seats in the Legislative Assembly of that state excluding the 24 seats earmarked for Pakistan-occupied territory is 87, out of which 7 seats have been reserved for the scheduled castes in pursuance of the Jammu and Kashmir Representation of the People Act, 1957.
High Court and the
Indian single
integrated judicial
system. The High Court operates below the Supreme Court but above the subordinate courts. The judiciary in a state consists of a High Court and a hierarchy of subordinate courts. The High Court occupies the top position in the judicial administration of a state. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. In 1866, a fourth High Court was established at Allahabad. In the course of time, each province in British India came to have its own High Court. After 1950, a High Court existing in a province became the High Court for the corresponding state. The Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for 2 or more states or for 2 or more states and a union territory. The territorial jurisdiction of a High Court is coterminous with the territory of a state. Similarly, the territorial jurisdiction of a common High Court is coterminous with the territories of the concerned states and union territory. At present, there are 24 High Courts in the country too. Out of them, 4 are common High Courts. Delhi is the only union territory that has a High Court of its own, since 1966. The other union territories fall under the jurisdiction of different state High Courts. The Parliament can extend the jurisdiction of a High Court to any union territory or exclude the jurisdiction of a High Court
From any
from
union,
any union
territory.
territory.
The
The name, year of establishment, territorial jurisdiction and seat, with bench or benches, of all the 24 High Courts are mentioned in Table 34.1 at the end of this chapter. Articles 214 to 231 in Part 6 of the Constitution deal
The
with
organization,
independence,
jurisdiction,
jurisdiction, powers, procedures and so on of the High Courts. Organization of High Court. Every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary to appoint. Thus, the Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. Accordingly, the President determines the strength of a High Court from time to time depending upon its workload. Judges. Appointment of judges. The judges of a High Court are appointed by the President. The Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of the state concerned. For appointment of other judges, the Chief Justice of the concerned High Court is also consulted. In case of a common High Court for 2 or more states, the governors of all the states concerned are consulted by the President. In the second Judges Case 3, 1993, the Supreme Court ruled that no appointment of a judge of the High Court can be made, unless it is in conformity with the opinion of the Chief Justice of India. In the third Judges Case 4, 1998, the Supreme Court opined that in case of the appointment of High Court judges, the Chief Justice of India should consult a collegium of 2 senior-most judges of the Supreme Court. Thus, the sole opinion of the Chief Justice of India alone does not constitute the consultation process. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body
called the
called
National
the
Judicial
Appointments Commission, in JAC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the INJAC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the 4th Judges Case 4A, 2015. The court opined that the new system, i.e., INJAC, would affect the independence of the judiciary. Qualifications of judges. A person to be appointed as a judge of a High Court should have the following qualifications. 1. He should be a citizen of India. 2. He should have held a judicial office in the territory of India for 10 years, or b. He should have been an advocate of a High Court, or High Courts in succession, for 10 years. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of a High Court. Moreover, unlike in the case of the Supreme Court, the Constitution makes no provision for appointment of a distinguished jurist as a judge of a High Court. Oath or affirmation. A person appointed as a judge of a High Court, before entering upon his office, has to make and subscribe an oath or affirmation before the governor of the state or some person appointed by him for this purpose. In his oath, a judge of a High Court swears, 1. To bear true faith and allegiance to the Constitution of India, 2. To uphold the sovereignty and integrity of India, 3. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will, and 4 to uphold the Constitution and the laws. Tenure of judges. The Constitution has not fixed the tenure of a judge of a high court. However, it makes the following 4 provisions in this regard. 1. He holds office until he attains the age of 62 years. 5. Any questions regarding his age is to be decided by the President after consultation with
the Chief Justice of India, and
the decision of the President is final. 2. He can resign his office by writing
to the President.
3. He can be removed from his office by the President on the recommendation of the Parliament. 4. He vacates his office when he is appointed as a judge of the Supreme Court or when he is transferred to another high court. Removal of judges. A judge of a high court can be removed from his office by an order of the President. The President can issue the removal order only after an address by the Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are 2. Proved misbehavior or incapacity. Thus, a judge of a high court can be removed in the same manner and on the same grounds as a judge of the Supreme Court. The Judges' Enquiry Act, 1968, regulates the procedure relating to the removal of a judge of a high court by the process of impeachment. 1. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker Chairman. 2. The Speaker Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of a. The Chief Justice or a Judge of the Supreme Court, b. a Chief Justice of a High Court, and c. a distinguished jurist. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. From the above, it is clear that the procedure for the impeachment of a judge of a high court is the same as that for a judge of the Supreme Court. It is interesting to know that no judge of a high court has been impeached so far. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of a high court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2009, the salary of the Chief Justice was increased from 30,000 to 90,000 per month and that of a judge from 26,000 to 80,000 per month. 6. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Transfer of judges. The President can transfer a judge from one high court to another after consulting the Chief Justice of India. On transfer, he is entitled to receive in addition to his salary such compensatory allowance as may be determined by Parliament. In 1977, the Supreme Court ruled that the transfer of High Court judges could be resorted to only as an exceptional measure and only in public interest and not by way of punishment. Again in 1994, the Supreme Court held that judicial review is necessary to check arbitrariness in transfer of judges. But only the judge who is transferred can challenge it. In the third judge's case, 1998, the Supreme Court opined that in case of the transfer of High Court judges, the Chief Justice of India should consult, in addition to the collegium of 4 senior-most judges of the Supreme Court, the Chief Justice of the 2 High Courts, one from which the judge is being transferred and the other receiving him. Thus, the sole opinion of the Chief Justice of India does not constitute the consultation process. Acting Chief Justice. The President can appoint a judge of a High Court as an acting Chief Justice of the High Court when 1. The office of Chief Justice of the High Court is vacant, or 2. The Chief Justice of the High Court is temporarily absent, Or 3. The Chief Justice of the High Court is unable to perform the duties of his office. Additional and acting judges. The President can appoint duly qualified persons as additional judges of a High Court for a temporary period not exceeding 2 years when 1. There is a temporary increase in the business of the High Court, or 2. There are arrears of work in the High Court. The President can also appoint a duly qualified person as an acting judge of a High Court when a judge of that High Court, other than the Chief Justice, is 1. Unable to perform the duties of his office due to absence or any other reason, or 2. Appointed to act temporarily as Chief Justice of that High Court. An acting judge holds office until the permanent judge resumes his office. However, both the additional or acting judge cannot hold office after attaining the age of 62 years. Retired judges. At any time, the Chief Justice of a High Court of a state can request a retired judge of that High Court or any other High Court to act as a judge of the High Court of that state for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers and privileges of a judge of that High Court. But he will not otherwise be deemed to be a judge of that High Court. Independence of High Court. The independence of a High Court is very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures and interferences of the Executive, Council of Ministers, and the
Legislature.
It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of a High Court. 1. Mode of appointment. The judges of a High Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, i.e., Chief Justice of India and the Chief Justice of the High Court. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. 2. Security of tenure. The judges of a High Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of a High Court has been removed, or impeached, so far. 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of a High Court are determined from time to time by the Parliament. But they cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of a High Court remain same during their term of office. 4. Expenses charged on consolidated fund. The salaries and allowances of the judges, the salaries, allowances and pensions of the staff as well as the administrative expenses of a High Court are charged on the consolidated fund of the state. Thus, they are non-votable by the state legislature, though they can be discussed by it. It should be noted here that the pension of a High Court judge is charged on the consolidated fund of India and not the state. 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of a High Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament.
6. Ban on practice
After retirement. The retired permanent judges of a High Court are prohibited from pleading or acting in any court or before any authority in India except the Supreme Court and the other High Courts. This ensures that they do not favor anyone in the hope of future favor. 7. Power to punish for its contempt. A High Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in a High Court to maintain its authority, dignity and honor. 8. Freedom to appoint its staff. The Chief Justice of a High Court can appoint officers and servants of the High Court without any interference from the executive.
He can also prescribe their conditions of service.
9. Its jurisdiction cannot be curtailed. The jurisdiction and powers of a High Court insofar as they are specified in the Constitution cannot be curtailed both by the Parliament and the state legislature. But, in other respects, The jurisdiction and powers of a High Court can be changed both by the Parliament and the state legislature. 10. Separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in public services. This means that the executive authorities should not possess the judicial powers. Consequent upon its implementation, the role of executive authorities in judicial administration came to an end. 7. Jurisdiction and powers of High Court. Like the Supreme Court, the High Court has been vested with quite extensive and effective powers. It is the highest court of appeal in the state. It is the protector of the fundamental rights of the citizens. It is vested with the power to interpret the Constitution. Besides, it has supervisory and consultative roles. However, the Constitution does not contain detailed provisions with regard to the jurisdiction and powers of a High Court. It only lays down that the jurisdiction and powers of a High Court are to be the same as immediately
before the commencement of the Constitution. But there is one addition, that is,
the Constitution gives the High Court jurisdiction over revenue matters, which it did not enjoy in the pre-Constitution era. The Constitution also confers, by other provisions, some more additional powers on a High Court like writ jurisdiction, power of superintendence, consultative power, etc. Moreover, it empowers the Parliament and the state legislature to change the jurisdiction and powers of a High Court. At present, a High Court enjoys the following jurisdiction and powers: 1. Original jurisdiction. 2. Writ jurisdiction. 3. Appellate jurisdiction. 4. Supervisory jurisdiction. 5. Control over subordinate courts. 6. A court of record. 7. Power of judicial review. The present jurisdiction and powers of a High Court are governed by a. The constitutional provisions, b. The letters patent, c. The Acts of Parliament, d. The Acts of State Legislature, e. Indian Penal Code, 1860, f. Criminal Procedure Code, 1973, and g. Civil Procedure Code, 1908. 1. Original jurisdiction. It means the power of a High Court to hear disputes in the first instance, not by way of appeal. It extends to the following: a. Matters of admiralty, will, marriage, divorce, company laws and contempt of court. b. Disputes relating to the election of members of Parliament and state legislatures. c. Regarding revenue matter or an act ordered or done in revenue collection. d. Enforcement of fundamental rights of citizens. e. Cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. f. The 4 High Courts, i.e., Calcutta, Bombay, Madras and Delhi High Courts, have original civil jurisdiction in cases of higher value. Before 1973, the Calcutta, Bombay and Madras High Courts also had
original criminal jurisdiction.
This was fully abolished by the Criminal Procedure Code, 1973. 2. Writ jurisdiction. Article 226 of the Constitution empowers the High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto for the enforcement of the fundamental rights of the citizens and for any other purpose. The phrase, "for any other purpose," refers to the enforcement of an ordinary legal right. The High Court can issue writs to any person, authority and government not only within its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. 8. The writ jurisdiction of the High Court, under Article 226, is not exclusive but concurrent with the writ jurisdiction of the Supreme Court, under Article 32. It means, when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. However, the writ jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. In the Chandra Kumar case 9, 1997, the Supreme Court ruled that the writ jurisdiction of both the High Court and the Supreme Court constitute a part of the basic structure of the Constitution. Hence, it cannot be ousted or excluded even by way of an amendment to the Constitution. 3. Appellate jurisdiction. A High Court is primarily a court of appeal. It hears appeals against the judgments of subordinate courts functioning in its territorial jurisdiction. It has appellate jurisdiction in both civil and criminal matters. Hence, the appellate jurisdiction of a High Court is wider than its original jurisdiction. A. Civil matters. The civil appellate jurisdiction of a High Court is as follows. I. First, appeals from the orders and judgments of the district courts, additional district courts and other subordinate courts lie directly to the High Court, on both questions of law and fact, if the amount exceeds the stipulated limit. 2. Second, appeals from the orders and judgments of the district court or other subordinate courts lie to the High Court in the cases involving questions of law only, and not questions of fact. 3. The Calcutta, Bombay and Madras High Courts have provision for intra-court appeals. When a single judge of the High Court has decided a case, either under the original or appellate jurisdiction of the High Court, an appeal from such a decision lies to the division bench of the same High Court. 4. Appeals from the decisions of the administrative and other tribunals lie to the division bench of the State High Court. In 1997, the Supreme Court ruled that the tribunals are subject to the writ jurisdiction of the High Courts. Consequently, it is not possible for an aggrieved person to approach the Supreme Court directly against the decisions of the tribunals, without first going to the High Courts. B. Criminal matters. The criminal appellate jurisdiction of a High Court is as follows. I. Appeals from the judgments of Sessions Court and Additional Sessions Court lie to the High Court if the sentence is one of imprisonment for more than 7 years. It should also be noted here that a death sentence, popularly known as capital punishment, awarded by a Sessions Court or an Additional Sessions Court should be confirmed by the High Court before it can be executed, whether there is an appeal by the convicted person or not. 2. In some cases specified in various provisions of the Criminal Procedure Code, 1973, the appeals from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate or other magistrates, judicial, lie to the High Court. 4. Supervisory jurisdiction. A High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction, except military courts or tribunals. Thus, it may a. Call for returns from them, b. Make and issue general rules and prescribe forms for regulating the practice and proceedings of them, c. Prescribe forms in which books, entries and accounts are to be kept by them, and d. Settle the fees payable to the sheriff, clerks, officers and legal practitioners of them. This power of superintendence of a High Court is very broad because, I. It extends to all courts and tribunals whether they are subject to the appellate jurisdiction of the High Court or not. 2. It covers not only administrative superintendence but also judicial superintendence. 3. It is a revisional jurisdiction. And 4. It can be suo motu, on its own, and not necessarily on the application of a party. However, this power does not vest the High Court with any unlimited authority over the subordinate courts and tribunals. It is an extraordinary power and hence has to be used most sparingly and only in appropriate cases. Usually, it is limited to I. Excess of jurisdiction, 2. Gross violation of natural justice, 3. Error of law, 4. Disregard to the law of superior courts, perverse findings, and 6. Manifest injustice. 5. Control over the subordinate courts in addition to its appellate jurisdiction and supervisory jurisdiction over the subordinate courts as mentioned above. A High Court has an administrative control and other powers over them. These include the following. A. It is consulted by the governor in the matters of appointment, posting and promotion of district judges and in the appointments of persons to the judicial service of the state, other than district judges. B. It deals with the matters of posting, promotion, grant of leave, transfers and discipline of the members of the judicial service of the state, other than district judges. C. It can withdraw a case pending in a subordinate court if it involves a substantial question of law that require the interpretation of the Constitution. It can then either dispose of the case itself or determine the question of law and return the case to the subordinate court with its judgment. D. Its law is binding on all subordinate courts functioning within its territorial jurisdiction in the same sense as the law declared by the Supreme Court is binding on all courts in India. 6. A court of record. As a court of record, a high court has two powers. A. The judgments, proceedings and acts of the high courts are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of court, either with simple imprisonment or with fine or with both. The expression, contempt of court, has not been defined by the Constitution. However, the expression has been defined by the Contempt of Court Act of 1971. Under this, contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ or other process of a court or willful breach of an undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which I. Scandalizes or lowers the authority of a court, or 2. Prejudices or interferes with the due course of a judicial proceeding, or 3. Interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticism of judicial acts and comment on the administrative side of the judiciary do not amount to contempt of court. As a court of record, a high court also has the power to review and correct its own judgment or order or decision, even though no specific power of review is conferred on it by the Constitution. The Supreme Court, on the other hand, has been specifically conferred with the power of review by the
Constitution.
7. Power of judicial review. Judicial review is the power of a high court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional and invalid, null and void, by the High Court. Consequently, they cannot be enforced by the government. Though the phrase, judicial review, has nowhere been used in the Constitution, the provisions of Articles 13 and 226 explicitly confer the power of judicial review on a High Court. The constitutional validity of a legislative enactment or an executive order can be challenged in a High Court on the following three grounds. A. It infringes the fundamental rights. Part 3. B. It is outside the competence of the authority which has framed it. And C. It is repugnant to the constitutional provisions. The 42nd Amendment Act of 1976 curtailed the judicial review power of High Court. It debarred the High Courts from considering the constitutional validity of any central law. However, the 43rd Amendment Act of 1977 restored the original position. Table 34.1 Name and Jurisdiction of High Courts. Name, Year of Establishment, Territorial Jurisdiction, Seat 1. Allahabad 1866, Uttar Pradesh. Allahabad, Bench at Lucknow. 2. Hyderabad 1954, Andhra Pradesh and Telangana. Hyderabad 3. Bombay 1862, Maharashtra, Goa, Dadra and Nagar Haveli and Daman Mumbai. Benches at Nagpur, Panaji,
And DU
and Aurangabad. 4. Calcutta 1862, West Bengal and Andaman and Nicobar Islands. Kolkata, Circuit Bench at Port Blair. 5. Chhattisgarh 2000, Chhattisgarh Bilaspur. 6. Delhi 1966, Delhi 7. Guwahati 194810, Assam, Nagaland, Mizoram and Arunachal Pradesh. 14. Guwahati, Benches at Kohima, Aswal and Itanagar. 8. Gujarat 1960, Gujarat Ahmedabad. 9. Himachal Pradesh 1971, Himachal Pradesh Simla 10. Jammu and Kashmir 1928, Jammu and Kashmir Srinagar and Jammu 11. Jharkhand 2000, Jharkhand Ranchi 12. Karnataka 188411, Karnataka Bangalore 13. Kerala 1958, Kerala and Lakshadweep Ernakulam 14. Madhya Pradesh 1956, Madhya Pradesh Jabalpur, benches at Gwalior and Indore, 15. Madras 13, 1862, Tamil Nadu and Puducherry Chennai 16. Manipur 15, 2013, Manipur Imphal 17. Meghalaya 15, 2013, Meghalaya Shillong 18. Orissa 16, 1948, Odisha Cuttack
19.
Patna 1916, Bihar Patna 20. Punjab and Haryana 187512, Punjab, Haryana and Chandigarh, Chandigarh 21. Rajasthan 1949, Rajasthan Jodhpur, bench at Jaipur, 22. Sikkim 1975, Sikkim Gangtok 23. Tripura 15, 2013, Tripura Agartala 24. Uttarakhand 2000, Uttarakhand Nainital Table 34.2, articles related to High Courts at a glance, article No. Subject matter 214. High Courts for States 215. High Courts to be Courts of Record 216. Constitution of High Courts 217. Appointment and conditions of the office of a Judge of a High Court 218. Application of certain provisions relating to Supreme Court to High Courts 219. Oath or affirmation by Judges of High Courts 220. 221 Restriction on practice after being a permanent judge, salaries etc. of judges 222. Transfer of a judge from one high court to another 223. Appointment of acting Chief Justice 224. Appointment of additional and acting judges 224a. Appointment of retired judges at sittings of high courts.
225.
Jurisdiction of existing high courts 226. Power of high courts to issue certain writs 226a. Constitutional validity of central laws not to be considered in proceedings under Article 226, repealed, 227. Power of superintendence over all courts by the High Court 228. Transfer of certain cases to High Court 228a. Special provisions as to disposal of questions relating to constitutional validity of state laws, repealed, 229. Officers and servants and the expenses of High Courts 230. Extension of jurisdiction of High Courts to Union Territories 231. Establishment of a common High Court for two or more states 232. Interpretation, repealed, notes and references 1. These three High Courts were set up under the provisions of the Indian High Courts Act, 1861. 2. With the creation of 3 more new states in 2000, the number of High Courts increased from 18 to 21. Again, with the creation of separate High Courts for the 3 northeastern states of Manipur, Meghalaya and Tripura in 2013, the number of High Courts increased from 21 to 24. 3. Supreme Court Advocates v. Union of India, 1993. 4. In re-presidential reference, 1998. The President sought the Supreme Court's opinion, under Article 143, on certain doubts over the consultation process to be adopted by the Chief Justice of India as stipulated in the 1993 case. 4. A Supreme Court Advocates on Record Association and Another versus Union of India, 2015. 5. The retirement age has been raised from 60 to 62 years by the 15th Amendment Act of 1963. 6. In 1950, their salaries were fixed at 4,000 per month and 3,500 per month respectively. In 1986, their salaries were raised to 9,000 per month and 8,000 per month respectively. In 1998, their salaries were raised to 30,000 per month and 26,000 per month respectively. 7. The Criminal Procedure Code, 1973, has effected the separation of judiciary from the executive, Article 50 under the directive principles of state policy. 8. The second provision was added by the 15th Constitutional Amendment Act of 1963. 9. L. Chandra Kumar V. Union of India, 1997. 10. Originally known as Assam High Court and renamed Guwahati High Court in 1971. 11. Originally known as Mysore High Court and renamed Karnataka High Court in 1973. 12. Originally known as Punjab High Court and renamed Punjab and Haryana High Court in 1966. 13. Though the names of Bombay, Calcutta and Madras are changed to Mumbai, Kolkata and Chennai respectively, the names of respective high courts are not changed. 14. In 2013, separate high courts were created for the three northeastern states of Manipur, Meghalaya and Tripura. 15. Established by the Northeastern Areas, Reorganization, and Other Related Laws, Amendment, Act, 2012. 16. Though the name of Orissa is changed to Odisha, the name of Orissa High Court is not changed. 17. The Andhra Pradesh High Court was renamed as the Hyderabad High Court, i.e., High Court of Judicature at Hyderabad, by the Andhra Pradesh Reorganization Act, 2014. Subordinate courts. The state judiciary consists of a high court and a hierarchy of subordinate courts, also known as lower courts. The subordinate courts are so called because of their subordination to the state high court. They function below and under the high court at district and lower levels. Constitutional provisions Articles 233 to 237 in Part 6 of the Constitution make the following provisions to regulate the organization of subordinate courts and to ensure their independence from the executive one. 1. Appointment of district judges. The appointment, posting and promotion of district judges in a state are made by the governor of the state in consultation with the High Court. A person to be appointed as district judge should have the following qualifications. A. He should not already be in the service of the central or the state government. B. He should have been an advocate or a pleader for 7 years. C. He should be recommended by the High Court for appointment. 2. Appointment of other judges. Appointment of persons, other than district judges, to the judicial service of a state are made by the governor of the state after consultation with the State Public Service Commission and the High Court. 2. 3. Control over the subordinate courts. The control over district courts and other subordinate courts including the posting, promotion and leave of persons belonging to the judicial service of a state and holding any post inferior to the post of district judge is vested in the High Court. 4. Interpretation. The expression, district judge, includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge and assistant sessions judge. The expression, judicial service, means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. 5. Application of the above provisions to certain magistrates. The governor may direct that the above-mentioned provisions relating to persons in the state judicial service would apply to any class or classes of magistrates in the state. Structure and jurisdiction. The organizational structure, jurisdiction and nomenclature of the subordinate judiciary are laid down by the states. Hence, they differ slightly from state to state. Broadly speaking, there are 3 tiers of civil and criminal courts below the High Court. This is shown as follows. The district judge is the highest judicial authority in the district. He possesses original and appellate jurisdiction in both civil as well as criminal matters. In other words, the district judge is also the sessions judge. When he deals with civil cases, he is known as the district judge, and when he hears the criminal cases, he is called as the sessions judge. The district judge exercises both judicial and administrative powers. He also has supervisory powers over all the subordinate courts in the district. Appeals against his orders and judgments lie to the High Court. The Sessions Judge has the power to impose any sentence including life imprisonment and capital punishment, death sentence. However, a capital punishment passed by him is subject to confirmation by the High Court, whether there is an appeal or not. Below the District and Sessions Court stands the Court of Subordinate Judge on the civil side and the Court of Chief Judicial Magistrate on the criminal side. The subordinate judge exercises unlimited pecuniary jurisdiction over the civil suits. 3. The Chief Judicial Magistrate decides criminal cases which are punishable with imprisonment for a term up to 7 years. At the lowest level, on the civil side, is the Court of Munsif, and on the criminal side, is the Court of Judicial Magistrate. The Munsif possesses limited jurisdiction and decides civil cases of small pecuniary stake. 4. The Judicial Magistrate tries criminal cases which are punishable with imprisonment for a term up to 3 years. In some metropolitan cities, there are city civil courts, chief judges, on the civil side and the courts of metropolitan magistrates on the criminal side. Some of the states and presidency towns have established small causes courts. 5. These courts decide the civil cases of small value in a summary manner. Their decisions are final, but the High Court possesses the power of revision. In some states, Panchayat courts try petty civil and criminal cases. They are variously known as Nyaya Panchayat, Gram Kacheri, Adalati Panchayat, Panchayat Adalat, and so on. National Legal Services Authority 6 Article 39 of the Constitution of India provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Articles 14 and 22, 1. of the Constitution also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. In the year 1987, the Legal Services Authorities Act was enacted by the Parliament, which came into force on 9 November 1995 to establish a nationwide uniform network for providing free and competent legal services to the weaker sections of the society on the basis of equal opportunity. The National Legal Services Authority, NLSA, has been constituted under the Legal Services Authorities Act, 1987 to monitor and evaluate implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. In every state, a State Legal Services Authority, and in every High Court, a High Court Legal Services Committee have been constituted. District Legal Services Authorities, Taluk Legal Services Committees have been constituted in the districts and most of the taluks to give effect to the policies and directions of the NLSA and to provide free legal services to the people and conduct Lok Adalats in the state. Supreme Court Legal Services Committee has been constituted to administer and implement the legal services program insofar as it relates to the Supreme Court of India. NLSA lays down policies, principles, guidelines and frames effective and economical schemes for the state legal services authorities to implement the legal services programs throughout the country. Primarily, the state legal services authorities, district legal services authorities, taluk legal services committees, etc. have been asked to discharge the following main functions on regular basis. 1. To provide free and competent legal services to the eligible persons. 2. To organize Lok Adalats for amicable settlement of disputes. 3. To organize legal awareness camps in the rural areas. The free legal services include a. Payment of court fee, process fees and all other charges payable or incurred in connection with any legal proceedings. b. Providing service of lawyers in legal proceedings. c. Obtaining and supply of certified copies of orders and other documents in legal proceedings. d. Preparation of appeal, paper book including printing and translation of documents in legal proceedings. The persons eligible for getting free legal services include I. Women and children. 2. Members of SC Cent. 3. Industrial workmen. 4. Victims of mass disaster, violence, flood, drought, earthquake, industrial disaster. Disabled persons. 6. Persons in custody. 7. Persons whose annual income does not exceed Rs 1 lakh. In the Supreme Court Legal Services Committee the limit is as 125,000-8. Victims of trafficking in human beings or bigar. Lok Adalats. Lok Adalat is a forum where the cases, or disputes, which are pending in a court or which are at pre-litigation stage, not yet brought before a court, are compromised or settled in an amicable manner. Meaning the Supreme Court has explained the meaning of the institution of Lok Adalat in the following way. 7. The Lok Adalat is an old form of adjudicating system prevailed in ancient India and its validity has not been taken away even in the modern days too. The word Lok Adalat means people's court. This system is based on Gandhian principles. It is one of the components of ADR, Alternative Dispute Resolution, system. As the Indian courts are overburdened with the backlog of cases and the regular courts are to decide the cases involving a lengthy, expensive and tedious procedure, the court takes years together to settle even petty cases. Lok Adalat, therefore, provides alternative resolution or device for expeditious and inexpensive justice. In Lok Adalat proceedings, there are no victors and vanquished and, thus, no rancor. The experiment of Lok Adalat, as an alternate mode of dispute settlement has come to be accepted in India, as a viable, economic, efficient and informal one. The Lok Adalat is another alternative in judicial justice. This is a recent strategy for delivering informal, cheap and expeditious justice to the common man by way of settling disputes, which are pending in courts and also those, which have not yet reached courts by negotiation, conciliation and by adopting persuasive, common sense and human approach to the problems of the disputants, with the assistance of specially trained and experienced members of a team of conciliators. Statutory status. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. This initiative proved very successful in the settlement of disputes. Consequently, the institution of Lok Adalat started spreading to other parts of the country. At that time, this institution was functioning as a voluntary and conciliatory agency without any statutory backing for its decisions. In view of its growing popularity, there arose a demand for providing a statutory backing to this institution and the awards given by Lok Adalats. Hence, the institution of Lok Adalat has been given statutory status under the Legal Services Authorities Act, 1987. The Act makes the following provisions relating to the organization and functioning of the Lok Adalats. 1. The State Legal Services Authority or the District Legal Services Authority or the Supreme Court Legal Services Committee or the High Court Legal Services Committee or the Taluk Legal Services Committee may organize Lok Adalat at such intervals and places and for exercising such jurisdiction and for such areas as it thinks fit. 2. Every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers and other persons of the area as may be specified by the agency organizing such Lok Adalat. Generally, a Lok Adalat consists of a judicial officer as the chairman and a lawyer, advocate, and a social worker as members. 3. A Lok Adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of I. Any case pending before any court, or 2. Any matter which is falling within the jurisdiction of any court and is not brought before such court. Thus, the Lok Adalat can deal with not only the cases pending before a court but also with the disputes at pre-litigation stage. Matters such as matrimonial family disputes, criminal, compoundable offences, cases, land acquisition cases, labour disputes, workmen's compensation cases, bank recovery cases, pension cases, housing board and slum clearance cases, housing finance cases, consumer grievance cases, electricity matters, disputes relating to telephone bills, municipal matters including house tax cases, disputes with cellular companies etc. are being taken up in Lok Adalat. 7. But the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. In other words, the offences which are non-compoundable under any law fall outside the purview of the Lok Adalat. For any case pending before the court can be referred to the Lok Adalat for settlement if I. The parties thereof agree to settle the dispute in the Lok Adalat, or 2. One of the parties thereof makes an application to the court for referring the case to the Lok Adalat, or 3. The court is satisfied that the matter is an appropriate one to be taken cognizance of by the Lok Adalat. In the case of a pre-litigation dispute, the matter can be referred to the Lok Adalat for settlement by the agency organizing the Lok Adalat, on receipt of an application from any one of the parties to the dispute. 5. The Lok Adalat shall have the same powers as are vested in a civil court under the Code of Civil Procedure, 1908, while trying a suit in respect of the following matters: a. The summoning and enforcing the attendance of any witness examining him on oath. b. The discovery and production of any document. c. The reception of evidence on affidavits. d. The requisitioning of any public record or document from any court or office, and e. Such other matters as may be prescribed. Further, a Lok Adalat shall have the requisite powers to specify its own procedure for the determination of any dispute coming before it. Also, all proceedings before a Lok Adalat shall be deemed to be judicial proceedings within the meaning of the Indian Penal Code, 1860, and every Lok Adalat shall be deemed to be a civil court for the purpose of the Code of Criminal Procedure, 1973. 6. An award of a Lok Adalat shall be deemed to be a decree of a civil court or an order of any other court. Every award made by a Lok Adalat shall be final and binding on all the parties to the dispute. No appeal shall lie to any court against the award of the Lok Adalat. Benefits according to the Supreme Court. The benefits under Lok Adalat are as follows: 1. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat. 2. The basic features of Lok Adalat are the procedural flexibility and speedy trial of the disputes. There is no strict application of procedural laws like the Civil Procedure Code and the Evidence Act while assessing the claim by Lok Adalat. 3. The parties to the dispute can directly interact with the judge through their counsel, which is not possible in regular courts of law. 4. The award by the Lok Adalat is binding on the parties, and it has the status of a decree of a civil court, and it is non-appealable, which does not cause the delay in the settlement of disputes finally. In view of above facilities provided by the Act, Lok Adalats are boon to the litigating public as they can get their disputes settled fast and free of cost amicably. The Law Commission of India summarized the advantages of ADR, alternative dispute resolution, in the following way: 9. 1. It is less expensive. 2. It is less time consuming. 3. It is free from technicalities vis-a-vis conducting of cases in law courts. 4. Parties are free to discuss their differences of opinion without any fear of disclosure before any law courts. 5. Parties have the feeling that there is no losing or winning side between them, but at the same time their grievance is redressed and their relationship is restored. Permanent Lok Adalats. The Legal Services Authorities Act, 1987 was amended in 2002 to provide for the establishment of the Permanent Lok Adalats to deal with cases pertaining to the public utility services. The reasons for the establishment of Permanent Lok Adalats are as follows. 1. The Legal Services Authorities Act, 1987 was enacted to constitute legal services authorities for providing free and competent legal services to the weaker sections of the society, to ensure that opportunities for securing justice were not denied to any citizen by reason of economic or other disabilities, and to organize Lok Adalats to ensure that the operation of the legal system promotes justice on a basis of equal opportunity. 2. The system of Lok Adalat, which is an innovative mechanism for alternate dispute resolution, has proved effective for resolving disputes in a spirit of conciliation outside the courts. 3. However, the major drawback in the existing scheme of organization of the Lok Adalats under the said Act is that the system of Lok Adalats is mainly based on compromise or settlement between the parties. If the parties do not arrive at any compromise or settlement, the case is either returned to the court of law or the parties are advised to seek remedy in a court of law. This causes unnecessary delay in the dispensation of justice. If Lok Adalats are given power to decide the cases on merits in case parties fails to arrive at any compromise or settlement, this problem can be tackled to a great extent. For further, the cases which arise in relation to public utility services such as Mahanagar Telephone Nigam Limited, Delhi Vidyut Board, etc., need to be settled urgently so that people get justice without delay even at pre-litigation stage, and thus most of the petty cases which ought not to go in the regular courts would be settled at the pre-litigation stage itself, which would result in reducing the workload of the regular courts to a great extent. 5. It is, therefore, proposed to amend the Legal Services Authorities Act, 1987 to set up permanent Lok Adalats for providing compulsory pre-litigative mechanism for conciliation and settlement of cases relating to public utility services. Features. The salient features of the new institution of permanent Lok Adalats are as follows. 1. The permanent Lok Adalat shall consist of a chairman who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge, and 2 other persons having adequate experience in public utility services. 2. The permanent Lok Adalat shall exercise jurisdiction in respect of 1 or more public utility services such as transport services of passengers or goods by air, road and water, postal, telegraph or telephone services, supply of power, light or water to the public by any establishment, public conservancy or sanitation, services in hospitals or dispensaries, and
insurance services.
3. The pecuniary jurisdiction of the permanent Lok Adalat shall be up to rupees 10 lakhs. However, the central government may increase the said pecuniary jurisdiction from time to time. 4. The permanent Lok Adalat shall have not jurisdiction in respect of any matter relating to an offence not compoundable under any law. 5. Before the dispute is brought before any court, any party to the dispute may make an application to the permanent Lok Adalat for settlement of the dispute. After an application is made to the permanent Lok Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. 6. Where it appears to the permanent Lok Adalat that there exist elements of a settlement, which may be acceptable to the parties, it shall formulate the terms of a possible settlement and submit them to the parties for their observations, and in case the parties reach an agreement, the permanent Lok Adalat shall pass an award in terms thereof. In case parties to the dispute fail to reach an agreement, the permanent Lok Adalat shall decide the dispute on merits. 7. Every award made by the permanent Lok Adalat shall be final and binding on all the parties thereto, and shall be by a majority of the persons constituting the permanent Lok Adalat. Family Courts. The Family Courts Act, 1984 was enacted to provide for the establishment of family courts with a view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. Reasons. The reasons for the establishment of separate family courts are as follows. 1. Several associations of women, other organizations and individuals have urged, from time to time, that family courts be set up for the settlement of family disputes, where emphasis should be laid on conciliation and achieving socially desirable results, and adherence to rigid rules of procedure and evidence should be eliminated.
2. The Law Commission in its
59th report, 1974, had also stressed that in dealing with disputes concerning the family, the court ought to adopt an approach radically different from the adopted in ordinary civil proceedings, and that it should make reasonable efforts at settlement before the commencement of the trial. The Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceedings relating to matters concerning the family. 3. However, not much use has been made by the courts in adopting this conciliatory procedure, and the courts continue to deal with family disputes in the same manner as other civil matters, and the same adversary approach prevails. The need was, therefore, felt, in the public interest, to establish family courts for speedy settlement of family disputes. Therefore, the main objectives and reasons for setting up of family courts are 10i. To create a specialized court which will exclusively deal with family matters, so that such a court may have the necessary expertise to deal with these cases expeditiously. Thus expertise and expeditious disposal are 2 main factors for establishing such a court. 2. To institute a mechanism for conciliation of the disputes relating to family. 3. To provide an inexpensive remedy. And 4. To have flexibility and an informal atmosphere in the conduct of proceedings. Features. The salient features of the Family Courts Act, 1984 are as follows. 1. It provides for the establishment of family courts by the state governments in consultation with the high courts. 2. It makes it obligatory on the state governments to set up a family court in every city or town with a population exceeding 1 million. 3. It enables the state governments to set up family courts in other areas also, if they deem it necessary. 4. It exclusively provides within the jurisdiction of the family courts the matters relating to I. Matrimonial relief, including nullity of marriage, judicial separation, divorce, restitution of conjugal rights, or declaration as to the validity of marriage or as to the matrimonial status of any person. 2. The property of the spouses or of either of them. 3. Declaration as to the legitimacy of any person. 4. Guardianship of a person or the custody of any minor. And we. Maintenance of wife, children and parents. 5. It makes it obligatory on the part of the family court to endeavor, in the first instance, to effect a reconciliation or a settlement between the parties to a family dispute. During this stage, the proceedings will be informal and rigid rules of procedure shall not apply. 6. It provides for the association of social welfare agencies, counselors, etc., during conciliation stage and also to secure the service of medical and welfare experts. 7. It provides that the parties to a dispute before a family court shall not be entitled, as of right, to be represented by legal practitioner. However, the court may, in the interest of justice, seek assistance of a legal expert as amicus curiae. 8. It simplifies the rules of evidence and procedure so as to enable a family court to deal effectively with a dispute. 9. It provides for only one right of appeal which shall lie to the High Court. Establishment. At present, 2016, a total of 438 family courts are functional in the country. The state-wise position is indicated below in Table 35.1. Table 35.1 Establishment of Family Courts, 2016, SL.No. States UT's number of family courts 1. Andhra Pradesh 14-2. Arunachal Pradesh 3. Assam 034. Bihar 39. 5. Chhattisgarh 19-6. Delhi 15-7. Goa 8. Gujarat 17-9. Haryana 07-10. Himachal Pradesh 11. Jammu and Kashmir 12. Jharkhand 21-13. Karnataka 27-14. Kerala 28-15. Madhya Pradesh 44-16. Maharashtra 22-17. Manipur 05-18. Meghalaya 19. Mizoram 04-20. Nagaland 02-21. Odisha 17-22. Punjab 07-23. Puducherry 01-24. Rajasthan 28-25. Sikkim 04-26. Tamil Nadu 14-27. Telangana 12-28. Tripura 03. 29. Uttar Pradesh 76-30. Uttarakhand 07-31. West Bengal 02. Total 438. Source: Ministry of Law and Justice, Government of India. Gram Nyayalayas. The Gram Nyayalayas Act, 2008 has been enacted to provide for the establishment of the Gram Nyayalayas at the grassroots level for the purposes of providing access to justice to the citizens at their doorsteps and to ensure that opportunities for securing justice are not denied to any citizen due to social, economic or other disabilities. Reasons. The reasons for the establishment of Gram Nyayalayas are as follows. 1. Access to justice by the poor and disadvantaged remains a worldwide problem despite diverse approaches and strategies that have been formulated and implemented to address it. In our country, Article 39 of the Constitution directs the state to secure that the operation of the legal system promotes justice, on a basis of equal opportunity and shall provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. 2. In the recent past, the government has taken various measures to strengthen judicial system, inter alia, by simplifying the procedural laws, incorporating various alternative dispute resolution mechanisms such as arbitration, conciliation and mediation, conducting of lok adalats, etc. These measures are required to be strengthened further. 3. The Law Commission of India in its 114th report on Gram Nyayalaya suggested establishment of Gram Nyayalayas so that speedy, inexpensive and substantial justice could be provided to the common man. The Gram Nyayalayas Act, 2008 is broadly based on the recommendations of the Law Commission. 4. Justice to the poor at their doorstep is a dream of the poor. Setting up of Gram Nyayalayas in the rural areas would bring to the people of rural areas speedy, affordable and substantial justice. Features. The salient features of the Gram Nyayalayas Act are as follows. 11. 1. The Gram Nyayalaya shall be court of judicial magistrate of the first class and its presiding officer, Nyayadhikari, shall be appointed by the state government in consultation with the High Court. 2. The Gram Nyayalaya shall be established for every panchayat at intermediate level or a group of contiguous panchayats at intermediate level in a district or where there is no panchayat at intermediate level in any state, for a group of contiguous panchayats. 3. The Nyayadhikaris who will preside over these Gram Nyayalayas are strictly judicial officers and will be drawing the same salary, deriving the same powers as first-class magistrates working under high courts. 4. The Gram Nyayalaya shall be a mobile court and shall exercise the powers of both criminal and civil courts. 5. The seat of the Gram Nyayalaya will be located at the headquarters of the intermediate panchayat. They will go to villages, work there and dispose of the cases. 6. The Gram Nyayalaya shall try criminal cases, civil suits, claims or disputes which are specified in the first schedule and the second schedule to the Act. 7. The central as well as the state governments have been given power to amend the first schedule and the second schedule of the Act, as per their respective legislative competence. 8. The Gram Nyayalaya shall follow summary procedure in criminal trial. 9. The Gram Nyayalaya shall exercise the powers of a civil court with certain modifications and shall follow the special procedure as provided in the Act. 10. The Gram Nyayalaya shall try to settle the disputes as far as possible by bringing about conciliation between the parties, and for this purpose, it shall make use of the conciliators to be appointed for this purpose. 11. The judgment and order passed by the Gram Nyayalaya shall be deemed to be a decree, and to avoid delay in its execution, the Gram Nyayalaya shall follow summary procedure for its execution. 12. The Gram Nyayalaya shall not be bound by the rules of evidence provided in the Indian Evidence Act, 1872, but shall be guided by the principles of natural justice and subject to any rule made by the High Court. 13. Appeal in criminal cases shall lie to the Court of Session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. 14. Appeal in civil cases shall lie to the District Court, which shall be heard and disposed of within a period of 6 months from the date of filing of the appeal. 15. A person accused of an offence may file an application for plea bargaining. Establishment. The central government has decided to meet the non-recurring expenditure on the establishment of these Gram Nyayalayas subject to a ceiling of 18 rupees lakhs, out of which 10 rupees lakhs is for construction of the court, 5 rupees lakhs for vehicle and 3 rupees lakhs for office equipment. More than 5,000 Gram Nyayalayas are expected to be set up under the Act, for which the central government would provide about 1,400 crores by way of assistance to the concerned states' union territories. Under of the Gram Nyayalayas Act, 2008, it is for the state governments to establish Gram Nyayalayas in consultation with the respective high courts. The state-wise progress of setting up of Gram Nyayalayas till 2016 is shown below in Table 35.2. Table 35.2 Establishment of Gram Nyayalayas, 2016, SL.No. States Gram Nyayalayas notified Gram Nyayalayas functional Madhya 1 Pradesh 89-89-2. Rajasthan 45-45-3. Karnataka 204. Odisha 16-13-5. Maharashtra 23-23-6. Jharkhand 607. Goa 208. Punjab 219. Haryana 2nd February 2010. Uttar Pradesh 104 to total 291175 source, Ministry of Law and Justice, Government of India. Majority of states have now set up regular courts at taluka level. Further, reluctance of police officials and other state functionaries to invoke jurisdiction of Gram Nyayalayas, lukewarm response of the bar, non-availability of notaries and stamp vendors, problem of concurrent jurisdiction of regular courts are other issues indicated by the states which are coming in the way of operationalization of the Gram Nyayalayas. The issues affecting operationalization of the Gram Nyayalayas were discussed in the Conference of Chief Justices of High Courts and Chief Ministers of the states in April 2013. It was decided in the conference that the state government and High Court should decide the question of establishment of Gram Nyayalayas wherever feasible, taking into account their local problems. The focus is on setting up Gram Nyayalayas in the talukas where regular courts have not been set up. Table 35.3 articles related to subordinate courts at a glance.
Article No.
Subject matter 233. Appointment of district judges 233A. Validation of appointments of, and judgments, etc., delivered by certain district judges 234. Recruitment of persons other than district judges to the judicial service 235. Control over the subordinate courts 236. Interpretation 237. Application of the provisions of this chapter to certain class or classes of magistrates. Notes and references. 1. The 20th Constitutional Amendment Act of 1966 added a new Article 233-A which retrospectively validated the appointment of certain district judges as well as the judgments delivered by them. 2. In practice, the State Public Service Commission conducts a competitive examination for recruitment to the judicial service of the state. 3. A subordinate judge is also known as civil judge, senior division, civil judge, class I, and so on. He may also be given the powers of an assistant sessions judge. In such a case, he combines in himself both civil as well as criminal powers like that of a district judge. 4. A munsif is also known as civil judge, junior division, civil judge, class 2, and so on. 5. Delhi, Bombay, Calcutta and Madras were formerly called presidency towns. 6. Annual Report 2015-16, Ministry of Law and Justice, Government of India, pp. 91-92. 7. P.T. Thomas v. Thomas Job, 2005. 7. India 2010, a reference annual, Publications Division, Ministry of Information and Broadcasting, Government of India, p. 711. 8. P.T. Thomas v. Thomas Job, 2005. 9. Law Commission of India, Report number 222 entitled as, Need for Justice Dispensation through ADR etc., April 2009, pp. 22-23. 10. Annual Report 2015-16, Ministry of Law and Justice, Government of India, p. 85. 11. Press Information Bureau, Government of India, 29th September 2009. Special Status of Jammu and Kashmir. Under Article 1 of the Indian Constitution, the state of Jammu and Kashmir, J&K, is a constituent state of Indian Union and its territory forms a part of the territory of India. On the other hand, Article 370 in Part 21 of the Constitution grants a special status to it. Accordingly, all the provisions of the Constitution of India do not apply to it. It is also the only state in the Indian Union which has its own separate state constitution, the U Constitution of Jammu and Kashmir. Under the same Part 21 of the Constitution, 12 other states, one of the Indian Union, also enjoy a special status but only in certain minor matters. On the other hand, The special status enjoyed by the state of J&K, as mentioned above, is unparalleled. Accession of J&K to India with the end of the British paramountcy, the state of Jammu and Kashmir, J&K, became independent on 15 August 1947. Initially its ruler, Maharaja Hari Singh, decided not to join India or Pakistan and thereby remain independent. On 20 October 1947, the Azad Kashmir forces supported by the Pakistan Army attacked the frontiers of the state. Under this unusual and extraordinary political circumstance, the ruler of the state decided to accede.
The state to India.
Accordingly, the Instrument of Accession of Jammu and Kashmir to India was signed by Pandit Jawaharlal Nehru and Maharaja Hari Singh on 26 October 1947.2. Under this, the state surrendered only three subjects: defense, external affairs and communications, to the dominion of India. At that time, the government of India made a commitment that the people of this state, through their own constituent assembly, would determine the internal constitution of this state and the nature and extent of the jurisdiction of the Union of India over the state, and until the decision of the Constituent Assembly of the state, the Constitution of India could only provide an interim arrangement regarding the state. 3. In pursuance of this commitment, Article 370 was incorporated in the
Constitution of India.
It clearly states that the provisions with respect to the state of J&K are only temporary and not permanent. It became operative on 17 November 1952, with the following provisions. 1. The provisions of Article 238, dealing with the administration of Part B states, is not applicable to the state of J&K. The state of J&K was specified in the category of Part B states in the original Constitution, 1950. This article in Part 7 was subsequently omitted from the Constitution by the 7th Constitutional Amendment Act, 1956, in the wake of the reorganization of states. 2. The power of Parliament to make laws for the state is limited to a. Those matters in the Union List and the concurrent list which correspond to matters specified in the state's instrument of accession. These matters are to be declared by the President in consultation with the state government. The instrument of accession contained matters classified under 4 heads, namely, external affairs, defense, communications and ancillary matters. b. Such other matters in the Union List and the concurrent list which are specified by the President with the concurrence of the state government. This means that laws can be made on these matters only with the consent of the state of J&K. 3. The provisions of Article 1, declaring India as a union of states and its territory, and this article, that is, Article 370, are applicable to the state of J&K. 4. Besides above, the other provisions of the Constitution can be applied to the state with such exceptions and modifications as specified by the President in consultation with the state government or with the concurrence of the state government. 5. The President can declare that Article 370 ceases to be operative or operates with exceptions and modifications. However, this can be done by the President only on the recommendation of Constituent Assembly of the state. Therefore, Article 370 makes Article 1 and Article 370 itself applicable to the state of J&K at once and authorizes the President to extend other articles to the state. Present relationship between J&K and India. In pursuance of the provisions of Article 370, the President issued an order called the Constitution, Application to Jammu and Kashmir, Order, 1950, to specify the Union's jurisdiction over the state. In 1952, the Government of India and the state of J&K entered into an agreement at Delhi regarding their future relationship. In 1954, the Constituent Assembly of J&K approved the state's accession to India as well as the Delhi Agreement. Then, the President issued another order with the same title, that is, the Constitution, Application to Jammu and Kashmir, Order, 1954. This order superseded the earlier order of 1950 and extended the Union's jurisdiction over the state. This is the basic order that as amended and modified from time to time, regulates the constitutional position of the state and its relationship with the Union. 4 At present, this is as follows. 1. Jammu and Kashmir is a constituent state of the Indian Union and has its place in Part I and Schedule I of the Constitution of India, dealing with the Union and its territory. But its name, area or boundary cannot be changed by the Union without the consent of its legislature. 2. The state of J&K has its own constitution and is administered according to that constitution. Hence, Part 6 of the Constitution of India, dealing with state governments, is not applicable to this state. The very definition of state under this part does not include the state of J&K. 3. Parliament can make laws in relation to the state on most of the subjects enumerated in the Union list and on a good number of subjects enumerated in the concurrent list. 5 But the residuary power belongs to the state legislature except in few matters like prevention of activities involving terrorist acts, questioning or disrupting the sovereignty and territorial integrity of India and causing insult to the national flag, national anthem and the Constitution of India. Further, the power to make laws of preventive detention in the state belongs to the state legislature. This means that the preventive detention laws made by the Parliament are not applicable to the state. 4. Part 3, dealing with fundamental rights, is applicable to the state with some exceptions and conditions. The fundamental right to property is still guaranteed in the state. Also, certain special rights are granted to the permanent residents of the state with regard to public employment, acquisition of immovable property, settlement and government scholarships. 5. Part 4, dealing with directive principles of state policy, and Part IVA, dealing with fundamental duties, are not applicable to the state. 6. A national emergency declared on the ground of internal disturbance will not have effect in the state except with the concurrence of the state government. 6. 7. The President has no power to declare a financial emergency in relation to the state. 8. The President has no power to suspend the constitution of the state on the ground of failure to comply with the directions given by him. 9. The state emergency, President's rule, is applicable to the state. However, this emergency can be imposed in the state on the ground of failure of the constitutional machinery under the provisions of state constitution and not Indian constitution. In fact, two types of emergencies can be declared in the state, namely, President's rule under the Indian constitution and Governor's rule under the state constitution. In 1986, the President's rule was imposed in the state for the first time. 10. International treaty or agreement affecting the disposition of any part of the territory of the state can be made by the centre only with the consent of the state legislature. 11. An amendment made to the Constitution of India does not apply to the state unless it is extended by a presidential order. 12. Official language provisions are applicable to the state only insofar as they relate to the official language of the Union, the official language of interstate and center-state communications and the language of the Supreme Court proceedings. 13. The fifth schedule, dealing with administration and control of scheduled areas and scheduled tribes, and the sixth schedule, dealing with administration of tribal areas, do not apply to the state. 14. The special leave jurisdiction of the Supreme Court and the jurisdictions of the Election Commission and the Controller and Auditor General are applicable to the state. 15. The High Court of J&K can issue writs only for the enforcement of the fundamental rights and not for any other purpose. 16. The provisions of Part 2 regarding the denial of citizenship rights of migrants to Pakistan are not applicable to the permanent residents of J&K, who after having so migrated to Pakistan return to the state for resettlement. Every such person is deemed to be a citizen of India. Therefore, the two characteristic features of the special relationship between the state of J&K and the Union of India, the state has a much greater measure of autonomy and power than enjoyed by the other states, and b. Centre's jurisdiction within the state is more limited than what it has with respect to other states. 7 Features of J&K Constitution. In September-October 1951, the Constituent Assembly of J&K was elected by the people of the state on the basis of adult franchise 2. prepare the future constitution of the state and to determine its relationship with the Union of India. This sovereign body met for the first time on 31st October 1951, and took about 5 years to complete its task. The Constitution of J&K was adopted on 17 November 1956, and came into force on 26 January 1957. Its salient features, as amended from time to time, are as follows. 1. It declares the state of J&K to be an integral part of India. 2. It secures justice, liberty, equality and fraternity to the people of the state. 3. It says that the state of J&K comprises all the territory that was under the ruler of the state on 15 August 1947. This means that the territory of the state also includes the area which is under the occupation of Pakistan. 4. It lays down that a citizen of India is treated as a permanent resident of the state if on 14 May 1954, a. he was a state subject of Class I or Class II, or b. having lawfully acquired immovable property in the state, he has been ordinarily resident in the state for 10 years prior to that date, or c. any person who before 14 May 1954 was a state subject of Class I or Class II and who, having migrated to Pakistan after 1 March 1947, returns to the state for resettlement. 5. It clarifies that the permanent residents of the state are entitled to all rights guaranteed under the Constitution of India. But, any change in the definition of permanent can be made by the state legislature only. 6. It contains a list of directive principles that are to be treated as fundamental in the governance of the state. However, they are not judicially enforceable. 7. It provides for a bicameral legislature consisting of the Legislative Assembly and the Legislative Council. The Assembly consists of 111 members directly elected by the people. 8 out of this, 24 seats are to remain vacant as they are allotted for the area that is under the occupation of Pakistan. Hence, as an interim measure, the total strength of the Assembly is to be taken as 87 for all practical purposes. The Council consists of 36 members, most of them are elected in an indirect manner and some of them are nominated by the Governor, who is also an integral part of the state legislature. 8. It vests the executive powers of the state in the Governor appointed by the President for a term of 5 years. It provides for a council of ministers headed by the Chief Minister to aid and advise the Governor in the exercise of his functions. The Council of Ministers is collectively responsible to the Assembly. Under the original Constitution of J&K, 1957, the head of the state and head of the government were designated as Sadr-i-Riyasat, President, and Wazir-i-Azam, Prime Minister, respectively. In 1965, they were redesignated as Governor and Chief Minister respectively. Also, the head of the state was to be elected by the State Assembly. 9. It establishes a High Court consisting of a Chief Justice and 2 or more other judges. They are appointed by the President in consultation with the Chief Justice of India and the Governor of the state. The High Court of J&K is a court of record and enjoys original, appellate and writ jurisdictions. However, it can issue writs only for the enforcement of fundamental rights and not for any other purpose. 10. It provides for Governor's rule. Hence, the Governor, with the concurrence of the President of India, can assume to himself all the powers of the state government, except those of the High Court. He can dissolve the Assembly and dismiss the Council of Ministers. The Governor's rule can be imposed when the state administration cannot be carried on in accordance with the provisions of the J&K Constitution. It was imposed for the first time in 1977. Notably, in 1964, Article 356 of the Indian Constitution, dealing with the imposition of President's rule in a state, was extended to the state of J&K 11. It declares Urdu as the official language of the state. It also permits the use of English for official purposes unless the state legislature provides otherwise. 12. It lays down the procedure for its amendment. It can be amended by a bill passed in each house of the state legislature by a majority of 2/3 of the total membership of that house. Such a bill must be introduced in the Assembly only. However, no bill of constitutional amendment can be moved in either house if it seeks to change the relationship of the state with the Union of India. J&K Autonomy Resolution rejected on 26 June 2000, in a historic move. The Jammu and Kashmir Legislative Assembly adopted by voice vote a resolution accepting the report of the State Autonomy Committee, recommending greater autonomy to the state. The Assembly sought the following: 1. The word temporary in Article 370 to be substituted with special. 2. Only defense, foreign affairs, communications and ancillary subjects to be with the centre. 3. Article 356 not to apply to J&K. 4. Election Commission of India to have no role. 5. J&K Assembly to have final say on central role in case of external aggression, internal emergency. 6. No room for all India services, IAS, IPS and IFs, in J&K. 7. Governor and Chief Minister to be called Sadari Riyasat and Wazir-e-Azam. 8. Separate Charter of Fundamental Rights for J&K. 9. Parliament's and President's role over J&K to be sharply curtailed. 10. No special leave to appeal by the Supreme Court. 11. No special provisions for scheduled castes, tribes and backward classes. 12. Centre to lose adjudication rights relating to interstate rivers or river valleys. 13. No jurisdiction of the Supreme Court in appeals from the High Court in civil and criminal matters. 14. Parliament not to be empowered to amend the Constitution and procedure with respect to J&K. On 14 July 2000, the Union Cabinet rejected as unacceptable the June 26 Autonomy Resolution of the Jammu and Kashmir Assembly, though at the same time committing itself to a greater devolution of powers to all states. The Cabinet found the June 26 resolution unacceptable because essentially it was a plea for restoration of the pre-1953 status to the state. The Cabinet was unanimous in its judgment that the June 26 resolution could not be accepted, fully or even partially, because it would set the clock back and reverse the natural process of harmonizing the aspirations of the people of Jammu and Kashmir with the integrity of the nation. Specifically about Jammu and Kashmir, the Cabinet wanted the people and the state government to join hands in the endeavor to address the real problems facing the state, to root out insurgency and cross-border terrorism, and to ensure accelerated development. Group of Interlocutors for J&K. The Group of Interlocutors for Jammu and Kashmir was appointed by the central government in October 2010 under the chairmanship of the eminent journalist Dilip Padgaonkar. 9. It was tasked to hold wide-ranging discussions with all sections of opinion in Jammu and Kashmir in order to identify the political contours of a solution to the problems of the state. The group submitted its report to the Union Home Minister in October 2011. The report is entitled, "A New Compact with the People of Jammu and Kashmir." The group did not recommend a pure and simple return to the pre-1953 situation. This would create a dangerous constitutional vacuum in the center-state relationship. The clock cannot be set back. Instead, the group recommended the establishment of a constitutional committee to review all central acts and articles of the Constitution of India extended to the state of Jammu and Kashmir after signing of the Delhi Agreement of 195210. The Constitutional Committee should be headed by a distinguished jurist who enjoys esteem and respect in the state and in the rest of the country. Its members should be constitutional legal experts from the state and the rest of India. Their choice should be acceptable to all stakeholders. In the exercise of its mandate, the Constitutional Committee should bear in mind the dual character of Jammu and Kashmir, viz., that it is a constituent unit of the Indian Union and that it enjoys a special status in the said union, enshrined in Article 370 of the Constitution of India. It should also bear in mind the dual character of the people of the state, viz., that they are both state subjects and Indian citizens. The review should, therefore, have to determine whether and to what extent the central acts and articles of the Constitution of India, extended with or without amendment to the state, have dented Jammu and Kashmir's special status and abridged the state government's powers to cater to the welfare of its people. The Constitutional Committee should be future-oriented in that it should conduct its review solely on the basis of the powers that the state needs to address the political, economic, social and cultural interests, concerns, grievances and aspirations of the people in all the three regions of the state Jammu, Kashmir and Ladakh and all its sub-regions and communities. In this connection, the committee should also need to reflect on the quantum of legislative, financial and administrative powers that the state government should delegate to the three regions at all levels of governance: the regional, district and panchayat municipality. The Constitutional Committee should be requested to complete its work within 6 months. Its recommendations must be reached through consensus,
so that they are acceptable
to all stakeholders represented in the State Assembly and in Parliament. The next step would be for the President, in exercise of the powers conferred by clauses 1 and 3
of Article 370
of the Constitution, to issue an order incorporating the recommendations of the Constitutional Committee. The order would need to be ratified by a bill in both houses of Parliament and by each house in the state legislature by a margin of not less than 2/3 majority of the total membership present and voting in each house. It would then be presented to the President for assent. Once this process is over, clauses 1 and 3 of Article 370 shall cease to be operative and no orders shall be made by the President hereafter under the said clauses as from the date of the final order. The recommendations of the group on certain issues of contention are as follows: 1. Delete the word temporary from the heading of Article 370 and from the title of Part 21 of the Constitution. Replace it with the word special, as it has been used for other states under Article 371, Maharashtra and Gujarat, Article 371A, Nagaland, 371B, Assam, 371C, Manipur, 371D and E, Andhra Pradesh, 371F, Sikkim, 371G, Mizoram, 371H, Arunachal Pradesh, 371I, Goa. 2. On the governor, the state government, after consultations with opposition parties, should submit a list of 3 names to the President. The President can ask for more suggestions if required. The governor should be appointed by the President and hold office at the pleasure of the President. 3. Article 356. The action of the governor is now justiciable in the Supreme Court. The present arrangement should continue with the proviso that the governor should keep the state legislature under suspended animation and hold fresh elections within 3 months. 4. Article 312. The proportion of officers from the All India services should be gradually reduced in favor of officers from the state civil service without curbing administrative efficiency. 5. The nomenclatures in English of the governor and the chief minister should continue as at present. Equivalent nomenclatures in Urdu may be used while referring to the 2 offices in Urdu. 6. Create 3 regional councils, 1 each for Jammu, Kashmir and
Ladakh.
The latter would no longer be a division of Kashmir. Devolve certain legislative, executive and financial powers to them. A further devolution of executive and financial powers to Panchayati Raj institutions at the level of a district, a village panchayat, a municipality or a corporation would be part of the overall package. All these bodies should be elected. Provisions should be made for representation of women, SC Cent, backward clans and minorities. MLAs should be ex officio members with voting rights. 7. Parliament should make no laws applicable to the state unless it relates to the country's internal and external security and its vital economic interest, especially in the areas of energy and access to water resources. 8. Extend the writ of autonomous and statutory institutions to the state and ensure that their functioning conforms to the provisions of the Constitution of Jammu and Kashmir. 9. These changes should be harmonized in all parts of the former princely state. All opportunities for cross-LOC cooperation should be promoted. This would require substantial constitutional changes in Pakistan-administered Jammu and Kashmir. 10. Take all appropriate measures to regard Jammu and Kashmir as a bridge between South and Central Asia. Table 36.1 The Constitution of Jammu and Kashmir at a glance. Parts Subject Matter Sections covered 11I Preliminary 1 to 2 2 The State 3 to 5 3 Permanent Residence 6 to 10 4 Directive Principles of State Policy 11 to 25 We the Executive 26 to 45 6 The State Legislature 46 to 92 7 The High Court 93 to 113 8 Finance, Property and Contracts 114 to 123 9. The Public Services 124 to 137 X Elections 138 to 142 11 Miscellaneous Provisions 143 to 146 12 Amendment of the Constitution 147 13 Transitional Provisions 148 to 158 Table 36.2 Schedules of the J&K Constitution at a glance. Numbers. Subject Matter. First Schedule. Method of election to the Office of Sadar Riyasat, omitted. Second Schedule. Emoluments, allowances and privileges of the Governor. Third Schedule. Salaries and allowances of the Speaker and Deputy Speaker of the Legislative Assembly and the Chairman and the Deputy Chairman of the Legislative Council. Fourth Schedule. Salaries, allowances and other conditions of service of the judges of the High Court. Fifth Schedule. Forms of oaths or affirmations. Sixth Schedule. Regional languages. Seventh Provisions as to disqualification on ground of defection. Schedule. Notes and references. 1. These include Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. 2. It was accepted by the Governor-General of India, Lord Mountbatten, on 27 October 1947. 3. D. Basu, Commentary on the Constitution of India, Prentice Hall, Walwi, 5th edition, 1970, p. 512. 4. This order was amended in 1963, 1964, 1965, 1966, 1972, 1974 and 1986. 5. The concurrent list was not applicable to the state till 1963. The state list is not applicable to the state even today. 6. Unlike in other states, a proclamation of emergency can be made in J&K on the ground of internal disturbance also. An emergency declared on the ground of war or external aggression is directly, i.e., without the concurrence of the state government, as in the case of other states, applicable to J&K. 7. M.P. Jain, Indian Constitutional Law, Wadhwa, 4th edition, 1987, p. 435. 8. Originally, the strength of J&K Assembly was 100 and this was increased to 111 in 1987. 9. The other two members of the group were academician Radha Kumar and former Information Commissioner M.M. Ansari. 10. This agreement, along with the instrument of accession and Article 370 of the Constitution, has been adopted by the Indian Parliament and the Constituent Assembly of Jammu and Kashmir. 11. For the subject matter of each section of the Constitution of Jammu and Kashmir, see Appendix 14. Special provisions for some states. Articles 371 to 371-J in Part 21 of the Constitution contain special provisions for 12 states. 1. Viz. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. The intention behind them is to meet the aspirations of the people of backward regions of the states or to protect the cultural and economic interests of the tribal people of the states or to deal with the disturbed law and order condition in some parts of the states or to protect the interests of the local people of the states. Originally, the Constitution did not make any special provisions for these states. They have been incorporated by the various subsequent amendments made in the context of reorganization of the states or conferment of statehood on the Union territories. Provisions for Maharashtra and Gujarat under Article 371, The President is authorized to provide that the Governor of Maharashtra and that of Gujarat would have special responsibility for 2. 1. The establishment of separate development boards for I. Vidarbha, Marathwada and the rest of Maharashtra, 2. Saurashtra, Kutch and the rest of Gujarat.
2. Making a provision
That a report on the working of these boards would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the above-mentioned areas. And 4. An equitable arrangement providing adequate facilities for technical education and vocational training, and adequate employment opportunities in the state services in respect of the above-mentioned areas. Provisions for Nagaland. Article 371-A makes the following special provisions for Nagaland. 3. 1. The Acts of Parliament relating to the following matters would not apply to Nagaland unless the State Legislative Assembly so decides. I. Religious or social practices of the Nagas. 2. Naga customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Naga customary law. And 4. Ownership and transfer of land and its resources. 2. The Governor of Nagaland shall have special responsibility for law and order in the state so long as internal disturbances caused by the hostile Nagas continue. In the discharge of this responsibility, the Governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. 4. This special responsibility of the Governor shall cease when the President so directs. 3. The Governor has to ensure that the money provided by the central government for any specific purpose is included in the demand for a grant relating to that purpose and not in any other demand moved in the State Legislative Assembly. 4. A regional council consisting of 35 members should be established for the Toensan district of the state. The Governor should make rules for the composition of the council, manner of choosing its members. 5. Their qualifications, term, salaries and allowances, the procedure and conduct of business of the council, the appointment of officers and staff of the council and their service conditions, and any other matter relating to the constitution and proper functioning of the council. 5. For a period of 10 years from the formation of Nagaland or for such further period as the Governor may specify on the recommendation of the regional council, the following provisions would be operative for the Toensan district. I. The administration of the Toensan district shall be carried on by the Governor. 2. The Governor shall in his discretion arrange for equitable distribution of money provided by the centre between Toensan district and the rest of Nagaland. 3. Any act of Nagaland legislature shall not apply to Toensan district unless the Governor so directs on the recommendation of the regional council. 4. The Governor can make regulations for the peace, progress and good government of the Toensan district. Any such regulation may repeal or amend an act of parliament or any other law applicable to that district. There shall be a minister for Toensan affairs in the State Council of Ministers. He is to be appointed from amongst the members representing Toensan district in the Nagaland Legislative Assembly. 6. The final decision on all matters relating to Toensan district shall be made by the Governor in his discretion. 7. Members in the Nagaland Legislative Assembly from the Toensan district are not elected directly by the people but by the regional council. Provisions for Assam and Manipur. Assam. Under Article 371b(6), the President is empowered to provide for the creation of a committee of the Assam Legislative Assembly consisting of the members elected from the tribal areas of the state and such other members as he may specify. 7. Manipur. Article 371-C makes the following special provisions for Manipur. 8. 1. The President is authorized to provide for the creation of a committee of the Manipur Legislative Assembly consisting of the members elected from the hill areas of the state. 9. 2. The President can also direct that the Governor shall have special responsibility to secure the proper functioning of that committee. 3. The Governor should submit an annual report to the President regarding the administration of the hill areas. 4. The central government can give directions to the state government as to the administration of the hill areas. Provisions for Andhra Pradesh or Telangana Articles 371-D and 371-E contain the special provisions for Andhra Pradesh 10. In 2014, Article 371-D has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act of 2014. Under Article 371-D the following are mentioned. 1. The President is empowered to provide for equitable opportunities and facilities for the people belonging to different parts of the state in the matter of public employment and education, and different provisions can be made for various parts of the state. 2. For the above purpose, the President may require the state government to organize civil posts in local cadre for different parts of the state and provide for direct recruitment to posts in any local cadre. He may specify parts of the state which shall be regarded as the local area for admission to any educational institution. He may also specify the extent and manner of preference or reservation given in the matter of direct recruitment to posts in any such cadre or admission to any such educational institution. 3. The President may provide for the establishment of an administrative tribunal in the state to deal with certain disputes and grievances relating to appointment, allotment or promotion to civil posts in the state. 11. The tribunal is to function outside the purview of the state High Court. No court, other than the Supreme Court, is to exercise any jurisdiction in respect of any matter subject to the jurisdiction of the tribunal. The President may abolish the tribunal when he is satisfied that its continued existence is not necessary. Article 371-E empowers the Parliament to provide for the establishment of a central university in the state of Andhra Pradesh. Provisions for Sikkim. The 36th Constitutional Amendment Act of 1975 made Sikkim a full-fledged state of the Indian Union. It included a new Article 371-F containing special provisions with respect to Sikkim. These are as follows. 1. The Sikkim Legislative Assembly is to consist of not less than 30 members. 2. One seat is allotted to Sikkim in the Lok Sabha and Sikkim forms one parliamentary constituency. 3. For the purpose of protecting the rights and interests of the different sections of the Sikkim population, the Parliament is empowered to provide for the number of seats in the Sikkim Legislative Assembly which may be filled by candidates belonging to such sections, and 2. Delimitation of the assembly constituencies from which candidates belonging to such sections alone may stand for election to the assembly. 4. The governor shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of the different sections of the Sikkim population. In the discharge of this responsibility, the governor shall act in his discretion, subject to the directions issued by the President. 5. The President can extend, with restrictions or modifications, to Sikkim any law which is in force in the state of the Indian Union. Provisions for Mizoram. Article 371-G specifies the following special provisions for Mizoram. 12. 1. The Acts of Parliament relating to the following matters would not apply to Mizoram unless the State Legislative Assembly so decides. I. Religious or social practices of the Mizos. 2. Mizo customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Mizo customary law. And 4. Ownership and transfer of land. 2. The Mizoram Legislative Assembly is to consist of not less than 40 members. Provisions for Arunachal Pradesh and Goa. Arunachal Pradesh. Under Article 371-H the following special provisions are made for Arunachal Pradesh. 13. 1. The governor of Arunachal Pradesh shall have special responsibility for law and order in the state. In the discharge of this responsibility, the governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. This special responsibility of the governor shall cease when the President so directs. 2. The Arunachal Pradesh Legislative Assembly is to consist of not less than 30 members. Goa. Article 371-I provides that the Goa Legislative Assembly is to consist of not less than 30 members. 14. Provisions for Karnataka. Under Article 371-J the President is empowered to provide that the Governor of Karnataka would have special responsibility for 1. The establishment of a separate development board for Hyderabad Karnataka region 15-2. Making a provision that a report on the working of the board would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the region. 4. The reservation of seats in educational and vocational training institutions in the region for students who belong to the region. 5. The reservation in state government posts in the region for persons who belong to the region. Article 371-J, which provided for special provisions for the Hyderabad Karnataka region of the state of Karnataka, was inserted in the Constitution by the 98th Constitutional Amendment Act of 2012. The special provisions aim to establish an institutional mechanism for equitable allocation of funds to meet the development needs over the region, as well as to enhance human resources and promote employment from the region by providing for local cadre in service and reservation in educational and vocational training institutions. In 2010, the Legislative Assembly as well as the Legislative Council of Karnataka passed separate resolutions seeking special provisions for the Hyderabad Karnataka region of the state of Karnataka. The government of Karnataka also endorsed the need for special provisions for the region. The resolutions sought to accelerate development of the most backward region of the state and promote inclusive growth with a view to reducing inter-district and inter-regional disparities in the state. Table 37.1 Articles related to special provisions for some states at a glance. Article No. Subject Matter 371. Special provision with respect to the states of Maharashtra and Gujarat. 371A. Special provision with respect to the state of Nagaland. 371B. Special provision with respect to the state of Assam. 371C. Special provision with respect to the state of Manipur. 371D. Special provisions with respect to the state of Andhra Pradesh
or the state of
Telangana. 371E. Establishment of Central University in Andhra Pradesh. 371F. Special provisions with respect to the state of Sikkim. 371G. Special provision with respect to the state of Mizoram. 371H. Special provision with respect to the state of Arunachal Pradesh. 371-I. Special provision with respect to the state of Goa. 371J. Special provisions with respect to the state of Karnataka. Notes and references. 1. Part 21 is entitled as Temporary, Transitional and Special Provisions. 2. This article was amended by the 7th Constitutional Amendment Act of 1956 and the Bombay Reorganization Act of 1960. Andhra Pradesh was taken out of this article by the 32nd Constitutional Amendment Act of 1973 and provided for separately in 2 new articles, 371-D and 371-E3. This article was added by the 13th Constitutional Amendment Act of 1962. 4. The validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in the exercise of his individual judgment. 5. The Deputy Commissioner of the Toinsan district shall be the ex officio chairman of the regional council and the vice chairman shall be elected by the members of the council from amongst themselves. 6. This article was added by the 22nd Constitutional Amendment Act of 1969. 7. The tribal areas of Assam are specified in the 6th schedule of the Constitution. They are North Kutch Hills District, Karbi Anglong District and Bodoland Territorial Areas District. 8. This article was added by the 27th Constitutional Amendment Act of 1971. 9. In this article, the expression, hill areas means such areas as the President may, by order, declare to be hill areas. 10. Both the articles were added by the 32nd Constitutional Amendment Act of 1973. 11. The tribunal has been set up by the Andhra Pradesh Administrative Tribunal Order, 1975. 12. This article was added by the 53rd Constitutional Amendment Act of 1986. 13. This article was added by the 55th Constitutional Amendment Act of 1986. 14. This article was added by the 56th Constitutional Amendment Act of 1987. 15. The Hyderabad Karnataka region includes the 6 backward districts of northern Karnataka, viz. Gulbarga, Bidar, Raichur, Koppal, Yadgir and Bellary. Part V. Local Government 38. Panchayati Raj 39. Municipalities. Panchayati Raj. The term Panchayati Raj in India signifies the system of rural local self-government. It has been established in all the states of India by the Acts T of the state legislatures to build democracy at the grassroots level. 1. It is entrusted with rural development. It was constitutionalized through the 73rd Constitutional Amendment Act of 1992. Evolution of Panchayati Raj. Balwant Rai Mehta Committee. In January 1957, the Government of India appointed a committee to examine the working of the Community Development Programme, 1952, and the National Extension Service, 1953, and to suggest measures for their better working. The chairman of this committee was Balwant Rai Ji Mehta. The committee submitted its report in November 1957 and recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. The specific recommendations made by it are: 1. Establishment of a 3-tier Panchayati Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level and Zilla Parishad at the district level. These tiers should be organically linked through a device of indirect elections. 2. The village Panchayat should be constituted with directly elected representatives, whereas the Panchayat Samiti and Zilla Parishad should be constituted with indirectly elected members. 3. All planning and development activities should be entrusted to these bodies. 4. The Panchayat Samiti should be the executive body while the Zilla Parishad should be the advisory, coordinating and supervisory body. 5. The district collector should be the chairman of the Zilla Parishad. 6. There should be a genuine transfer of power and responsibility to these democratic bodies. 7. Adequate resources should be transferred to these bodies to enable them to discharge their functions and fulfill their responsibilities. 8. A system should be evolved to effect further devolution of authority in future. These recommendations of the committee were accepted by the National Development Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions. But the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on 2 October 1959, in Nagoy district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in 1959. Thereafter, most of the states adopted the system. Though most of the states created Panchayati Raj institutions by mid-1960s, there were differences from one state to another with regard to the number of tiers, relative position of Samiti and Parishad, their tenure, composition, functions, finances and so on. For example, Rajasthan adopted the 3-tier system while Tamil Nadu adopted the 2-tier system. West Bengal, on the other hand, adopted the 4-tier system. Further, in the Rajasthan-Andhra Pradesh pattern, Panchayat Samiti was powerful as the block was the unit of planning and development, while in Maharashtra-Gujarat pattern, Zilla Parishad was powerful as the district was the unit of planning and development. Some states also established Nyaya Panchayats, that is, judicial panchayats to try petty civil and criminal cases. Study teams and committees. Since 1960, many study teams, committees and working groups have been appointed to examine the various aspects of functioning of Panchayati Raj system. They are mentioned below in Table 38.1. Table 38.1 Study teams and committees on Panchayati Raj SL No. Year Name of the Study Team Committee Chairman 1. 1960 Committee on Rationalization of Panchayat Statistics V.R. Rao 2. 1961 Working Group on Panchayats and Cooperatives S.D. Mishra 3. 1961 Study Team on Panchayati Raj Administration V. Iswaran 4. 1962 Study Team on Nyaya Panchayats Gr. Rajgopal 5. 1963 Study Team on the Position of Gram Sabha in Panchayati Raj Movement R. Divakar 6. 1963 Study Group on Budgeting and Accounting Procedure of Panchayati Raj Institutions M. Ramakrishnaya 7. 1963 Study Team on Panchayati Raj Finances K. Santanam 8. 1965 Committee on Panchayati Raj Elections K. Santanam 9. 1965 Study Team on the Audit and Accounts of Panchayati Raj Bodies R. K. Khanna 10. 1966 Committee on Panchayati Raj Training Centers G. Ramachandran Study Team on Involvement of Community Development Agency and Panchayati Raj 11. 1969 Institutions in the Implementation of Basic V. Ramanathan. Land Reform Measures 12. 1972 Working Group for Formulation of Fifth Five-Year Plan on Community Development and Panchayati Raj N. Ramakrishnaya 13. 1976 Committee on Community Development and SMT Daya Panchayati Raj Chobe Ashok Mehta Committee in December 1977. The Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted its report in August 1978 and made 132 recommendations to revive and strengthen the declining Panchayati Raj system in the country. Its main recommendations were: 1. The three-tier system of Panchayati Raj should be replaced by the two-tier system, that is, Zilla Parishad at the district level, and below it, the Mandal Panchayat consisting of a group of villages with a total population of 15,000 to 20,000. 2. A district should be the first point for decentralization under popular supervision below the state level. 3. Zilla Parishad should be the executive body and made responsible for planning at the district level. 4. There should be an official participation of political parties at all levels of Panchayat elections. 5. The Panchayati Raj institutions should have compulsory powers of taxation to mobilize their own financial resources. 6. There should be a regular social audit by a district-level agency and by a committee of legislators to check whether the funds allotted for the vulnerable social and economic groups are actually spent on them. 7. The state government should not supersede the Panchayati Raj institutions. In case of an imperative supersession, elections should be held within 6 months from the date of supersession. 8. The Nyaya Panchayats should be kept as separate bodies from that of development Panchayats. They should be presided over by a qualified judge. 9. The Chief Electoral Officer of a state in consultation with the Chief Election Commissioner should organize and conduct the Panchayati Raj elections. 10. Development functions should be transferred to the Zilla Parishad and all development staff should work under its control and supervision. 11. The voluntary agencies should play an important role in mobilizing the support of the people for Panchayati Raj. 12. A minister for Panchayati Raj should be appointed in the State Council of Ministers to look after the affairs of the Panchayati Raj institutions. 13. Seats for SCs and STs should be reserved on the basis of their population. 14. A constitutional recognition should be accorded to the Panchayati Raj institutions. This would give them the requisite status, sanctity and stature, and an assurance of continuous functioning. Due to the collapse of the Janata government before the completion of its term, no action could be taken on the recommendations of the Ashok Mehta committee at the central level. However, the three states of Karnataka, West Bengal and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the Ashok Mehta committee. G.V.K. Rao Committee. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of G.V.K. Rao was appointed by the Planning Commission in 1985. The committee came to conclusion that the developmental process was gradually bureaucratized and divorced from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is actually called as grass without roots. Hence, the committee made the following recommendations to strengthen and revitalize the Panchayati Raj system. I. The district level body, that is, The Zilla Parishad should be of pivotal importance in the scheme of democratic decentralization. It stated that the district is the proper unit for planning and development, and the Zilla Parishad should become the principal body for management of all development programs which can be handled at that level. 2. The Panchayati Raj institutions at the district and lower levels should be assigned an important role with respect to planning, implementation and monitoring of rural development programs. 3. Some of the planning functions at the state level should be transferred to the district level planning units for effective decentralized district planning. 4. A post of District Development Commissioner should be created. He should act as the Chief Executive Officer of the Zilla Parishad and should be in charge of all the development departments at the district level. Elections to the Panchayati Raj institutions should be held regularly. It found that elections became overdue for 1 or more tiers in 11 states. Thus the committee, in its scheme of decentralized system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. It is in this respect that the recommendation of the G.V.K. Rao Committee Report, 1986, differed from those of the Dantwala Committee Report on Block-Level Planning, 1978, and the Hanumantha Rao Committee Report on District Planning, 1984. Both the committees have suggested that the basic decentralized planning function should be done at the district level. The Hanumantha Rao Committee advocated separate district planning bodies under either the district collector or a minister. In both the models, the collector should play a significant role in the decentralized planning, though the committee stated that Panchayati Raj institutions would also be associated with this process of decentralized planning. The committee recommended that the collector should be the coordinator, at the district level, of all developmental and planning activities. Thus the Hanumantha Rao Committee differed in this respect from those of Balwantaraye Mehta Committee, the Administrative Reforms Commission of India, the Ashok Mehta Committee, and finally the G.V.K. Rao Committee, which recommended reduction in the developmental role of the district collector and which assigned a major role to the Panchayati Raj in development administration. L.M. Singhvi Committee.
In
1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development, under the chairmanship of L.M. Singhvi. It made the following recommendations. I. The Panchayati Raj institutions should be constitutionally recognized, protected and preserved. For this purpose, a new chapter should be added in the Constitution of India. This will make their identity and integrity reasonably and substantially inviolate. It also suggested constitutional provisions to ensure regular, free and fair elections to the Panchayati Raj bodies. 2. Nyaya Panchayats should be established for a cluster of villages. 3. The villages should be reorganized to make Gram Panchayats more viable. It also emphasized the importance of the Gram Sabha and called it as the embodiment of direct democracy. 4. The village panchayats should have more financial resources. The judicial tribunals should be established in each state to adjudicate controversies about election to the Panchayati Raj institutions, their dissolution and other matters related to their functioning. Pungan Committee in 1988, a subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P.K. Pungan to examine the political and administrative structure in the district for the purpose of district planning. This committee suggested for the strengthening of the Panchayati Raj system. It made the following recommendations. 1. The Panchayati Raj bodies should be constitutionally recognized. 2. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. Jilla Parishad should be the pivot of the Panchayati Raj system. It should act as the planning and development agency in the district. 4. The Panchayati Raj bodies should have a fixed tenure of 5 years. 5. The maximum period of supersession of a body should be 6 months. 6. A planning and coordination committee should be set up at the state level under the chairmanship of the Minister for Planning. The presidents of
Jilla Parishad should be its members.
7. A detailed list of subjects for Panchayati Raj should be prepared and incorporated in the constitution.
8.
8. Reservation of seats in all the 3 tiers should be on the basis of population. There should also be reservation for women. 9. A state finance commission should be set up in each state. It would lay down the criteria and guidelines for the devolution of finances to the Panchayati Raj institutions. 10. The district collector should be the chief executive officer of the Jilla Parishad. Gadgil Committee. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V. N. Gadgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. In this context, the committee made the following recommendations. 1. A constitutional status should be bestowed on the Panchayati Raj institutions. 2. A 3-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. The term of Panchayati Raj institutions should be fixed at 5 years. 4. The members of the panchayats at all the 3 levels should be directly elected. 5. Reservation for SCs, STs and women. 6. The Panchayati Raj bodies should have the responsibility of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified in the constitution. 7. The Panchayat Raj bodies should be empowered to levy, collect and appropriate taxes and duties. 8. Establishment of a state finance commission for the allocation of finances to the panchayats. 9. Establishment of a state election commission for the conduction of elections to the panchayats.
The above recommendations of the
Gadgil Committee became the basis for drafting an amendment bill aimed at conferring the constitutional status
and protection to the
Panchayati Raj institutions. Constitutionalization. Rajiv Gandhi government. The Rajiv Gandhi government introduced the 64th Constitutional Amendment Bill in the Lok Sabha in July 1989 to constitutionalize Panchayati Raj institutions and make them more powerful and broad-based. Although the Lok Sabha passed the bill in August 1989, it was not approved by the Rajya Sabha. The bill was vehemently opposed by the opposition on the ground that it sought to strengthen centralization in the federal system. V.P. Singh government. The National Front government, soon after assuming office in November 1989 under the Prime Ministership of V.P. Singh, announced that it would take steps to strengthen the Panchayati Raj institutions. In June 1990, a 2-day conference of the state chief ministers under the chairmanship of V.P. Singh was held to discuss the issues relating to the strengthening of the Panchayati Raj bodies. The conference approved the proposals for the introduction of a fresh constitutional amendment bill. Consequently, a constitutional amendment bill was introduced in the Lok Sabha in September 1990. However, the fall of the government resulted in the lapse of the bill. Narasimha Rao government. The Congress government under the Prime Ministership of P.V. Narasimha Rao once again considered the matter of the constitutionalization of Panchayati Raj bodies. It drastically modified the proposals in this regard to delete the controversial aspects and introduced a constitutional amendment bill in the Lok Sabha in September 1991. This bill finally emerged as the 73rd Constitutional Amendment Act, 1992 and came into force on 24th April, 1932. 73 are the Amendment Acts of 1992.
Significance of the act.
This act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243-0. In addition, the Act has also added a new 11th schedule to the Constitution. This schedule contains 29 functional items of the Panchayats. It deals with Article 243-G. The Act has given a practical shape to Article 40 of the Constitution, which says that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This article forms a part of the directive principles of state policy. The Act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The provisions of the Act can be grouped into two categories, compulsory and voluntary. The compulsory, mandatory or obligatory, provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. The voluntary provisions, on the other hand, may be included at the discretion of the states. Thus, the voluntary provisions of the Act ensures the right of the states to take local factors like geographical, political, administrative and others into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transfers the representative democracy into participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. The salient features of the Act are: Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral rolls of a village comprised within the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of the Panchayat. It may exercise such powers and perform such functions at the village level as the legislature of the state determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate, and district levels 3. Thus, the Act brings about uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not constitute panchayats at the intermediate level. Election of members and chairpersons. All the members of panchayats at the village, intermediate and district levels shall be elected directly by the people. Further, the chairperson of panchayats at the intermediate and district levels shall be elected indirectly, by and from amongst the elected members thereof. However, the chairperson of a panchayat at the village level shall be elected in such manner as the state legislature determines. Reservation of seats. The Act provides for the reservation of seats for scheduled castes and scheduled tribes in every panchayat, i.e., at all the three levels, in proportion of their population to the total population in the panchayat area. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other level for the SCs and STs. The Act provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging the SCs and STs. Further, not less than 1/3 of the total number of offices of chairpersons in the panchayats at each level shall be reserved for women. The Act also authorizes the legislature of a state to make any provision for reservation of seats in any panchayat or offices of chairperson in the panchayat at any level in favor of backward classes. Duration of panchayats. The Act provides for a 5-year term of office to the panchayat at every level. However, it can be dissolved before the completion of its term. Further, fresh elections to constitute a panchayat shall be completed, a. before the expiry of its duration of 5 years, or b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved panchayat would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new panchayat for such period. Moreover, a panchayat constituted upon the dissolution of a panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panchayat would have continued had it not been so dissolved. In other words, a panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. Disqualifications. A person shall be disqualified for being chosen as or for being a member of panchayat if he is so disqualified, a. under any law for the time being in force for the purpose of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission, the superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the panchayats shall be vested in the State Election Commission. It consists of a state election commissioner to be appointed by the governor. His conditions of service and tenure of office shall also be determined by the governor. He shall not be removed from the office except in the manner and on the grounds prescribed for the removal of a judge of the State High Court for. His conditions of service shall not be varied to his disadvantage after his appointment. The state legislature may make provision with respect to all matters relating to elections to the panchayats. Powers and functions. The state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th schedule. Finances. The state legislature may a. authorize the panchayat to levy, collect and appropriate taxes, duties, tolls and fees, b. assign to a panchayat taxes, duties, tolls and fees levied and collected by the state government, c. provide for making grants in it to the panchayats from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the panchayats. Finance Commission. The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayats. It shall make the following recommendations to the governor: 1. The principles that should govern a. the distribution between the state and the panchayats of the net proceeds of the taxes, duties, tolls and fees levied by the state. b. the determination of taxes, duties, tolls and fees that may be assigned to the panchayats. c. the grants in it to the panchayats from the consolidated fund of the state. 2. the measures needed to improve the financial position of the panchayats. 3. any other matter referred to it by the governor in the interests of sound finance of the panchayats. The state legislature may provide for the composition of the commission, the required qualifications of its members and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the states, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by the panchayats and the auditing of such accounts. Application to Union Territories. The President of India may direct that the provisions of this Act shall apply to any Union Territory subject to such exceptions and modifications as he may specify. Exempted states and areas. The Act does not apply to the states of Jammu and Kashmir, Nagaland, Meghalaya and Mizoram and certain other areas. These areas include a. the scheduled areas and the tribal areas in the states 5, b. the hill area of Manipur for which a district council exists, and c. Darjeeling district of West Bengal for which Darjeeling Gorkha Hill Council exists. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. Continuance of existing laws and panchayats. All the state laws relating to panchayats shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new Panchayati Raj system based on this Act within the maximum period of 1 year from 24 April 1993, which was the date of the commencement of this Act. However, all the panchayats existing immediately before the commencement of Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Consequently, majority of states passed the Panchayati Raj Acts in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. But to interference by courts in electoral matters, the Act bars the interference by courts in the electoral matters of panchayats. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 11th schedule. It contains the following 29 functional items placed within the purview of panchayats. 1. Agriculture, including agricultural extension. 2. Land improvement, implementation of land reforms, land consolidation and soil conservation. 3. Minor irrigation, water management and watershed development. 4. Animal husbandry, dairying and poultry. 5. Fisheries. 6. Social forestry and farm forestry. 7. Minor forest produce. 8. Small-scale industries, including food processing industries. 9. Khadi, village and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways and other means of communication. 14. Rural electrification, including distribution of electricity. 15. Non-conventional energy sources. 16. Poverty alleviation program. 17. Education, including primary and secondary schools. 18. Technical training and vocational education. 19. Adult and non-formal education. 20. Libraries. 21. Cultural activities. 22. Markets and fairs. 23. Health and sanitation, including hospitals, primary health centers and dispensaries. 24. Family welfare. 25. Women and child development. 26. Social welfare, including welfare of the handicapped and mentally retarded. 27. Welfare of the weaker sections, and in particular, of the scheduled castes and the scheduled tribes. 28. Public distribution system. 29. Maintenance of community assets. Compulsory and voluntary provisions. Now, we will identify separately the compulsory, obligatory or mandatory, and voluntary, discretionary or optional, provisions, features, of the 73rd Constitutional Amendment Act, 1992, or the Part 9 of the Constitution. A compulsory provisions. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of panchayats at the village, intermediate and district levels. 3. Direct elections to all seats in panchayats at the village, intermediate and district levels. 4. Indirect elections to the post of chairperson of panchayats at the intermediate and district levels. 5. 21 years to be the minimum age for contesting elections to panchayats. 6. Reservation of seats, both members and chairpersons, for SCs and STs in panchayats at all the 3 levels. 7. Reservation of 1/3 seats, both members and chairpersons, for women in panchayats at all the 3 levels. 8. Fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any panchayat. 9. Establishment of a state election commission for conducting elections to the panchayats. 10. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. B. Voluntary provisions. 1. Giving representation to members of the parliament, both the houses and the state legislature, both the houses, in the panchayats at different levels falling within their constituencies. 2. Providing reservation of seats, both members and chairpersons, for backward classes in panchayats at any level. 3. Granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. 4. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice, and to perform some or all of the 29 functions listed in the 11th schedule of the Constitution. 5. Granting financial powers to the panchayats, that is, authorizing them to levy, collect and appropriate taxes, duties, tolls and fees. PSA Act of 1996, Extension Act. The provisions of Part 9 of the Constitution relating to the panchayats are not applicable to the 5th schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the Provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, popularly known as the PSA Act or the Extension Act. At present, 2016, 10 states have 5th schedule areas. These are Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PSA Act are as follows. 6. 1. To extend the provisions of Part 9 of the Constitution relating to the panchayats to the scheduled areas with certain modifications. 2. To provide self-rule for the bulk of the tribal population. 3. To have village governance with participatory democracy and to make the Gram Sabha a nucleus of all activities. 4. To evolve a suitable administrative framework consistent with traditional practices. 5. To safeguard and to preserve the traditions and customs of tribal communities. 6. To empower panchayats at the appropriate levels with specific powers conducive to tribal requirements. 7. To prevent panchayats at the higher level from assuming the powers and authority of panchayats at the lower level of the Gram Sabha. Features of the Act. The features, or the provisions, of the PSA Act are as follows. 1. A state legislation on the panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. 2. A village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. 3. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. 4. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources and the customary mode of dispute resolution. 5. Every Gram Sabha shall, I. Approve of the plans, programs and projects for social and economic development before they are taken up for implementation by the panchayat at the village level, and 2. Be responsible for the identification of beneficiaries under the poverty alleviation and other programs. 6. Every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs and projects. 7. The reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of panchayats at all levels shall be reserved for the scheduled tribes. 8. The state government may nominate such scheduled tribes which have no representation in the panchayat at the intermediate level or the panchayat at the district level. But such nomination shall not exceed 1/10 of the total members to be elected in that panchayat. 9. The Gram Sabha or the panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, the actual planning and implementation of the projects in the scheduled areas shall be coordinated at the state level. 10. Planning and management of minor water bodies in the scheduled areas shall be entrusted to panchayats at the appropriate level. 11. The recommendations of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining lease for minor minerals in the scheduled areas. 12. The prior recommendation of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 13. While endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with I. The power to enforce prohibition or to regulate or restrict the sale and consumption of any intoxicant. 2. The ownership of minor forest produce. 3. The power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawfully alienated land of a scheduled tribe. 4. The power to manage village markets. The power to exercise control over money lending to the scheduled tribes. 6. The power to exercise control over institutions and functionaries in all social sectors. 7. The power to control local plans and resources for such plans including tribal subplans. 14. The state legislations shall contain safeguards to ensure that panchayats at the higher level do not assume the powers and authority of any panchayat at the lower level or of the Gram Sabha. 15. The state legislature shall endeavour to follow the pattern of the 6th schedule to the constitution while designing the administrative arrangements in the panchayats at district levels in the scheduled areas. 16. Any provision of any law relating to panchayats in the scheduled areas, which is inconsistent with the provisions of this act shall cease to be enforced at the expiry of 1 year from the date on which this act receives the assent of the President. 7. However, all the panchayats existing immediately before such date shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Finances of Panchayati Raj. The Second Administrative Reforms Commission of India, 2005 to 2009, has summarized the sources of revenue of the Panchayati Raj institutions, PRIs, and their financial problems in the following way. 7a. 1. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRIs, but the real strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways: I. Grants from the Union Government based on the recommendations of the Central Finance Commission as per Article 280 of the Constitution. 2. Devolution from the State Government based on the recommendations of the State Finance Commission as per Article 243-I. 3. Loans grants from the State Government. 4. Program-specific allocation under centrally sponsored schemes and additional central assistance. Internal resource generation, tax and non-tax. 2. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka and Tamil Nadu are the states which are considered to be progressive in PRI's empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. I. Internal resource generation at the panchayat level is weak. This is partly due to a thin tax domain and partly due to panchayats' own reluctance in collecting revenue. 2. Panchayats are heavily dependent on grants from union and state governments. 3. A major portion of the grants both from union as well as the state governments is scheme specific. Panchayats have limited discretion and flexibility in incurring expenditure. 4. In view of their own tight fiscal position, state governments are not keen to devolve funds to panchayats. In most of the critical 11th schedule matters like primary education, healthcare, water supply, sanitation and minor irrigation, even now, it is the state government which is directly responsible for implementation of these programs and hence expenditure. 6. Overall, a situation has been created where panchayats have responsibility but grossly inadequate resources. 3. Though, in absolute terms, the quantum of funds the union state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources, it is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens. For in terms of own resource collection, the Gram Panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees and non-tax revenue for generating internal resources. 5 state Panchayati Raj Acts have given most of the taxation powers to
Village Panchayats.
The revenue domain of the intermediate and district Panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and conservancy services, registration of vehicles, cess on stamp duty and a few others. 6. A study of various state legislations indicates that a number of taxes, duties, tolls and fees come under the jurisdiction of the village panchayats. These inter alia include octroi, property house tax, profession tax, land tax cess, taxes tolls on vehicles, entertainment tax fees, license fees, tax on non-agriculture land, fee on registration of cattle, sanitation drainage conservancy tax, water rate tax, lighting rate tax, education cess and tax on fairs and festivals. Reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act, 1992, the performance of the Panchayati Raj institutions, PRIs, has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. 7b. 1. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3 Fs, i.e., functions, funds and functionaries, to the PRIs to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRIs have resources to match the responsibilities entrusted to them. While SFCs, State Finance Commissions, have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRIs. 2. Excessive control by bureaucracy. In some states, the Gram Panchayats have been placed in a position of subordination. Hence, the Gram Panchayat Sarpanches have to spend extraordinary amount of time visiting block offices for funds and or technical approval. These interactions with the block staff office distort the role of Sarpanches as elected representatives. 3. Tied nature of funds. This has 2 implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. 4. Overwhelming dependency on government funding. A review of money received and own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. 5. Reluctance to use fiscal powers. An important power devolved to GP, Gram Panchayat, is the right to levy tax on property, business, markets, fairs and also for services provided, like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. 6. Status of the Gram Sabha. Empowering the Gram Sabhas could have been a powerful weapon for transparency, accountability and for involvement of the marginalized sections. However, a number of the state acts have not spelled the powers of Gram Sabhas nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. 7. Creation of parallel bodies. Often, parallel bodies, PBs, are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBs have avoided the evils including that of partisan politics, sharing of spoils, corruption and elite capture. Missions, in particular, often bypassing mainstream programs, create disconnect, duality, and alienation between the existing and the new structures and functions. PBs usurp the legitimate space of PRIs and demoralize the PRIs by virtue of their superior resource endowments. 8. Poor infrastructure. A large number of Gram Panchayats in the country do not have even full-time secretary. Around 25% of the Gram Panchayats do not have basic office buildings. The database for planning, monitoring etc. are lacking in most of the cases. A large number of elected representatives of PRIs are semi-literate or literate and know little about their roles and responsibilities, programs, procedures, systems. Often for want of good, relevant and periodic training, they are not able to perform their functions properly. Although all the district and intermediate panchayats are connected with computers, only around 20% Gram Panchayats reported to be having computing facility. In some states, village panchayats do not have any computing facility. Table 38.2 articles related to panchayats at a glance. Article No. Subject matter 243. Definitions 243a. Gram Sabha 243b. Constitution of Panchayats 243c. Composition of Panchayats 243d. Reservation of seats 243e. Duration of Panchayats, and so on 243f. Disqualifications for membership 243g. Powers, authority and responsibilities of Panchayats 243h. Powers to impose taxes by, and funds of, the Panchayats 243-I. Constitution of Finance Commission to review financial position 243j. Audit of accounts of Panchayats 243k. Elections to the Panchayats 243l. Application to Union Territories 243m. Part not to apply to certain areas 243n. Continuance of existing laws and Panchayats 243-O but to interference by courts in electoral matters. Table 38.3 Name and number of Panchayats, 2010, 8.
SL No.
State Panchayati Raj institutions, including ADCs, number 1. Andhra Pradesh 1. Gram Panchayats 2. Mandal Parishads 3. Jilla Parishads 2 1809, 1097 2022. Arunachal Pradesh 1. Gram Panchayats 2. Anchal Samitis 3. Jilla Parishads 1751 150 16 3. Assam 1. Goan Panchayats 2. Ankalik Panchayats 3. Jilla Parishads 4. Autonomous District Councils 2202 185 24 4. Bihar 1. Village Panchayats 2. Panchayat Samitis 3. Jilla Parishads 8463 531 38 5. Chhattisgarh 1. Gram Panchayats 2. Janpad Panchayats 3. Jilla Panchayats 9820 146 16 6. Goa 1. Village Panchayats 2. Jilla Panchayats 189 27. Gujarat 1. Village Panchayats 2. Taluka Panchayats 3. District Panchayats 13,738 224 26 8. Haryana 1. Gram Panchayats 2. Panchayat Samitis 3. Jilla Parishads 6,187 119 19 9. Himachal Pradesh 1. Gram Panchayats 2. Panchayat Samitis 3. Jilla Panchayats 3,243 75 12 10. Jammu and Kashmir 1. Halka Panchayats 4,139. 1 Gram Panchayats 4,562 11. Dharwad 2. Panchayat Samitis 212 3. Jilla Panchayats 24 1. Gram Panchayats 5652 12. Karnataka 2. Taluka Panchayats 176 3. Jilla Panchayats 29 1. Village Panchayats 999 13. Kerala 2. Block Panchayats 152 3. District Panchayats 14 1. Village Panchayats 23,040 14. Madhya Pradesh 2. Block Panchayats 313 3. District Panchayats 48 1. Village Panchayats 27,916 15. Maharashtra 2. Panchayat Samitis 351 3. Jilla Parishads 33 1. Gram Panchayats 165 16. Manipur 2. Jilla Panchayats 4 3. Autonomous District Councils 6 17. Meghalaya 1. Autonomous District Councils 318. Mizoram 1. Village Councils 707 19. Nagaland 1. Village Councils 1110 1. Gram Panchayats 6234 20. Odisha 2. Panchayat Samitis 314 3. Jilla Parishads 31. Gram Panchayats 12,447 21. Punjab 2. Panchayat Samitis 141 3. Jilla Parishads 21. Gram Panchayats 9,184 22. Rajasthan 2. Panchayat Samitis 237 3. Jilla Parishads 32. 23 Sikkim 1. Gram Panchayats 2. Jilla Panchayats 163 4 24. Tamil Nadu 1. Village Panchayats 2. Panchayat Unions 3. District Panchayats 12,618 385 29 1. Gram Panchayats 513 25. Tripura 2. Panchayat Samitis 3. Jilla Panchayats 2344. Autonomous District Councils 11. Gram Panchayats 52,026. Uttar Pradesh 2. Kshetra Panchayats 823. Jilla Panchayats 71. Gram Panchayats 7,227 27. Uttarakhand 2. Intermediate Panchayats 95 3. District Panchayats 13 1. Gram Panchayats 3,354 28. West Bengal 2. Panchayat Samitis 341 3. Jilla Parishads 18 All India 1. Gram Village Panchayats, including village councils, 2. Panchayat Samitis 3. Jilla Panchayats 4. Autonomous District Council.
For Autonomous District Council 239, 432, 60875.
14 Table 38.4 Milestones in the evolution of Panchayati Raj 9I towards first generation Panchayats 1948 Constituent Assembly debates on the role of Panchayati Raj in 49 Indian polity 1950. The Constitution of India comes into force on 26 January. Directive principles of state policy mention village panchayats as units of self-government, Art 40. 1952 Community Development Program starts on 2nd October 1957. Balvantarai Mehta Committee, appointed in January, submits its report on 24 November 1958 to 1960. Several state governments enact new Panchayat Acts bringing in three-tier Panchayat system. 1959 Jawaharlal Nehru inaugurates the first generation Panchayat at Nagoy in Rajasthan. On 2nd October Kerala District Council Bill is introduced in Kerala Assembly, lapses after Assembly is dissolved. 1964 Decline of first generation Panchayati Raj institutions. 77-2 Growth and decline of second-generation panchayats. Panchayat elections are held in West Bengal on party basis on 4th June, marking the beginning of second generation of panchayati. 1978 Raj Ashok Mehta Committee on Working of Panchayats, appointed on 12 December 1977, submits its report on 21 August 1983. Karnataka government enacts new PR Act. 1984 Hanumantha Rao Committee on District Level Planning, appointed by Planning Commission in September 1982, submits its report in May 1985. Karnataka PR Act receives President's assent in July, comes into force on 14 August 1985. GVK Rao Committee on Administrative Aspects of Rural Development, appointed by Planning Commission on 25 March, submits its report in December 1986. Andhra Pradesh follows West Bengal and Karnataka Panchayati Raj model. 1987 Karnataka holds Panchayat elections in January. 1990 to 1992 Panchayats are dissolved and brought under administrators in Karnataka. 3. Constitutionalization of Panchayati Raj. 1986 LM Singhvi Committee submits its report on 27 November, recommends constitutional status for Panchayats. 1988 Consultative Committee of Parliament appoints a subcommittee under chairpersonship of P.K. Pungan to consider constitutional amendment. 1989 64th Constitutional Amendment Bill is introduced in Parliament on 15 May. Is defeated in Rajya Sabha on 15 October 1990. 74th Constitutional Amendment Bill is introduced in Parliament on 7 September. Lapses on dissolution of Lok Sabha. 1991 72nd, Panchayats, and 73rd, municipalities, amendment bills are introduced in Parliament, referred to the Parliament's Joint Select Committee in September 1992. Lok Sabha passes both the bills on 22nd December. Rajya Sabha passes them on 23rd December 1993. 73rd Amendment Act, 1992 comes into force on 24th April. 74th Amendment Act, 1992 comes into force on 1st June 1993 to 1994. All state governments pass conformity acts between 30th May 1993 and 23rd April 1994. 1994. Madhya Pradesh holds Panchayat elections under the 73rd Amendment dispensation on 30th May 1996. Provisions of the Panchayats, Extension to the Scheduled Areas Act, 1996, extending 73rd Amendment Act to Scheduled Areas, comes into force on 24th December. Kerala launches People's Plan campaign on 16th August 2001. Bihar holds Panchayat elections after 23 years, 11 to 30 April. 83rd Constitutional Amendment Act, 2000 amends Art. 243-M to 2001 dispense with reservations for scheduled castes in Arunachal Pradesh, paving way for Panchayat elections in the only state yet to hold them under the new dispensation. Table 38.5 Committees related to Panchayati Raj, after constitutionalization, SL No. Name of the committee chairman appointed in reported in 1. Task Force on Devolution of Powers and Functions to Panchayati Raj Institutions Lalit Mathur 2001-2001. 2. Expert Group on Planning at the Grassroots Level V. Ramachandran 2005-2006. 3. Task Force for Preparation of a Manual for District Planning SMT Rajwant Sandhu 2008-2008. 4. Committee on Restructuring of DRDA, District Rural Development Agency, V. Ramachandran 2010-2012. Expert Committee on Leveraging Panchayats Mani Shankar 5. For Efficient Delivery a year 2012-2013 of Public Goods and Services.
Notes and references 1.
The subject of local government is mentioned in the state list under the 7th schedule of the Constitution. 2. This bill was passed by the Lok Sabha on 22nd December 1992 and by the Rajya Sabha on 23rd December 1992. Later, it was approved by the 17 state assemblies and received the assent of the President on 20th April 1993. 3. The Act defines all these terms in the following manner. A. Panchayat means an institution, by whatever name called, of self-government for rural areas. B. Village means a village specified by the governor by public notification to be a village for this purpose, and includes a group of villages so specified. C. Intermediate level means a level between the village and district levels specified by the governor by public notification for this purpose. D. District means a district in a state. 4. A judge of a high court can be removed from his office by the President on the recommendation of the Parliament. This means that a state election commissioner cannot be removed by the governor, though appointed by him. 5. At present, 2016, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. Presently, 2016, there are a total of 10 tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. 6. S.K. Singh, Panchayats in Scheduled Areas, Kurukshetra, May 2001, p.26. 7. This Act received the assent of the President on 24 December 1996. 7. A Second Administrative Reforms Commission, Government of India, Report on Local Governance, 2007, pp.151-154. 7b Ministry of Panchayati Raj, Government of India, Roadmap for the Panchayati Raj, 2011-16, pp.11-12, 23 and 7-8. 8. Report of the 13th Finance Commission, 2010-2015, Volume 2, December 2009, p.424426. 9. Panchayati Raj Update, October 2002, Institute of Social Sciences, New Delhi.
Municipalities, term,
urban local government, in India signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area T which is demarcated for this purpose by the state government. 1. There are 8 types of urban local governments in India: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust and special purpose agency. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. At the central level, the subject of urban local government is dealt with by the following 3 ministries. I. Ministry of Urban Development, created as a separate ministry in 1985. 2. Ministry of Defence in the case of cantonment boards. 3. Ministry of Home Affairs in the case of Union Territories. Evolution of urban bodies. Historical perspective. The institutions of urban local government originated and developed in modern India during the period of British rule. The major events in this context are as follows. In 1687 to 88, the first municipal corporation in India was set up at Madras. 2. In 1726, the municipal corporations were set up in Bombay and Calcutta. 3. Lord Mayo's resolution of 1870 on financial decentralization visualized the development of local self-government institutions. 4. Lord Ripon's resolution of 1882 has been hailed as the Magna Carta of local self-government. He is called as the father of local self-government in India. The Royal Commission on Decentralization was appointed in 1907 and it submitted its report in 1909. Its chairman was Hobhouse. 6. Under the Jatiya scheme introduced in provinces by the Government of India Act of 1919, local self-government became a transferred subject under the charge of a responsible Indian minister. 7. In 1924, the Cantonments Act was passed by the central legislature. 8. Under the Provincial Autonomy Scheme introduced by the Government of India Act of 1935, local self-government was declared a provincial subject. Committees and commissions. The committees and commissions appointed by the central government to improve the functioning of urban local governments are mentioned below in Table 39.1. Table 39.1 Committees and Commissions on Urban Local Governments SL No. Year Name of the Committee Commission Chairman 1. 1949-51 Local Finance Enquiry Committee PK Wattle 2. 1953-54 Taxation Enquiry Commission John Mathur 3. 1963-65 Committee on the Training of Municipal Employees Nuruddin Ahmed. 4. 1963-66 Rural Urban Relationship Committee AP Jain 5. 1963 Committee of Ministers on Augmentation of Financial Resources of Urban Local Bodies Rafiq Zakaria 6. 1965-68 Committee on Service Conditions of Municipal Employees 7. 1974 Committee on Budgetary Reform in Municipal Administration Girijapati Mukherjee 8. 1982 Study Group on Constitution, Powers and Laws of Urban Local Bodies and Municipal Corporations KN Sahai 9. 1985 National Commission on Urbanization CM 88 Korea Constitutionalization in August 1989, the Rajiv Gandhi government introduced the 65th Constitutional Amendment Bill, i.e., Nagarpalika Bill, in the Lok Sabha. The bill aimed at strengthening and revamping the municipal bodies by conferring a constitutional status on them. Although the bill was passed in the Lok Sabha, it was defeated in the Rajya Sabha in October 1989 and hence, lapsed. The National Front government under VP Singh introduced the revised Nagarpalika bill in the Lok Sabha again in September 1990. However, the bill was not passed and finally lapsed due to the dissolution of the Lok Sabha. P.V. Narasimha Rao's government also introduced the Modified Municipalities Bill in the Lok Sabha in September 1991. It finally emerged as the 74th Constitutional Amendment Act of 1992 and came into force on 1 June 1932. 74th Amendment Act of 1992. This act has added a new Part 9A to the Constitution of India. This part is entitled as the Municipalities and consists of provisions from Articles 243p to 243zg. In addition, the Act has also added a new 12th Schedule to the Constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243-W. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Act. The Act aims at revitalizing and strengthening the urban governments so that they function effectively as units of local government. Salient features. The salient features of the Act are: 3 types of municipalities. The Act provides for the constitution of the following 3 types of municipalities in every state. 1. A Nagar Panchayat, by whatever name called, for a transitional area, that is, an area in transition from a rural area to an urban area. 2. A municipal council for a smaller urban area. 3. A municipal corporation for a larger urban area. 3. Composition. All the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. It may also provide for the representation of the following persons in a municipality. 1. Persons having special knowledge or experience in municipal administration without the right to vote in the meetings of municipality. 2. The members of the Lok Sabha and the State Legislative Assembly representing constituencies that comprise wholly or partly the municipal area. 3. The members of the Rajya Sabha and the State Legislative Council registered as electors within the municipal area. 4. The chairpersons of committees, other than wards committees. Wards committees, there shall be constituted a wards committee, consisting of one or more wards, within the territorial area of a municipality having population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a wards committee shall be filled. It may also make any provision for the constitution of committees in addition to the wards committees. Reservation of seats. The Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and the STs. The state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SCs, STs and women. It may also make any provision for the reservation of seats in any municipality or offices of chairpersons in municipalities in favor of backward classes. Duration of municipalities. The Act provides for a 5-year term of office for every municipality. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed, a. before the expiry of its duration of 5 years, or b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved municipality would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. Disqualifications. A person shall be disqualified for being chosen as or for being a member of a municipality if he is so disqualified, a. under any law for the time being in force for the purposes of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Powers and functions. The state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the delegation of powers and responsibilities upon municipalities at the appropriate level with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th schedule. Finances. The state legislature may a. authorize a municipality to levy, collect and appropriate taxes, duties, tolls and fees, b. assign to a municipality taxes, duties, tolls and fees levied and collected by state government, c. provide for making grants in aid to the municipalities from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the municipalities. Finance Commission. The Finance Commission, which is constituted for the panchayats, shall also, for every 5 years, review the financial position of municipalities and make recommendation to the governor as to 1. the principles that should govern the distribution between the state and the municipalities, the net proceeds of the taxes, duties, tolls and fees levied by the state, b. The determination of the taxes, duties, tolls and fees that may be assigned to the municipalities. c. The grants in aid to the municipalities from the consolidated fund of the state. 2. The measures needed to improve the financial position of the municipalities. 3. Any other matter referred to it by the governor in the interests of sound finance of municipalities. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by municipalities and the auditing of such accounts. Application to Union Territories. The President of India may direct that the provisions of this Act shall apply to any Union Territory subject to such exceptions and modifications as he may specify. Exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states for. It shall also not affect the functions and powers of the Darjeeling Gorkha Hill Council of the West Bengal. District Planning Committee. Every state shall constitute at the district level a district planning committee to consolidate the plans prepared by panchayats and municipalities in the district, and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The functions of such committees in relation to district planning. And 4. The manner of the election of the chairpersons of such committees. The Act lays down that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayat and municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the rural and urban populations in the district. The chairperson of such committee shall forward the development plan to the state government. In preparing the draft development plan, a district planning committee shall a. Have regard to I. Matters of common interest between the panchayats and the municipalities including spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 2. The extent and type of available resources whether financial or otherwise, and b. Consult such institutions and organizations as the governor may specify. Metropolitan Planning Committee. Every metropolitan area shall have a Metropolitan Planning Committee to prepare a draft development plan. 5. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The representation in such committees of the central government, state government and other organizations. 4. The functions of such committees in relation to planning and coordination for the metropolitan area. And 5. The manner of election of chairpersons of such committees. The Act lays down that 2/3 of the members of a Metropolitan Planning Committee should be elected by the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. The chairpersons of such committees shall forward the development plan to the state government. In preparing the draft development plan, a Metropolitan Planning Committee shall a. Have regard to I. The plans prepared by the municipalities and the panchayats in the metropolitan area. 2. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 3. The overall objectives and priorities set by the Government of India and the Government of the state. 4. The extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and of the Government of the state and other available resources whether financial or otherwise, and b. Consult such institutions and organizations as the governor may specify. Continuance of existing laws and municipalities. All the state laws relating to municipalities shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new system of municipalities based on this Act within the maximum period of 1 year from 1 June 1993, which is the date of commencement of this Act. However, all municipalities existing immediately before the commencement of this Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. But to interference by courts in electoral matters, the Act bars the interference by courts in the electoral matters of municipalities. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any municipality is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 12th schedule. It contains the following 18 functional items placed within the purview of municipalities: 1. Urban planning including town planning. 2. Regulation of land use and construction of buildings. 3. Planning for economic and social development. 4. Roads and bridges. 5. Water supply for domestic, industrial and commercial purposes. 6. Public health, sanitation, conservancy and solid waste management. 7. Fire services. 8. Urban forestry, protection of the environment and promotion of ecological aspects. 9. Safeguarding the interests of weaker sections of society, including the handicapped and mentally retarded. 10. Slum improvement and upgradation. 11. Urban poverty alleviation. 12. Provision of urban amenities and facilities such as parks, gardens, playgrounds. 13. Promotion of cultural, educational and aesthetic aspects. 14. Burials and burial grounds, cremations and cremation grounds and electric crematoriums. 15. Cattle ponds, prevention of cruelty to animals. 16. Vital statistics including registration of births and deaths. 17. Public amenities including street lighting, parking lots, bus stops and public conveniences. And 18. Regulation of slaughterhouses and tanneries. Types of urban governments. The following 8 types of urban local bodies are created in India for the administration of urban areas. Municipal corporation, municipality notified area committee, town area committee, cantonment board, township, port trust, special purpose agency. 1. Municipal corporation. Municipal corporations are created for the administration of big cities like Delhi, Mumbai, Kolkata, Hyderabad, Bangalore and others. They are established in the states by the acts of the concerned state legislatures, and in the union territories by the acts of the Parliament of India. There may be one common act for all the municipal corporations in a state or a separate act for each municipal corporation. A municipal corporation has 3 authorities, namely, the council, the standing committees and the commissioner. The council is the deliberative and legislative wing of the corporation. It consists of the councillors directly elected by the people, as well as a few nominated persons having knowledge or experience of municipal administration. In brief, the composition of the council including the reservation of seats for SCs, STs and women is governed by the 74th Constitutional Amendment Act. The council is headed by a mayor. He is assisted by a deputy mayor. He is elected in a majority of the states for a 1-year renewable term. He is basically an ornamental figure and a formal head of the corporation. His main function is to preside over the meetings of the council. The standing committees are created to facilitate the working of the council, which is too large in size. They deal with public works, education, health, taxation, finance and so on. They take decisions in their fields. The municipal commissioner is responsible for the implementation of the decisions taken by the council and its standing committees. Thus, he is the chief executive authority of the corporation. He is appointed by the state government and is generally a member of the IS. To municipality, the municipalities are established for the administration of towns and smaller cities. Like the corporations, they are also set up in the states by the acts of the concerned state legislatures and in the union territory by the acts of the Parliament of India. They are also known by various other names like municipal council, municipal committee, municipal board, borough municipality, city municipality and others. Like a municipal corporation, a municipality also has three authorities, namely, the council, the standing committees and the chief executive officer. The council is the deliberative and legislative wing of the municipality. It consists of the councillors directly elected by the people. The council is headed by a president chairman. He is assisted by a vice president vice chairman. He presides over the meetings of the council. Unlike the mayor of a municipal corporation, he plays a significant role and is the pivot of the municipal administration. Apart from presiding over the meetings of the council, he enjoys executive powers. The standing committees are created to facilitate the working of the council. They deal with public works, taxation, health, finance and so on. The chief executive officer, chief municipal officer, is responsible for day-to-day general administration of the municipality. He is appointed by the state government. 3. Notified area committee. A notified area committee is created for the administration of two types of areas: a fast developing town due to industrialization, and a town which does not yet fulfill all the conditions necessary for the constitution of a municipality, but which otherwise is considered important by the state government. Since it is established by a notification in the Government Gazette, it is called as Notified Area Committee. Though it functions within the framework of the State Municipal Act, only those provisions of the Act apply to it which are notified in the Government Gazette by which it is created. It may also be entrusted to exercise powers under any other act. Its powers are almost equivalent to those of a municipality. But unlike the municipality, it is an entirely nominated body, that is, all the members of a notified area committee including the chairman are nominated by the state government. Thus, it is neither an elected body nor a statutory body. 4. Town Area Committee. A town area committee is set up for the administration of a small town. It is a semi-municipal authority and is entrusted with a limited number of civic functions like drainage, roads, street lighting, and conservancy. It is created by a separate act of the state legislature. Its composition, functions and other matters are governed by the act. It may be wholly elected or wholly nominated by the state government or partly elected and partly nominated. 6. 5. Cantonment Board. A cantonment board is established for municipal administration for civilian population in the cantonment area. 7. It is set up under the provisions of the Cantonments Act of 2006, a legislation enacted by the central government. It works under the administrative control of the Defense Ministry of the central government. Thus, unlike the above 4 types of urban local bodies, which are created and administered by the state government, a cantonment board is created as well as administered by the central government. The Cantonments Act of 2006 was enacted to consolidate and amend the law relating to the administration of cantonments with a view to impart greater democratization, improvement of their financial base to make provisions for developmental activities and for matters connected with them. This act has repealed the Cantonments Act of 1924. At present, 2016, there are 62 cantonment boards in the country. They are grouped into 4 categories on the basis of the civil population. This is shown below in Table 39.2. Table 39.2 Classification of Cantonment Boards. Category Civil Population. I above 50,000 to 10,000 to 50,000, 3 2,500 to 10,000, 4 below 2,500. A cantonment board consists of partly elected and partly nominated members. The elected members hold office for a term of 5 years, while the nominated members, i.e., ex officio members, continue so long as they hold the office in that station. The military officer commanding the station is the ex officio president of the board and presides over its meetings. The vice president of the board is elected by the elected members from amongst themselves for a term of 5 years. The category I cantonment board consists of the following members: I, a military officer commanding the station; 2, an executive engineer in the cantonment; 3, a health officer in the cantonment; 4, a first-class magistrate nominated by the district magistrate; 3 military officers nominated by the officer commanding the station; 6, 8 members elected by the people of the cantonment area; 7, Chief Executive Officer of the Cantonment Board. The functions performed by a cantonment board are similar to those of a municipality. These are statutorily categorized into obligatory functions and discretionary functions. The sources of income includes both tax revenue and non-tax revenue. The Executive Officer of the Cantonment Board is appointed by the President of India. He implements all the resolutions and decisions of the board and its committees. He belongs to the central cadre established for the purpose. 6. Township. This type of urban government is established by the large public enterprises to provide civic amenities to its staff and workers who live in the housing colonies built near the plant. The enterprise appoints a town administrator to look after the administration of the township. He is assisted by some engineers and other technical and non-technical staff. Thus, the township form of urban government has no elected members. In fact, it is an extension of the bureaucratic structure of the enterprises. 7. Port Trust. The port trusts are established in the port areas like Mumbai, Kolkata, Chennai and so on for two purposes: A, to manage and protect the ports, and B, to provide civic amenities. A port trust is created by an Act of Parliament. It consists of both elected and nominated members. Its chairman is an official. Its civic functions are more or less similar to those of a municipality. 8. Special purpose agency. In addition to these 7 area-based urban bodies, or multipurpose agencies, the states have set up certain agencies to undertake designated activities or specific functions that, legitimately, belong to the domain of municipal corporations or municipalities or other local urban governments. In other words, these are function-based and not area-based. They are known as single-purpose, unipurpose, or special-purpose agencies or functional local bodies. Some such bodies are: 1. Town improvement trusts; 2. Urban development authorities; 3. Water supply and sewerage boards; 4. Housing boards; 5. Pollution control boards; 6. Electricity supply boards; 7. City transport boards. These functional local bodies are established as statutory bodies by an act of state legislature or as departments by an executive resolution. They function as autonomous bodies and deal with the functions allotted to them independently of the local urban governments, that is, municipal corporations or municipalities and so forth. Thus, they are not subordinate agencies of the local municipal bodies. Municipal personnel. There are 3 types of municipal personnel systems in India. The personnel working in the urban governments may belong to any one or all the 3 types. These are: 1. Separate personnel system. Under this system, each local body appoints, administers, and controls its own personnel. They are not transferable to other local bodies. It is the most widely prevalent system. This system upholds the principle of local autonomy and promotes undivided loyalty. 2. Unified personnel system. In this system, the state government appoints, administers, and controls the municipal personnel. In other words, statewide services, cadre, are created for all the urban bodies in the state. They are transferable between the local bodies in the state. This system is prevalent in Andhra Pradesh, Tamil Nadu, Uttar Pradesh, Rajasthan, Madhya Pradesh and so on. 3. Integrated personnel system. Under this system, the personnel of the state government and those of the local bodies form part of the same service. In other words, the municipal personnel are the members of the state services. They are transferable not only between the local bodies in the state but also between local bodies and departments of state government. Thus, there is no distinction between local civil service and state civil service. This system is prevalent in Odisha, Bihar, Karnataka, Punjab, Haryana and others. The various national level institutions providing training to the municipal personnel are 1. All India Institute of Local Self-Government, Mumbai, constituted in 1927, it is a private registered society. 2. Centre for Urban and Environmental Studies, New Delhi, set up in 1967 on the recommendation of Nuruddin Ahmed Committee on Training of Municipal Employees, 1963 to 1965. 3. Regional Centres for Urban and Environmental Studies, Kolkata, Lucknow, Hyderabad and Mumbai, set up in 1968 on the recommendation of Nuruddin Ahmed Committee on Training of Municipal Employees, 1963 to 1965. 4. National Institute of Urban Affairs, established in 1976. 5. Human Settlement Management Institute, established in 1985. Municipal revenue. There are 5 sources of income of the urban local bodies. These are as follows. 1. Tax revenue. The revenue from the local taxes include property tax, entertainment tax, taxes on advertisements, professional tax, water tax, tax on animals, lighting tax, pilgrim tax, market tax, toll on new bridges, octroi and so on. In addition, the municipal bodies imposes various cesses like library cess, education cess, beggary cess and so on. Octroi, i.e., taxes on the entry of goods into a local area for consumption, use or sale therein, has been abolished in most of the states. Property tax is the most important tax revenue. 2. Non-tax revenue. This source include rent on municipal properties, fees and fines, royalty, profits and dividends, interest, user charges and miscellaneous receipts. The user charges, i.e., payment for public utilities, include water charges, sanitation charges, sewerage charges and so on. 3. Grants. These include the various grants given to municipal bodies by the central and state governments for several development programs, infrastructure schemes, urban reform initiatives and so on. 4. Devolution. This consists of the transfer of funds to the urban local bodies from the state government. This devolution is made on the basis of the recommendations of the State Finance Commission. 5. Loans. The urban local bodies raise loans from the state government as well as financial institutions to meet their capital expenditure. They can borrow from the financial institutions or other bodies only with the approval of the state government. Central Council of Local Government. The Central Council of Local Government was set up in 1954. It was constituted under Article 263 of the Constitution of India by an order of the President of India. Originally, it was known as the Central Council of Local Self-Government. However, the term, self-government, was found to be superfluous and hence was replaced by the term, government, in the 1980s. Till 1958, it dealt with both urban as well as rural local governments, but after 1958 it has been dealing with matters of urban local government only. The Council is an advisory body. It consists of the Minister for Urban Development in the Government of India and the Ministers for Local Self-Government in states. The Union Minister acts as the chairman of the Council. The Council performs the following functions with regard to local government: I. Considering and recommending the policy matters. 2. Making proposals for legislation. 3. Examining the possibility of cooperation between the centre and the states. 4. Drawing up a common program of action. Recommending central financial assistance. 6. Reviewing the work done by the local bodies with the Central Financial Assistance Table 39.3 articles related to municipalities at a glance. Article No. Subject Matter 243p Definitions 243q Constitution of Municipalities 243r Composition of Municipalities 243s Constitution and Composition of Wards Committees, and so on. 243t Reservation of seats 243u Duration of municipalities, and so on. 243 disqualifications for membership. 243 watts powers, authority and responsibilities of municipalities, and so on. 243 X powers to impose taxes by and funds of the municipalities. 243 Y Finance Commission. 243 Z Audit of accounts of municipalities. 243 Z Elections to the municipalities. 243 ZB Application to union territories. 243 ZC Part not to apply to certain areas. 243 ZE Committee for District Planning. 243 ZE Committee for Metropolitan Planning. 243 Z Floor Continuance of existing laws and municipalities. 243 ZG but to interference by courts in electoral matters. Table 39.4 Name and number of municipalities, 2010, 8 SL. No. State Urban Local Bodies Number 1. Municipal Corporations 15-1. Andhra Pradesh 2. Municipalities 103-3. Nagar Panchayats 6-2. Arunachal Pradesh, ULBs do not exist, 1. Municipal Corporations 1-3. Assam 2. Municipalities 29-3. Town Panchayats 59-1. Municipal Corporations 11-4. Bihar 2. Municipal Councils 43-3. Nagar Panchayats 84-1. Municipal Corporations 10-5. Chhattisgarh 2. Municipalities 3. Town Panchayats 28-124. 6 Goa 1. Municipal Corporations 2. Municipal Councils 113-7. Gujarat 1. Municipal Corporations 2. Municipalities 3. Notified Area Councils 7-159-8. Haryana 1. Municipal Corporations 2. Municipal Councils 3. Municipal Committees 124-51-9. Himachal Pradesh 1. Municipal Corporations 2. Municipal Councils 3. Nagar Panchayats 120-28-10. Jammu and Kashmir 1. Municipal Corporations 2. Municipal Committees 280-11. Jharkhand 1. Municipal Corporations 2. Municipalities MC 3. Town Panchayats NAC 215-22-12. Karnataka 1. Municipal City Corporations 2. Municipal City Councils 3. Town Panchayats 8-138-73-13. Kerala 1. Municipal Corporations 2. Municipalities 553-14. Madhya Pradesh 1. Municipal Corporations 2. Municipalities 3. Nagar Panchayats 1488-236-15. Maharashtra 1. Municipal Corporations 2. Municipal Councils 3. Nagar Panchayats 22-222-516. Manipur 1. Municipal Councils 2. Nagar Panchayats 10-18-17. Meghalaya 1. Municipalities 6. 18 Mizoram 1. Municipalities 119. Nagaland 1. Municipal Councils 2. Town Councils 316-20. Odisha 1. Municipal Corporations 2. Municipalities 3. Notified Area Councils 336-64-21. Punjab 1. Municipal Corporations 2. Municipalities 3. Nagar Panchayats 597-33-22. Rajasthan 1. Municipal Corporations 2. Municipal Councils 3. Municipal Boards 311-169-23. Sikkim 1. Municipal Corporations 2. Municipal Councils 3. Nagar Panchayats 129-24. Tamil Nadu 1. Municipal Corporations 2. Municipalities 3. Town Panchayats 8-155-161-25. Tripura 1. Municipal Councils 2. Nagar Panchayats 112-26. Uttar Pradesh 1. Nagar Nigam 2. Nagar Palika Parishads 3. Nagar Panchayats 12-194-422-27. Uttarakhand 1. Nagar Nigam 2. Nagar Palika Parishads 3. Nagar Panchayats 130 130 128. West Bengal 1. Municipal Corporations 2. Municipalities 3. Notified Area Authorities 6 118 31. Municipal Corporations 139.
All India 2.
Municipalities 1595 3. Nagar Panchayats 2108. Note and references 1. Local government is a subject mentioned in the state list under the 7th schedule of the Constitution. 2. The bill was passed in both the Lok Sabha and the Rajya Sabha in December 1992. After that, the bill was approved by the required number of state legislatures. It was assented by the President in April 1993. 3. A transitional area, a smaller urban area or a larger urban area means such area as the governor may specify by public notification for this purpose with regard to the following factors: a. Population of the area, b. Density of population, c. Revenue generated for local administration, d. Percentage of employment in non-agricultural activities, and e. Economic importance or such other factors as the governor may deem fit. 4. At present, 2016, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Orissa and Rajasthan. Presently, 2016, there are a total of 10 tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. 5. Metropolitan area means an area having a population of 10 lakh or more, in 1 or more districts and consisting of 2 or more municipalities or panchayats or other contiguous areas. 6. The Rural-Urban Relationship Committee, 196366, headed by A.P. Jain, recommended that small town area committees should be merged with the Panchayati Raj institutions to avoid multiplicity in the pattern of local bodies. 7. A cantonment area is a delimited area where the military forces and troops are permanently stationed. 8. Report of the 13th Finance Commission, 2010 to 2015, Volume 2, December 2009, p. 424 to 426. Part 6. Union Territories and Special Areas 40. Union Territories 41. Scheduled and Tribal Areas. Union Territories under Article 1 of the Constitution. The territory of India comprises 3 categories of territories: a. Territories of the states, b. Union Territories, U and c. Territories that may be acquired by the Government of India at any time. At present, there are 29 states, 7 union territories and no acquired territories. The states are the members of the federal system in India and share a distribution of power with the centre. The union territories, on the other hand, are those areas which are under the direct control and administration of the central government. Hence, they are also known as centrally administered territories. In this way, existence of these territories constitutes a conspicuous departure from federalism in India. The Government of India is plainly unitary insofar as the relationship between New Delhi and these central enclaves is concerned. 1. Creation of union territories. During the British rule, certain areas were constituted as scheduled districts in 1874. Later, they came to be known as Chief Commissioners' Provinces. After independence, they were placed in the category of Part C and Part D states too. In 1956, they were constituted as the Union Territories by the 7th Constitutional Amendment Act, 1956, and the States Reorganization Act, 1956. Gradually, some of these Union Territories have been elevated to statehood. Thus, Himachal Pradesh, Manipur, Tripura, Mizoram, Arunachal Pradesh and Goa, which are states today, were formerly union territories. On the other hand, the territories that were acquired from the Portuguese, Goa, Daman and Diu, and Dadra and Nagar Haveli, and the French, Puducherry, were constituted as the Union territories. At present, there are 7 Union territories. They are, along with the year of creation, 1. Andaman and Nicobar Islands, 1956, 2. Delhi, 1956, 3. Lakshadweep, 1956, 4. Dadra and Nagar Haveli, 1961, 5. Daman and Diu, 1962, 6. Puducherry, 1962, and 7. Chandigarh, 1966. Till 1973, Lakshadweep was known by the name of Lakshadweep, Minikoy and Amindevi Islands. In 1992, Delhi was redesignated as the National Capital Territory of Delhi. Till 2006, Puducherry was known as Pondicherry. The Union territories have been created for a variety of reasons. These are mentioned below 3. 1. Political and administrative consideration, Delhi and Chandigarh. 2. Cultural distinctiveness, Puducherry, Dadra and Nagar Haveli, and Daman and Diu. 3. Strategic importance, Andaman and Nicobar Islands and Lakshadweep. 4. Special treatment and care of the backward and tribal people, Mizoram, Manipur, Tripura and Arunachal Pradesh, which later became states. Administration of Union Territories. Articles 239 to 241 in Part 8 of the Constitution deal with the Union Territories. Even though all the Union Territories belong to one category, there is no uniformity in their administrative system. Every Union Territory is administered by the President acting through an administrator appointed by him. An administrator of a Union Territory is an agent of the President and not head of state like a governor. The President can specify the designation of an administrator. It may be Lieutenant Governor or Chief Commissioner or Administrator. At present, it is Lieutenant Governor in the case of Delhi, Puducherry and Andaman and Nicobar Islands, and Administrator in the case of Chandigarh, Dadra and Nagar Haveli, Daman and Diu and Lakshadweep. The President can also appoint the Governor of a state as the administrator of an adjoining Union Territory. In that capacity, the Governor is to act independently of his Council of Ministers. The Union Territories of Puducherry, in 1963, and Delhi, in 1992, are provided with a Legislative Assembly for and a Council of Ministers headed by a Chief Minister. The remaining 5 Union Territories do not have such popular political institutions. But the establishment of such institutions in the Union Territories does not diminish the supreme control of the President and Parliament over them. The Parliament can make laws on any subject of the 3 lists, including the state list, for the Union Territories. This power of Parliament also extends to Puducherry and Delhi, which have their own local legislatures. This means that the legislative power of Parliament for the Union Territories on subjects of the state list remain unaffected even after establishing a local legislature for them. But the Legislative Assembly of Puducherry can also make laws on any subject of the state list and the concurrent list. Similarly, the Legislative Assembly of Delhi can make laws on any subject of the state list, except public order, police and land, and the concurrent list. The President can make regulations for the peace, progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu. In the case of Puducherry also, the President can legislate by making regulations, but only when the Assembly is suspended or dissolved. A regulation made by the President has the same force and effect as an Act of Parliament and can also repeal or amend any Act of Parliament in relation to these Union Territories. The Parliament can establish a High Court for a Union Territory or put it under the jurisdiction of the High Court of adjacent state. Delhi is the only Union Territory that has a High Court of its own, since 1966. The Bombay High Court has got jurisdiction over 2 Union Territories, Dadra and Nagar Haveli, and Daman and Diu. Andaman and Nicobar Islands, Chandigarh, Lakshadweep and Puducherry are placed under the Calcutta, Punjab and Haryana, Kerala, and Madras High Courts respectively. The Constitution does not contain any separate provisions for the administration of acquired territories. But the constitutional provisions for the administration of Union territories also apply to the acquired territories. Special provisions for Delhi. The 69th Constitutional Amendment Act of 19,915 provided a special status to the Union Territory of Delhi, and redesignated it the National Capital Territory of Delhi, and designated the Administrator of Delhi as the Lieutenant Governor. It created a Legislative Assembly and a Council of Ministers for Delhi. Previously, Delhi had a Metropolitan Council and an Executive Council. The strength of the Assembly is fixed at 70 members, directly elected by the people. The elections are conducted by the Election Commission of India. The Assembly can make laws on all the matters of the state list and the concurrent list except the three matters of the state list, that is, public order, police and land. But the laws of Parliament prevail over those made by the Assembly. The strength of the Council of Ministers is fixed at 10% of the total strength of the Assembly, that is, 7, 1 Chief Minister and 6 other ministers. The Chief Minister is appointed by the President, not by the Lieutenant Governor. The other ministers are appointed by the President on the advice of the Chief Minister. The ministers hold office during the pleasure of the President. The Council of Ministers is collectively responsible to the Assembly. The Council of Ministers, headed by the Chief Minister, aid and advise the Lieutenant Governor in the exercise of his functions except insofar as he is required to act in his discretion. In the case of difference of opinion between the Lieutenant Governor and his ministers, the Lieutenant Governor is to refer the matter to the President for decision and act accordingly. When a situation arises in which the administration of the territory cannot be carried on in accordance with the above provisions, the President can suspend their above provisions operation and make the necessary incidental or consequential provisions for administering the territory. In brief, in case of failure of constitutional machinery, the President can impose his rule in the territory. This can be done on the report of the Lieutenant Governor or otherwise. This provision resembles Article 356, which deals with the imposition of President's rule in the states. The Lieutenant Governor is empowered to promulgate ordinances during recess of the Assembly. An ordinance has the same force as an act of the Assembly. Every such ordinance must be approved by the Assembly within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. But he cannot promulgate an ordinance when the Assembly is dissolved or suspended. Further, no such ordinance can be promulgated or withdrawn without the prior permission of the President. Table 40.1 Administrative System of Union Territories at a glance. Union Territories Executive Legislature Judiciary 1. Andaman and Nicobar Islands Lieutenant Governor, under Calcutta High Court 2. Chandigarh Administrator, under Punjab and Haryana High Court 3. Dadra and Nagar Haveli Administrator, under Bombay High Court 4. Daman and Diu Administrator, under Bombay High Court 5. Delhi, A. Lieutenant Governor, B. Chief Minister, C. Council of Ministers Legislative Assembly Separate High Court 6. Lakshadweep Administrator, under Kerala High Court 7. Puducherry, A. Lieutenant Governor, B. Chief Minister, C. Council of Ministers Legislative Assembly under Madras High Court. Note: the Governor of Punjab is concurrently the Administrator of Chandigarh. The Administrator of Dadra and Nagar Haveli is concurrently the Administrator of Daman and Diu. Lakshadweep has a separate Administrator. 6. Advisory Committees of Union Territories under the Government of India. Allocation of Business, Rules 1961. Ministry of Home Affairs is the nodal ministry for all matters of Union Territories relating to legislation, finance and budget, services and appointment of lieutenant governors and administrators. All the 5 UTs without legislature, Andaman and Nicobar Islands, Chandigarh, Daman and Diu, Dadra and Nagar Haveli and Lakshadweep, have the Forum of Home Ministers Advisory Committee, MUC Administrators Advisory Committee, AAC. While MUC is chaired by the Union Home Minister, AC is chaired by the administrator of the concerned UTs. Member of Parliament and elected members from the local bodies, e.g. district panchayats and municipal council of the respective UTs, are members of these committees among others. The committee discusses the general issues relating to social and economic development of the UTs. Table 40.2 Comparing States and Union Territories. States, Union Territories. 1. Their relationship with Centre is federal. 1. Their relationship with Centre is unitary. 2. They share a distribution of power with the Centre. 2. They are under the direct control and administration of the Centre. 3. They have autonomy. 3. They do not have any autonomy. 4. There is uniformity in their administrative setup. 4. There is no uniformity in their administrative setup. Their executive head is 5. Their executive head is known as 5. Known by various governor designations, administrator or lieutenant governor or chief commissioner. 6. The governor is a constitutional head of the state. 6. An administrator is an agent of the president. Parliament cannot make laws on. Parliament can make laws on. 7. The subjects of the state list in 7. Any subject of the 3 lists in relation to the states except under relation to the union territories. Extraordinary circumstances. Table 40.3 Articles related to union territories at a glance. Article No. Subject matter 239. Administration of union territories. 239A. Creation of local legislatures or council of ministers or both for certain union territories. 239A. Special provisions with respect to Delhi. 239AB. Provision in case of failure of constitutional machinery. 239B. Power of administrator to promulgate ordinances during recess of legislature. 240. Power of president to make regulations for certain union territories. 241. High courts for union territories. 242. Code. Repealed. Notes and references. 1. S.R. Maheshwari, State Governments in India, Macmillan, 2000 edition. P. 131. 2. Under the original Constitution of India, 1950, the states were classified into 4 categories, namely, Part A, B, C and D states. 3. J. C. Johari, Indian Government and Politics, which